Good morning, ladies and gentlemen. This is the Board of Standards and Appeals public hearing for September 10, 2019.
Okay, I just wanted to start this off by announcing for me the sad moving on to higher or other or new world adventures, our General Counsel, L'Oreal Monroe, who served as really a very, very excellent General Counsel, a brilliant lawyer. And to announce with great pleasure the ascendancy to the roles of General Counsel Kurt Steinhaus and Deputy General Counsel Chase Vine. And I want to say that I don't necessarily know how it works in other city agencies, but the Board of Standards and Appeals has been blessed with having some of the most excellent, intelligent, skilled lawyers that really the city has to offer. And it makes doing what is a very difficult job a lot easier because we have very high intellectual standards and high skills, heavy skills, strong skills. And so I welcome them and congratulate them.
So decision item, appeals calendar, item number 1, 2019-45A, 1002 Farragut Road, Brooklyn.
Good morning, Chair Perlmutter, members of the board. First of all, Council, let me be the first one from the public to congratulate you on your new positions. We look forward to working with you. Okay. I'm going to be very brief.
No, you have to be brief. It's a closed decision.
It's closed for decision.
You get to say your name and congratulations, and then okay.
It was just based on the review session.
Yeah, right, but this is closed, so unless we reopen, no, you can stay there, but based on the review session. Okay. Does DOB want to come up and just introduce themselves, or?
Timothy McKernan for the Department of Buildings.
Okay, thank you. So, as discussed, we have been asked, the way we're interpreting the question before us is whether the proposed medical waste transfer facility is a use group 18. And from my perspective, based on the information that was presented, it is not a use group 18 because it's not processing materials the way the use group 18 medical transfer facility would be handling. It receives, in this particular case, 330 tons per month maximum of medical waste that arrives in a sealed container. And all it does is take it off a truck, put it into the space, and put it on another truck, weigh it, and so on, but never opens it. So based on those facts, I don't see it as a use group 18, but a use group 16. And that somewhere, and reason for use group 16 is because it's falling somewhere similar to the uses that we see in use group 16, i.e. a crematorium for humans or animals, animal hospital, and then we also have the motor freight station, which is a place where it's picking up and delivering whatever it is that's freight. So it falls somewhere in there, but we're going to leave it to DOB to refine that as they go. And we're not going to create like a new use group 16 item because that's not our purview. If anything, that's DOB to create in a TPPN, or city planning, of course, to create an actual use. So with that, I'd like to make a motion to grant the appeal.
Chair Perlmutter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Shetta?
Aye.
Commissioner Shabeta?
Aye.
The application has been granted. Continued hearing items, item number 2, 2017-310A, 1002 Farragut Road, Brooklyn.
Timothy McKernan for the Department of Buildings. I think DOB and applicant are in agreement that the previous CO was issued in error. In light of your vote just now, it appears that applicant will submit a new job. DOB will approve that job consistent with your vote. And then the current CO will be replaced with one that lists regulated medical waste transfer as a principal use group 16 use. But we'd like to adjourn the CO modification action until that CO, the new CO is actually issued.
Okay, great. So then we could put that on for, how much time do you think you need for doing this?
3 months, I think, to be
3
safe.
months? Yeah, that's fine. So December 10th, which is a submission on, you know, submission on, so
What is it,
December
December
10th
10th?
hearing, it's a submission on November 20th.
I have a question.
Yeah.
So if you succeed in modifying the CFO, will you be withdrawing this action? prior
Yeah,
to-
I don't want to promise that we'll do that here, but that would be the most likely course of events.
And in the event that it's not,
And what?
has not been, in the event that it's not been resolved by the December 10th, you could submit a letter just requesting,
Right, but...
whatever additional-
But we're assuming significant progress will be made by the property owner to amend the C of O, right?
Right, I don't anticipate there will be any issues, and that I think we both hope that this will be taken care of by this date, but we can't make any promises.
Right, I mean, it's not as if we then vote on it, it might mean that they need more time because of something that's holding up the CO issuance, all right? Okay, thank you very much. Are there any speakers on this?
Do you-
Kenneth Fisher for the applicant. Thank you.
Thank you, okay.
Why is this? Oh, look at that. Sorry about that. Okay. Item number 3, 2019-89A, 36 West 66th Street. It's the application from City Club. And item number 4, correct?
Yes,
This is the application, 2019-94A, 36 West 66th Street also. This is the application filed by Landmark West. So,
yes, does the appellant just want to get up and,
Madam Chair.
oh, yeah, I'm
I'd
sorry,
like to
I'm
recuse.
sorry. Yes, thank you. But this is still open, right? Yes.
Good morning. I have a handout, which I should also...
Can you speak up, please, because...
Yes, I have a
please identify yourself for the record. I'm sorry.
John Lobert for Appellants City Club of New York et al. I have something I'd like to give to the members of the board.
You can just hand it over here, it's more effective. Thank you.
Forgot she's- Yes.
Thank you.
So, well, I heard from the executive session yesterday that pretty much the board is not inclined to grant the appeal, so I'll be brief. I just want to add these things to the record. I want to say, too, that I hope this decision can be rendered quickly, because I think the key thing in this case, as in all cases in which construction is ongoing, is that a court should, or courts should be able to reach the merits before the building is substantially complete, because otherwise I don't think there's really any chance that the decision of the board could be reversed, even if the court were otherwise inclined to do so. I'd just like to spend a moment...
So then, to that point, so we didn't close the record last time, to enable a submission to continue the argument, right? We sometimes close and vote decisions, but only when there's no new material that you want us to consider. So if you're interested in closing this hearing and having us come to a decision, I recommend that you not introduce new arguments unless you think they're strong ones that we should consider. Otherwise, it'll put off our ability to decide on this today.
Well, I don't think that this, I'd just like it to be in the record, but I don't think it will change your mind. I mean, I think this whole post-hearing round of briefing added, as I believe, I don't know, I believe somebody said yesterday, it didn't add that much, and I would have been more than happy to call the case after the first hearing, these are just, they're not new arguments, they're just in response to things that Mr. Karnofsky said, some of which, since I got the date wrong on the simultaneous briefing, I think he responded to what I had said in my post-hearing submission. So about the law and how statutory interpretation should work in a case like this, I think it's pretty clear we disagree with Mr. Karnofsky, with Extel. It's true that there's a difference between legislative intent or purpose and legislative history, but we're not just relying on legislative history here. We're looking at the whole picture, at what this statute is intended to do as evidenced by its entire language, not just one or two phrases. And I think it's obvious that the statute was intended to limit height. We can discuss exactly how precisely the City Planning Commission meant to limit height and whether it did so or not, but I don't think there can really be any dispute that by enacting these provisions, the City Planning Commission intended to limit height. And Extel hasn't proposed any purpose in a rule that would permit buildings to be much taller just because they straddle two zoning districts, one of which provides for a lower density, not a higher density. And I think this is obvious from the language, not just from legislative history, but both from the formula of the bulk packing rule, that 60% of the bulk has to be below 150 feet, and the tower coverage rule of 30% minimum tower coverage. It's also obvious, as I said in my last submission, from the fact that what's contemplated is a 60-40 ratio, that the 60 and the 40 should add up to 100, not to 130 or whatever it is in this case. Mr. Shabeta, Commissioner Shabeta had raised the question about whether the rule of absurd results applies in cases involving zoning and property. And we cited Stringfellows to address that particularly. And I think, that case does say that while zoning ordinances must be narrowly interpreted and ambiguities are to be construed against the zoning authority, the fundamental rule in construing any statute, or in this case, an amendment to zoning resolution, is to ascertain and give effect to the intention of the legislative body. And I don't think that the intention of the legislative body was to allow a much higher building just because part of it was in a lower density zoning district, part of the zoning lot. also would disagree with Mr. Karnofsky's interpretation of some of the cases, but perhaps it's a moot point at this point. But I think it's very clear that although the cases on occasion do say that you have to find ambiguity, they find that ambiguity not only in the provision, in the words being construed, but they look at the statute as a whole and what it's trying to accomplish, and at its legislative history as well. For example, in Abood versus Hospital Ambulance Service, the Court of Appeals said that intent is to be gleaned from the entire statute, its legislative history, or the statutes of which it is made a part, and that intent must be followed in construing the statute. There's a lot of, Bankers Association versus Albright has a very good explanation of how the court, or this body for that matter, should approach cases of this kind. But
what
again,
you're suggesting is that for every single statute written, every one, the reader, the user of the statute, shouldn't look at the plain meaning, what it says to do right in front of you, but instead should try to glean from legislative history and other case law and so on what it really meant, as opposed to what it really meant, as opposed to what it says. So,
No.
well, but that's effectively what you're saying, because what we've been saying here is when the bulk packing rule says it applies to the entire special purpose district, that's a direction. And that a user of that text should have to look around what is actually meant. And, the zoning resolution, like every piece of legislature, has an instruction for buildings located in a certain place,
Right.
for schools operating in a certain way. What you're suggesting is that in every single case, you should always look behind the plain language. It's as opposed to when you don't know what to do because the language isn't clear.
no, it's not in every single case. It's only when the result is absurd or unreasonable or obviously contrary to the purpose. And then, of course, we get to the next question, which is this such a case?
Right.
But,
Then I go back to the same question. You would say, looking at a very simple statute that says for buildings located in an R10 district, and then you look at, should I be unpacking that and seeing whether there's an absurd result here before I move on? You can't expect an architect to do that. For one, what are the absurd results? How do you analyze them, et cetera? And for two, really, is that what you're supposed to be doing?
But this isn't up to necessarily the architect. The architect, of course, will do his best and will try to see what it all means, and maybe will even push the envelope and say, well, I think it means this. But it's up to the Department of Buildings and to this board to have that view of the zoning resolution that would enable the Buildings Department or this board to say, well, actually, it's very clear that this statute was intended to do X, and
How does that argument hold up against Raritan?
Well, I think if you read the dissent in Raritan, they put the case very well.
I personally agree with the dissent in Raritan, but Raritan is what's dictating, it's the law that we have to follow. It's our precedent at this moment.
But
Sorry, speak up. I know your
I'm sorry,
voice is
it's
hoarse. Speak up right into the mic.
At this moment, Raritan is the controlling precedent.
But, in each one of these cases, you'll find it's all a question of, one judge might think this is an absurd result or an unreasonable result. Another judge might not. I mean, that's the nature of the law. In Raritan, the majority thought it was not unreasonable. The dissent thought it was unreasonable.
Well, they kind of, it was more that the language was so clear. Not so much that is this result that absurd or unreasonable. The language is so clear, similar to this case. The language is very clear. Now, while the legislative intent is important, but not when it usurps a property owner's right and in such a clear text. If there was an ambiguity in the text, and that ambiguity was substantial, then we can start going into the intent. But pursuant to Raritan, that is our precedent.
Well, I would say that the ambiguity consists in the obvious contrast between the outcome and the purpose of the statute.
You're jumping to the absurd result,
Right.
assuming ambiguity, but when you look at the text
Right.
has no ambiguity.
But in every one of these cases, or anyway, in every one, really, I think if you read the text, there's no ambiguity. Now, sometimes the courts come back, sometimes they say, even though the literal language says X, we won't apply it here. In other cases, they say, we see ambiguity not in the literal language of the text, but looking at the statute as a whole. So the courts do routinely in these kinds of cases, which admittedly are not routine, but they do arise not that infrequently, and where that happens, they do look beyond the literal language of the text. I mean, let's take water here, do we?
Sorry.
Oh, well. Let's take Stringfellows. If you look at Stringfellows, the lower court said it was clear and unambiguous that club did not fit within the definition of an adult establishment, because one of the requirements of the definition is that the club customarily not admit minors. Now, the appellate division, wanting to look at the statute as a whole, and clearly this club was an adult establishment, said, well, maybe, customarily here could mean what's customary for adult establishments generally. But basically, in doing that, I mean, when you have a definition, when the statute was written that way, it's just doesn't make the appellate division's interpretation of it doesn't make any sense, because essentially they're saying, well, this was just a statement about adult establishments in general. It didn't mean that you look to each club to see whether it meets the criteria. Well, if you're not going to look to see if the club meets the criteria, then why is this a part of the test, part of the definition? It has to be that it's applied to each club to see whether it does or does not customarily admit minors. So, they kind of got around it, but I think if you read that language, it's really hard to say that language means what the Court of Appeals, what the appellate division says it does. And in many other cases, the courts don't even, and by the way, post-Raritan, because I think Mr. Karnofsky suggested that these cases are all old cases. I mean,
Now, there's good law. There's good law in these cases. I just believe that it's been made abundantly clear to this board through Raritan that when an owner is following the language of the text, the result must be extremely absurd. It must be very clear. The text must show something that is clearly an error, or something that any reasonable person would read and say, that's not what this means, even though it's written like that. I think our hands are tied.
okay. Well,
And by the way, I don't really see the absurd result. It's a 4-story difference.
no, it's not for a stories difference, as we showed in our, now I'm losing track of all the submissions, but I believe it was in my reply, possibly, that I submitted before the last hearing, that it's actually 8 or 9 stories. But that's because when I first did this calculation, I was assuming that they could put all of the available 60% of the bulk on the zoning lot in the C47 portion. But I I wasn't looking at the reality of this zoning lot and the fact that the landmarked Armory building is on that zoning lot. And moreover, you're considering a permit that has already been approved that has a certain amount of bulk below 150 feet. If you take that bulk and then say, okay, so if they followed the rules as we believe they should be applied, how much could they build? It would be 8-point-something stories less than what they have. So,
I'm looking at a diagram right now that's showing if the distribution was in both zones, you get a 39-story tower, because that's what we're talking about, both the R and the C. And if there were no bulk packing rules, so in other words, it doesn't apply in the R district, which is what's being suggested, then it would be a 43-story tower, so.
is this the diagram that Mr. Karnofsky submitted?
Yeah, on 827.
Yeah, but as I said in response to that, that's a hypothetical case. It's not this case on this zoning lot.
But you know, when city planning is looking at no builds and builds, which was what your argument earlier was, that there were these soft sites that were considered in the rezoning, in the new zoning district, right? And they looked at those soft sites, but they didn't look at this soft site, or they didn't look at this soft site in the same way, right? So they couldn't have predicted whether you keep a building, you don't keep a building, how many buildings are on a zoning lot. When they look at a soft site, they tear down all the buildings on the lot. So if you're going to compare apples to apples, you have to have a vacant site and that straddles the two boundaries. Otherwise, there's infinite possibilities for every single soft site, right? So this one is that, for lack of a better word, sort of the dumb version. They clear the site. What can you build if you have the bulk packing rule that straddles, and what can you do if you don't have it, right? And so there was a 4-story difference. It's an absurd result would be a 10-story difference or a 20-story difference, maybe.
Well, in addition to the fact that 4 or whatever it is, 5 times 16 is not whatever, I forget how many feet that is, but it's not totally insignificant at all. But it's the logic of the interpretation that is absurd. In other words, to the extent that you buy this rule that they have, that they would have you accept, to the extent that the bulk is put outside of where the tower coverage rule applies and where there would ordinarily be towers, it leads to a perverse result. Of course, it's not as perverse as it could be because they didn't have enough room in the R portion of the lot to move all that bulk out and to put the building on stilts, as they could have done if they had a bigger R8 section. But anyhow, it's the logic of it, really, not just the amount by which.
So if I were to take take your presentation here, where you're saying it's the logic of it. So as you have stated, and the City Planning Commission report started off with the intent to find a bulk form that would be more in keeping with the, that would not result in tall towers, right? That's what you're arguing. And they proposed certain texts, and the text is what is being contested. Or the interpretation of the text, where it's being. What I'm trying to understand is how is it failing to meet the goals that the City Planning Commission started off with? With this text, it does result in a height reduction, both in R8 and C47. I think everybody's in agreement, and the diagrams have shown that. The fact that the zoning lot has become larger than when it was reviewed then in '96, which nobody could have guessed what the zoning lot could have, is partially, to a large extent, is causing a larger zoning lot with a larger floor area I mean, you're getting the floor area from the landmark building also, which is in the C47 area. There are a lot of other factors that are also adding to a more buildable floor area, which was not anticipated then. If this text was not there, it would have resulted in a taller building. Because of the text, what we see is a shorter building. May not be as short as you want, but it is shorter than what would have been without the text. So I'm not able to find that connection. So the logical part of the argument seems to work, is that this text does result in a reduction in height.
Right, but the thing is, it's not because the lot is larger, because as I showed in my first submission, this interaction between tower coverage and bulk packing results in the height being kept constant regardless of the lot size. And so, I mean, I do believe that.
Sorry, but that's a different provision, which I agree with you that the provision that is the tower on a base rule in residence districts is an elegant structure. It's very nice the way it works. But when we look at the special purpose district, where they write it very intentionally, it takes a long time to put together a special purpose district, right? They intentionally kept this section on bulk separate from this section on on tower coverage. Why? I don't know, but so they may not have been looking at the same kind of result. We don't know that because it doesn't say that in any of the, in the report. So that elegant chart that applies to all sizes of zoning lots and all sizes of tower coverage and so on was anticipating great variety throughout the city wherever towers apply, right? But in this case, there were only a few sites that they were anticipating, and in addition to which you never know, but they didn't anticipate or allow for, that was the other part, they were not allowing for any skinny towers, 40% or nothing. Right? And so in this district, they decided that a 40% tower coverage is the minimum you get.
30, but yeah.
And whereas in the other districts, you could go much lower than that. I think it's 30%.
No, it's 30 here, and I think it could.
It's 40. No, it's 40 here.
40?
40 and 55%.
Okay, well, anyway.
40% tower coverage.
Yeah. Okay, so,
okay,
did you want to tell us why you
Yeah,
did this?
about this, so,
Yeah, it's 40.
I just wanted to address Mr. Karnofsky's argument that our little model, which I sent you in an Excel spreadsheet.
I see, okay.
I don't know. Works for this building at 1865 Broadway, and that the prediction is exactly what we say it would be. So there's something strange in this building, and, we could go down a whole rabbit hole here, but essentially, what is very odd about this building is that if you look at, okay, so on the, there's a page here, which I think is 1, 2, 3, the 5th page. It shows, it's a blow-up from the ZD1. It shows special tower coverage under section 8236, and it says that the lot coverage of the tower is 7,297 square feet. Of course, just below it says 7,298, but we'll let that pass, and that is 32.32% tower coverage,
Right.
and that's compliant.
Yeah, I just want to correct my sentence now that I'm looking at section 8236. It says, at any level at or above a height of 85 feet above curb, a tower shall occupy in the aggregate not more than 40% of the lot area of a zoning lot, or for a zoning lot of less than 20,000 square feet, the percent set forth in section 2365 tower regulations, and not less than 30% of the lot area of a zoning lot.
Right, so we're concerned here primarily with the minimum, not the maximum, which
Right.
the minimum is 30. So the the supposed tower coverage, according to this, is 7,298 square feet. But then if you look at the next page where I've blown up where it lists all the floors and their floor area, gross floor area, and residential floor area. So if you look at these tower floors, so typically, since floor area is defined as being from the outside, the outer wall, I mean, the thickness of the outer wall is included in gross floor area. So it should be pretty much the same as lot coverage, but here there's an 18% difference if you look at this.
So, I'm sorry, where are we going with this? I'm a little
Okay.
confused. No, I understand you're
Okay, all I'm
breaking
gonna
this
say-
apart, but why are we doing it? Is
Well,
it
why are we
building?
doing it is because Mr. Karnofsky said that this building was as tall as it was, that my model of how the bulk packing and tower coverage rules created a precise height limit is wrong, because look at this building, and this building has some very strange things going on in it. But if instead of using that 7,298 square foot number, you use gross floor area for tower coverage, then the model exactly predicts.
Wait a minute. This is for 1865 Broadway,
Right,
right?
right.
Right.
The site in question is, sorry, just checking the correct address, just a second, is 36 West 66th Street and 50 West 66th Street.
Right. So all I want to say is that Mr. Karnofsky, in his last submission, used this building as an example of why or how the model that we say that the bulk packing rule and the tower coverage rule, when working together, create a precise or almost exact height limit. And he says, no, look at this building, it's way taller than your model predicts. And so I got the ZD1 for this building, and I looked at it, and it has some strange things in it. He then went on to say, well, actually, this building could have been even taller, and he presents another model, which shows how it could have been even taller, but that one has even more strange things going on in it. For example, it has 16 floors below 150 feet. This is his Exhibit D on his last submission. I don't know how you get 16 floors, especially given the ceiling heights of 15 feet, 10 feet, 10.7 feet, and 12 feet, how all that fits below 150 feet. It just doesn't. And then he has a penthouse, where penthouses are required to be 80% of the floor area of the floor immediately below. His first penthouse floor is only 50% the floor area of the floor below. So I submit, all I want to say with all this, and I'd just like to put it in the record, is that I think that to the extent that Mr. Karnofsky was trying to undermine our contention that these two rules work together to fix a height in the low 30s, he didn't succeed, or he hasn't shown that with these examples.
Okay, so again, do you want us to be looking at this and unpacking this and
No,
trying to
no,
make-
I just-
Because you're introducing in additional information that we...
I don't think I mean, since he brought up these examples, I submit it as
I
rebuttal, but I don't think it should delay you 1 second, because...
Right.
Yes.
So,
I think we can ask Mr. Karnowski to
to
explain.
respond to this, but
Yeah,
maybe
we'll
by
ask.
being even taller, the floor-to-floor heights are quite low here. So this actually could have been a much taller building and still comply with the lot coverage and bulk packing rule. So
The floor-to-floor heights in which?
in the building that you gave to
Oh.
us, it's got very low floor-to-floor heights relative to a lot of the projects we see. They have 15-foot floor-to-floor heights in some of our projects.
But I'm not
So-
talking about the height, I'm just
No,
talking about the
I
number
know,
of floors.
But maybe that's what Mr. Karnowski was referring to.
No,
I don't know
I don't
what he was
believe he
referring to.
was. I mean, this building actually only has 13 floors below 150 feet. We, in our model, said you could have 14 floors below 150 feet. This has 13 floors below 150 feet, so I don't think that's the answer, but, you know, if you'd rather just not accept it into the record, that's
It's
fine,
in the
but I don't want to
record. Sorry,
delay
you
anything,
submitted it,
so...
and you are talking about it, so here we
Okay,
are.
well, I don't think it'll change anything. I just wanted to defend our little model and to say that the criticism that was made of it doesn't prove that we're wrong on that point. But since your point is that the tower on base, the bulk packing and tower coverage rules, in your view, were meant to be separate here, you know, the whole model really doesn't...
That's not what I said. I said they are separate. Whether they were meant to be separate, we can't know. There they are, separately written in the text with an instruction,
Yeah, yeah.
right? And so, as opposed to tower and a base rules in residence districts,
Well,
those
they
are
are
all together.
they are physically separate by one other provision, but nobody has come up with any reason why the City Planning Commission would have wanted to do this, so, you
Right.
know, or why.
Or why they didn't want to do it, so that's part of the
Right,
point. We
right,
don't have,
right.
as I mentioned yesterday, we have been exposed sometimes to provisions of the zoning that were inadvertently missed when city planning did a comprehensive zoning text change, and for a while, the architectural community is all confused because they know they made a mistake, and do they take advantage of the mistake, which will be corrected in some, eventually, maybe, or do they not dare because they might get stopped in the middle of construction, right? We've seen a few examples of that. This isn't one of those examples where city planning realized, oh, we made a mistake, in which case they would have corrected it, or they might correct it in the future if they determine from our decision that they made a mistake.
Right.
But it's not our impression that they think they did.
Right.
So, okay, so let's hear from DOB.
Good morning,
Sorry,
Commissioners.
yeah, go ahead.
Michael Zoltan on behalf of the Department of Buildings. A lot has been spoken about the meeting.
Yeah. So we're having a lot of trouble with mics. You have to put your, like, mouth really close and speak loudly like you're screaming at somebody.
Sure, how's this?
Yeah, that's good.
Okay.
Excellent.
So Michael Zoltan on behalf of the Department of Buildings. A lot has been spoken about the bulk distribution rule and about plain meaning doctrine, and I think for the most part, the board understands the department's position, so I'm not going to expound much on that. Yesterday, there was a little discussion about the mechanical space regarding the horizontal layout of it as opposed to the height of the floor. This was more in the Landmark West case than the
Right.
City Club one. So just one clarification to make. The department has issued final determination in this case in the sense of there is a PAA that was filed, and that changed the scope of the permit, and so that's a final determination, and that is before the board today, and we have 2 BSA cases, 2 calendar numbers, challenging the issuance of that PAA approval and that permit. So now, if there is a new challenge that comes to the department about a different issue, the mechanical space on a horizontal analysis, there is no challenge period that is before the department.
Correct.
So, as with all complaints, the department reviews complaints and will make sure that everything is okay, but that may not lead to a new final determination to come back to the board in the future.
May not lead to it.
So
right.
we'll review it, and if we are still convinced that everything is fine, there may not be a new final determination before the board. That can lead to an appearance before the
challenge.
board. Yes.
Well, but so if the appellants are interested in having Department of Buildings take another look at the mechanicals, and the department looks at the mechanicals in terms of their layout and plan, and determines that it's a reasonable layout, or it justifies the amount of floor space to occupy by the mechanicals, you're saying the department might not issue another determination?
A final determination, one that is appealable.
Appealable?
Yes.
Because?
There is no public challenge period closed, so the ZD1 goes up, and that's a public challenge period on new building, or when the permit is issued, that's a public challenge period that they can take to BSA, which they did in this case, but there's no new avenue for a public challenger to request, that necessitates DOB issuance of a final determination.
Unless, for example, the appellant reviewed the materials themselves and found that they were faulty, for example. Would that, if the appellant hired an engineer, and the engineer said, there's too much mechanical equipment in here, and contest it, would that open a challenge? Not necessarily.
It can be a complaint to the department, and we will review it, but it won't necessitate a final determination. That's the distinction.
Okay, so this is, again, Department of Building practice, and I would say council of appellants and DOB council would talk that out, because I don't, that's not really our domain, okay? But the question isn't before us, because DOB hasn't reviewed it, so, okay, thank you very much. Okay, yeah, Mr. Klein?
Morning, Madam Chair, Commissioners. My name is Stuart Klein.
Speak really loudly.
Okay, sorry. My name is Stuart Klein of Klein Slowick, and
And say who you represent, so everyone can
I
hear.
represent Landmark West, and let me preface what I'm about to say, which is, that is the most absurd statement I've ever heard in my life.
Which?
And, well, the fact that the building department admits it made a mistake in not reviewing the plans, because the plans were grossly incomplete, and yet there's no review process available to the board, because they will not issue a final determination on that. Aside from being grossly wrong, if they took a look at the 45-day challenge rule and the history of legislation, they're completely misinterpreting it. They're also misinterpreting or misreading our application. Our appeal was predicated not on the zoning document. Our appeal was predicated on the DOB permit issued on April 11th, 2019, which was based in part on the mechanical space plan submitted by the applicant. That permit is an appealable final determination as per the code of the City of New York 101-15A3. So obviously, it is properly before this forum. And for them now to say that we have no appeal rights in this because they're not going to review these and render a final determination, literally takes away our right to appear before the board.
So they didn't say they wouldn't review it. They said it might not result in a final determination.
Well, that's another way of
which is
saying it
different.
won't result. I have 3 applications from the BSA now to appeal permits. They are sitting on their desk for over a year, and each of them is a single issue item. and I keep on emailing them, and they keep on saying we're working on it.
It's currently before the board now.
What, excuse me?
It is currently before.
No,
It is currently before-
no, that's what we don't.
No, excuse me, it is before the board, because under the city rules, the permit is a final determination. Our appeal was not made pursuant to the 45-day rule.
Right, so the issue, though, is that you have to raise the specific issue within 30 days in order for it to be
And we
before the
did.
board.
It was, excuse me,
I believe at the last hearing, it was discussed, and this was briefed in the papers, that actually the characterization of the issue in your papers was as to this sort of horizontal issue.
no,
that
actually,
was
absolutely not. It basically...
As to the
Don't interrupt.
I'm sorry.
measurements of the mechanical space. And since that issue was not presented in a timely manner under the board's rules of practice and procedure, that is not before the board. But nothing would preclude the Department of Buildings from issuing a final determination as to that matter.
Excuse me.
It's obviously subject to discretion from what we just heard, although the public challenge rule also provides for a new public challenge period should a new ZD1 be uploaded. However, because you did not raise this issue in your papers within 30 days, that is why it is not before the board.
With all due respect, that is wrong. The permit was issued April 11th. We filed within the 30 days on May 13th because there was a Sunday involved. So we submitted it the last day of the 30-day period. That permit is appealable as it is a final determination. So it is
That's not
before,
the-
excuse me, it
that's
is
not the
before the
issue.
board. Let me address your second issue. Your second issue, it wasn't raised. Well, number one, you don't have to raise every single issue in your first application. You always supplement it. So there are issues that are raised subsequent to the initial application, which the board has always engaged and always resolved and always
Sorry, we
received testimony.
don't always engage and always resolve. We have many applications where an appellant brings up, we have one we're working on now, brings up hundreds of issues that the board can't possibly look at, right? One at a time has to be something where DOB has considered the issue clearly, and the board has had an opportunity to understand the arguments being made by appellant. And in this situation, we were never presented with any information about the mechanicals in horizontal mechanical layout. And so all of these papers that have been submitted, not once has there been something actually given to us for us to analyze mechanicals, and nor has DOB opined on whether they think the mechanical space has been properly laid out.
With all due respect, again, that is not true. In our original application on 513, we said the permit, not the zoning, not the CD1, the permit should be revoked because the underlying plans contravene the zoning resolution in that the owner's attempts to exempt the voids from floor area should be rejected, as the voids are neither used for mechanical equipment nor are they accessory uses to the residential uses in the tower.
Sorry,
That
a
is the-
void is not the same as the mechanical space. Mechanical space is occupied, and a void is sort of a recent term of art that's been coined by challengers to these buildings, right? But void, by its very word, implies nothing inside, right? But when we have a mechanical floor, it's filled with mechanical stuff sitting on the, in plan on the floor, and so the language in your appeal refers to voids. I'm sorry, it doesn't
I'm sorry,
refer
there's-
to mechanical space or mechanical equipment being not
But you're defining a
justifiable.
term that is not defined anywhere in the code. I mean, voids mean space, and this space, if you look at the plans, is a unitized space with mechanical elements in there, and the buildings department in the Sky House case specifically said that it reviews every single case to determine the functionality of the mechanical space and if in fact the deductions are merited. We argued that the mechanicals do not merit those deductions. And as a matter of fact, we cited to a memo submitted by the buildings department, which indicates, excuse me for a second, that A, the plans will not be reviewed, unless there's sufficient detail on all the drawings, that they will not be accepted or approved for review, and that in the building code, or rather in the BIS system, it says, mechanical drawings show the building systems that provide for the heating, ventilation, air conditioning, plumbing, and fire protection needs for the proposed project. They shall include mechanical drawings involving heating systems, ventilation systems, air conditioning systems, exhaust air systems, piping layout, locations of return, air plenums, location and heights of exhaust and vents above, and goes on and on and on.
What is
None
it
of
you're
those-
reading? Sorry, I don't know what you're reading.
I'm reading from a guideline for filing plans issued on the building department computer.
How is that relevant to what we're talking about?
Because the building department approved these plans, and none of those articles, none of those items were submitted to the building department, despite the fact that in the townhouse case, they said they review each and every building for the particularities of the mechanicals submitted.
So
the
you're,
buildings-
I'm sorry.
Yes.
But you're aware, because I know you're aware, that I don't know actually what the status, and Mr. Kornowski will address this, what the status of the filings are on this building, whether they've already filed full electricals and mechanicals.
No,
I
they
just
were-
don't
excuse me.
know.
They had to be filed in order to have the permit issued. The permit was issued for this mechanical space, and those plans were submitted to you. And the mechanical space was, I took all those plans, it's about 10 in nature, I blew them up, and there is absolutely nothing in the plans that comply with the building code directives and the building code law. So they approved a permit to issue for this building, and those plans were palpably deficient. So I'm simply asking one of two things, that the permit be revoked as per my request on my May 13th application, because it doesn't deal with height, it deals with spatial realities and the actual description of the mechanical space, or that the applicant come forward and submit those documents, which should have been submitted in the first hand to the building department. And all I'm asking for the building department to do is to do that which is required to do by law, and which they agreed to do, and they claim they do in the Sky House case.
So.
They didn't do that here.
So here's the thing, you are in fact, if we simply listen to the videos and read your submission, you're introducing a whole pile of new things that you want us to review.
No, I'm not.
Right? Yes, you are. And so we haven't looked at whether or not that those questions about buildings department performance are actually properly before us. We usually do not get involved in whether buildings department properly processed their materials, because they handle the construction of these buildings in the way that they do, where we've learned that there are series of applications that are filed for all the different trades, and that eventually they collect into one complete application, but they're not filed all at the same time, because that's just not how buildings are designed. And the buildings department allows those applications to be filed sequentially. That's why you have a mechanical submission, electrical submission, structural submissions, all of that, the main architectural drawings. So if you're
But it's
asking
submitted
us
at the
to
time of
go,
permit.
if you're asking us to go through buildings department procedure and question how buildings department processes their applications, it's a completely different, stop interrupting, it's a completely different review. And then we would need Department of Buildings to get up here and explain to us what's the process that they go through, how does it comply with the building code and the admin code, et cetera, et cetera. This was not before us, and if you think it should be before us, then we have to certainly delay any decision on this part of the case. I don't know what that does to the concern about the other case, the City Club case, and so who wants a decision today, right?
Well, I don't care if they want the decision today, that's my concern.
They want a decision today.
That's not my concern.
It's not your concern?
Absolutely not. I mean, you could bifurcate this, number one, but number two, in the Sky House case, you specifically went through the protocol as to what the building department does to review mechanical deductions. You asked them, and you agreed with their protocol. Here, we raised the fact in our May 13th, which is an appeal of the permit. We raised the fact that this mechanical space was improperly deducted. I do not understand how that's not before the board.
So the Sky House case was the question about the mechanical voids, right? And in the process of reviewing the subject of mechanical voids, we needed to understand what's the mechanical equipment in the space so that we could look at that, right? Because what if the void, we were just talking about what is a void and whether there's a height limitation. So we wanted to also know what's the height of the equipment, et cetera. So show us drawings to show us how those spaces are occupied by mechanical equipment. In the end, of course, the appellants didn't come with an engineer, so all we had was pictures of mechanical equipment and no determination from DOB. We didn't get a determination from DOB about whether it was a reasonable amount of mechanical equipment. We just got drawings.
Well, actually, it did.
No,
They
we-
stated on multiple occasions in that case that DOB came in and told you that they reviewed them and they are sufficient for the building and the deduction was justified. They did say that. Now, here, it is impossible to make an objection to the mechanical space deduction because nothing was included in the plans.
Counsel.
You had 20,000 square foot floors with a little box here that said boiler, a little box here that said something else, and none of the information that is required to be in the plans as per DOB code and DOB protocols was in it. So essentially, the buildings department is saying, excuse me, we made a mistake, but it's not appealable. That's
Counsel.
absurd.
Assuming it was, this issue wasn't properly raised,
Yes.
are we precluded from hearing this?
Well, so it goes more like this. What Mr. Klein is suggesting is that we unpack the entire application.
Absolutely not. I'm just asking
And,
the mechanical
well,
space.
it's just because that's all you're asking to, no, you did more than that. You said mechanical space
Right.
being occupied by mechanical equipment, and then you said, oh, but the permit wasn't properly issued because they
It
didn't
wasn't
submit the
properly
drawings
issued.
and all that stuff.
And no, all
right?
I'm simply, please, don't conflate the two. I basically
I'm not
said.
conflating, I'm saying
No,
what
I
you-
simply said, it is within your power to either revoke the permit because it was improperly issued, because they never received completed
different.
plans, or in the alternative, ask the buildings department to secure plans consistent with the building code and come to the board and show that the deductions were reasonable. Here, there is nothing on the record or at the buildings department to show that those tens of thousands of square feet which were given to them in deductions is justified, period. There's no justification for a single piece of equipment. As a matter of fact, if you take a look at former First Deputy Commissioner Faliello's memo to his own staff, it said you have to include pipes. If it's above 5 feet above grade, it doesn't count. I mean, there's a whole protocol, none of which the buildings department followed, and then they come here before you and brazenly say, well, we're not going to issue a final determination.
Okay, so what I do want to stop right here is, I don't know the status of the current filings with the buildings department, and so I don't know whether counsel for the owner actually knows the answer to this, because the only people who would know is the engineer and architect on the job, and whether or not those things have been filed.
They haven't been.
Sorry,
It'll either be in the bid system or not, it's not there.
I don't know the status of the application. I'm not going to go on your say-so, because you're
I
not
appreciate that.
you're not the owner of the building.
Okay.
Okay, so I want to hear from the owner of the
Thank
building.
you.
Okay, thank you. Please refrain from clapping. It takes time. It's not necessary.
David Karnofsky, Fried Frank, Harris, Shriver, and Jacobson for owner. I'll address the City Club first and then Mr. Klein. I'll try to be brief. I do agree with Mr. Lobier that this has been fairly substantially briefed, and you're aware of just about everything there is to say. At the August 6th public hearing, we demonstrated that the language of the bulk distribution provision is clear and unambiguous. Within the special district, that is, within the Lincoln Square Special District, without exception or limitation, qualification, exclusion of any zoning district. at least 60% of the total floor area permitted on the zoning lot, that's the total floor area on the zoning lot without limitation as to the zoning district, shall be within stories located partially or entirely below a height of 150 feet from curb level, and that's irrespective of whether development is built under tower regulations or standard height and setback, and without any fixed limit on the number of stories either below or above 150 feet. And the project complies fully with this provision. In the face of this clear and unambiguous language, the appellants have made multiple arguments that the plain language does not mean what it says, and that it somehow excludes the floor area permitted on the R8 portion of the zoning lot from the 60% bulk distribution calculation. And in their most recent submissions, they revert to an argument that Section 8234 mandates a 60-40 ratio between the floor area and the base of the building and the tower portions, and what they mean by that is simply none other than that the 60% bulk distribution must be calculated on the basis of the C47 portion of the zoning lot only, which is another way of saying what they've said all along in 20 different ways, that 8234 does not apply to the R8 portion of the zoning lot despite its plain language. At the August 6th public hearing, the chair asked City Club's council whether it could identify any ambiguity in 8234, whether considered alone or in conjunction with the provisions of the special district, with the chair noting that the question should be answered by council without resort to extrinsic evidence or the provisions of Article 2, meaning without trying to conflate 8234 with the tower and a base regulations of Article 2. As we understand it, the reason for asking this question was that under New York law, where a zoning provision is unambiguous, the board must, to use the words of the Court of Appeals in the Zalden v. Concord case, quote, do no more and no less than apply the language as it is written. The appellants have failed to identify any such ambiguity, and the statute should be applied in accordance with its terms. Unable to identify an ambiguity, they misstate the law, saying that the principle that where statutory language is clear and unambiguous, the court must construe it to give effect to the plain language, by saying that that is only valid in certain circumstances, or in most circumstances, but not in all. And they misstate Zalden, they misstate Raritan, and they ignore the guidance of those cases that legislative intent is to be ascertained from the language of the statute itself, and that resort to extrinsic evidence beyond the language of the statute occurs only where the language is ambiguous. Now, they cite to Stringfellows as an example of a post-Raritan case, which they say qualifies Raritan, but what does that decision actually say? It says that legislative intent is ascertained from the words and language used in the statute, and if the language thereof is unambiguous and the words plain and clear, there is no occasion to resort to other means of interpretation. In that case itself, the issue was about what does the word customarily mean in the context of the adult use regulations, and there was an ambiguity about it, an identified ambiguity about what that meant. There were two competing interpretations. What did the court do? The court looked to the use of the word customarily under other provisions of the zoning resolution, like in the home occupation provision, and it looked to the rules of construction of the zoning resolution, and it resolved the decision in the city's favor. It is not a support for a qualification or diminution of the law stated in Raritan. The other cases cited by City Club don't support the proposition that resort to extrinsic evidence is appropriate where the language is unambiguous. They either involve situations where the statutory language was ambiguous and the courts recognized it, or where a court interpreted an ambiguous provision by looking to other provisions within the same statute, or where a court was called on to resolve a conflict between provisions of a particular statutory scheme. Now here, I think as we've demonstrated over and over again, when you read 8234 in relation to the other provisions of the special district, it only reinforces that its plain language means what it says. And that's because, as we pointed out, in the context of the other special district provisions, it's clear that 8234 is distinct in applying within the special district without all the various types of exceptions, exclusions, and limitations found in those other provisions. Regardless, as has been discussed, and I'm not going to go over this again, the result in this case is not absurd the absurdity doctrine being a very limited exception to the Raritan doctrine. And we've demonstrated that. Most recently, the appellant City Club argues and claims that 8234 inexorably dictates an upper limit to the number of occupiable floors, which they calculate with exacting precision using an Excel or Excel spreadsheet of 32.4 stories. 14 floors below, 150 feet, and 18.4 floors above. According to them, the parameters set by the statute embody a mathematical limit that not coincidentally is in the low 30s. Although the statute does not spell out in words the requirement that the number of stories remain in the low 30s regardless of lot size, it does so in numbers. Its mathematics make it so. Of course, had the City Planning Commission wished to establish a fixed limit on the number of permitted stories, it would have done so by codifying the appellant's 32.4 floor limit or some other limit in the statute. It did the opposite. It rejected any absolute height limit, and it disavowed an interest in producing uniform results by noting that the special district is an area characterized by towers of various heights. And as discussed on August 6th, the Planning Commission predicted in a single statement in its report, and a statement that was based only on study of 6 soft sites studied as part of its work leading up to the zoning text amendment, that its proposal would produce a range of results, not a single fixed maximum from the mid-20 to the low 30s. And as we also discussed, City Planning's proposal was controversial because, among stakeholders, precisely because it didn't produce a predictable result, or so they felt. The exact opposite of what appellants now claim. In fact, Landmarks West was a vocal opponent of the bulk distribution proposal in 1993, and it testified at City Planning as follows. While we agree with the intention of limiting height expressed by the department, we cannot accept the device of packing the bulk. This device would not, in fact, limit the height of buildings, but only makes achieving a tall building slightly more difficult than at present. Moreover, Landmark West stated, based on work that was conducted at the Environmental Simulation Center, that buildings of 33 to 35 stories, quote, would not be uncommon on the remaining development sites. This belies appellants' wishful thinking that there is some kind of 32.4-story limit hidden and embedded in this statute. City Planning did not intend any such mathematically fixed limit, and the stakeholders opposed it precisely for that reason. Now, with regard to 1865 Broadway, the purpose of our introducing that into the record was simply to illustrate the variability in the application of the rules. 1865 Broadway is a building being built by another developer with 32 stories. And what we demonstrate is that that 32 stories is a function of the tower coverage, which exceeds the minimum required, and the fact that they didn't take advantage of the penthouse rule, which allows you to have floors at the higher levels which have lower tower coverage. And what we show is simply that by going down to the minimum, the 30%, and utilizing the penthouse rule, a greater number of floors can be achieved, and we calculate that as 35. That's 2.6 floors more than the appellant's supposed 32.4 limit. By the way, it's the number that was cited by Landmark West in 1993 as a possible result, and 35 is the number of stories in the project itself, exclusive of the mechanicals. It's clearly not an absurd result in this case to have the same number of floors as could be available and achievable at 1865 Broadway, which is a site wholly in the C47 district. And even assuming, arguendo, that 8234 uniformly produces 32.4 residential floors on a zoning lot located wholly within the C47 district, it is clearly not absurd that the project, with different conditions resulting from the fact that it is a split lot, contains 35 residential floors, a difference of 2.6 floors. So neither the language nor the legislative history nor the modeling by appellants supports the theory that the special district rules embody a fixed limit of 32.4 occupiable floors. So for all of the reasons set forth in our papers and discussed on August 6th, as well as today, DOB's decision applying the plain language of Section 8234 in accordance with its terms and following the clear direction of the Court of Appeals of the state should be upheld and the appeal denied. Now,
I just want
Oh,
to,
sure.
just a question on this 1865
Yeah.
Broadway. So what you were saying is, if you use the penthouse rule, you could have a smaller tower,
Yeah.
which allows more height, but you still have to have the 60% or whatever the number is.
Yes.
Below the 150 feet, so you need to play around with the floor area. Oh, but then you would just have a smaller floor plate
Yeah,
of the
at
tower.
that higher levels.
You'd have a 30% tower, and then you'd have whatever the...
And then below, it can be below 30%,
Yeah,
as long as
yeah.
you comply with that penthouse rule. That building, for whatever reason, and that was their choice, elected not to do that. We were illustrating that if you do it, you can get to the 35 floors in combination with going down to 30%. That was the purpose of that, and that's its only purpose. With regard to, should I move on to? Okay.
Yeah.
With regard to Landmark West's argument that the board should address in this proceeding issues regarding the mechanical floors, regarding the floor area deductions taken from mechanical equipment on mechanical floors on the basis that its initial statement of May 13th squarely raised those issues, it did not. These issues regarding mechanical floor space were first raised at the public hearing on August 6th, more than 2.5 months after submission of the statement of facts, well after the 30-day period that Mr. Steinhaus referred to. The issue relating to mechanical deductions as defined in Landmark West's appeal on May 13th is as follows. The permit should be revoked because the underlying plans contravene the ZR in that the owner's attempts to exempt the voids from floor area should be rejected, as the voids are neither used for mechanical equipment nor are they accessory uses to the residential uses in the tower, end quote. There is no question that the term voids as used here refers to the building's tall mechanical spaces and not to issues relating to whether the amount of horizontal floor space used for mechanical equipment in the project is excessive. Landmark West's statement of fact, in fact, defines the term voids. It refers to them as vertical space. It states, quote, a substantial portion of the tower's height, 196 vertical feet, would be comprised of empty spaces, parentheses, the, quote, voids, end quote, end parentheses. Insofar as Landmark West questioned whether the voids are needed for mechanical equipment, it was with respect to their vertical dimension, that is the floor-to-ceiling heights of the spaces. Each and every one of the arguments was made to argue that mechanical spaces with tall floor-to-ceiling heights are unlawful or must be counted towards floor area, precisely the issues which the board addressed in calendar number 2016-427A relating to 30th Street. Landmark West's assertion and in its August 21st supplemental statement that the issue presented in its initial May 13th statement of fact, quote, covers all spatial objections, length, width, and height to the FAR deductions is simply wrong. They had the opportunity as early as May to raise issues, whether the floor space used for mechanical equipment in the project is excessive, but they chose not to do so until the August 6th hearing. We believe, as Mr. Steinhaus indicated, that this is improper, that appeal should have been made within the 30-day period, and that the new issues raised by them at this late date should not be heard in this proceeding, and that their resort is to the DOB, as the DOB counsel explained. With regard to your question about mechanical drawings, over 150 mechanical drawings were submitted and approved by the DOB in connection with the permit approval. The suggestion that they are incomplete or that they don't exist is specious.
Okay. Do you happen to know when they were approved, just to get that?
Well, they were approved in well, I don't know specifically on the mechanical review, but the
Right.
April approval of the permit was an approval with respect to everything.
Okay.
And do you
Okay.
believe we're
And-
precluded from hearing this issue on?
Say that again, I
Excuse me.
can't
Do you
hear.
believe we're precluded from hearing?
As I understand it, and obviously you'll be guided by your counsel, the appeal period was a 30-day period, during which time they had the opportunity to raise the issues they wanted to raise on appeal. This is not a free-ranging exercise of raising issues continuously unrelated to the issues raised on appeal. So I would say no, they don't have you
Right.
don't have jurisdiction, but you have to be guided by your counsel, not me.
So I wanted, while you've been talking and in response to what Mr. Klein said, I was reviewing all of the submissions for that particular, for Mr. Klein's case, right? And I do have to say that up until August 22nd, there were no submissions made on that case that were different from the case that was for by City Club. In fact, it was a cut and paste onto new letterhead to the point where we were reading the same thing twice. And so the only time, and every time that we talked about mechanical equipment in those earlier submissions before August 22nd, the discussion of mechanical equipment always had to do with how tall it is in the space, and there is actually a sentence that says if the equipment were 6 inches high, then that would count, and therefore you could have a mechanical void that's however many feet high, right? And so the focus was always on that, not on the mechanical equipment. It's on August 22nd for the first time that there's a submission that says, should address the issue of the subject FAR deductions for mechanical equipment space without reviewing the mechanical plans, without determining what equipment, if any, the alleged mechanical voids will house, and without analyzing the technical manufacturing requirements of the equipment and the spatial parameters necessary. So that was really just submitted relative to this current hearing. And so really brought up as a new subject. And without knowing exactly what our purview, or let's say limitations are, what I do know is on other cases where we have appellants bring up things as we go, the board can't continuously look at things that come up in the hearings, because it would mean that they go on indefinitely. They need to be raised at the outset so that the board gets the right information and that it's properly before us according to statutory requirements. So my personal opinion is that this is raised too late.
And just a question, if it was raised, it would have been challenging DOB's determination, and it would have been in those documents, and I don't think that was reflected either.
So what the appellant is arguing on this second case is that the challenge is of the building permit, which therefore is absolutely everything, right? But without directing us to what on the building permit to look at in the initial submission, we can't look at absolutely everything, right? And to bring up things on the eve of decision, really, because it was clear that we were going to be deciding this on the next hearing, right? I think, for one, I think is improper. In addition to which, we have no reason to believe, because there's been no analysis of the mechanical equipment, we have no reason to believe that it isn't the right amount of mechanical equipment for the space, right? So according to that, it's sort of like a red herring, you know? There's lots of things that could be wrong with the building. They could have, you know, they could say the staircases aren't wide enough, the elevators don't meet code, et cetera, and there's no way, then we would have to look at whether the staircases meet code because they bring it up. And so this is the problem, right? And so I don't think it's properly raised, and I'm sorry that really in this case that this appellant wasn't submitting their own papers. Instead, they were submitting City Club's papers on new letterhead, frankly, and we were reading the same arguments on both sides. So.
And also, as we discussed at the last hearing, the vesting issue under 11-331 isn't before the board, and it appears that everybody's sort of... As we discussed at the last hearing, the issue that was subsequently raised past the 30-day period with respect to zoning resolution section 11-331, which is statutory vesting, it was undisputed at that point and still is. Nobody's been talking about it today, that issue is not timely before the board.
Right. Okay, so now if you would just, so the drawings were submitted, mechanical drawings were submitted. They're available in the public record because they're submitted. You don't find them on Biz. You have to go actually into the buildings department and pull files and do it with an engineer who can actually review the drawings. But we have no reason to question that the mechanical equipment is defectively represented on the drawings, which is a completely different thing than the other appeal. The other appeal actually sets up the argument. It says, we think they're wrong, we think they misinterpreted the statute, and this is why. That's how you bring an appeal, right, with some basis.
How do we, procedurally, we wouldn't decide on the merits of this case then?
the merits that were brought to us in the initial
In the initial.
submission were the same ones as on the City Club case.
Okay.
The bulk packing rule, basically. And the mechanical voids were brought to us, and we decided that's issue precluded, because we already decided that on a prior case. And city planning already amended the zoning resolution in response to our decision. So, okay. All right, thank you very much. Yeah, now public testimony, yeah.
Elected officials first, please.
Just to note that for the public testimony aspect of this application, if you could limit your testimony to the merits of this appeal. Thank you.
And, yeah.
Okay. Good morning, my name is Richard Gottfried. I represent the 75th Assembly District, which includes 33 West 66th Street, also known as 50 West 66th Street. I oppose the construction because of the impact it would have on the community and the precedent it would set. The Board of Standards and Appeals should revoke the permit, the building permit, for the building issued by the New York City Department of Buildings on April 11th, 2019. The project uses large mechanical voids dispersed through the building. There is a cumulative 239 feet of void space in this tower, comparable to 24 stories. The developer's attempts to exempt the voids from counting as equivalent floor area should be rejected. The developer has failed to prove that such an unprecedented oversized void is required for proper mechanical functioning of the structure, and the New York City Department of Buildings has failed to verify the location and spacing of any mechanical equipment on these floors, and therefore cannot justify their existence. These voids, like those being included in some other super tall buildings, serve no functional purpose. They are used to increase the developer's profit by increasing the altitude and thus the market value of upper floor apartments. They do this at the expense of imposing more visual pollution and loss of light on the surrounding community. If the volume of the voids were counted as if it were divided into ordinary floors, the building's floor area ratio would plainly violate the applicable zoning. The city should not tolerate this abuse of the zoning and building codes. At the state level, I co-sponsor Assemblymember Linda Rosenthal's bill, A5026A. This bill would provide that if the height of the floor exceeds 12 feet, the additional increments of height would count as additional floors for the purpose of calculating floor area ratio. This building's floor area calculations are contrary to the zoning resolution. The bulk packing rule states that 60% of the building's floor area must be below 150 feet. And the tower coverage rule states that the lot area of a zoning lot higher than 85 feet must be between 30 and 40% of the lot area. In tandem, these tower on base rules are in place to limit the height of building development. Buildings in the neighborhood that abide by these rules average 20 to 30 stories. These rules were put in place to preserve the context of the neighborhood and to limit the height of buildings to an appropriate level. Because the building's site involves two different zoning districts, a C47 and an R8, the developer is choosing to selectively apply portions of the zoning resolution to the zoning district. And the developer asserts would allow for a larger and taller building. Both rules must apply to this building, and the developer cannot be allowed to pick and choose which rules he wants to abide by. The 36 West 66th Street building development is an abuse of zoning regulations, is contextually out of scale, and would set a terrible precedent for future proposed developments. I strongly urge the BSA to revoke the permit for this super tall tower. Thank you.
Thank you. Please, no clapping, please, you have to, please,
If
no.
you're going to show support, please use jazz hands. Thank you.
Yeah,
Who's next?
please.
Good morning. State Senator Brad Hoylman. State Senator Brad Hoylman. I represent part of the Upper West Side, including 36 West 66th Street, as well as other parts of Manhattan. I would just say from the outset, my district certainly does not need a super tall building on the Upper West Side, and therefore I've come to speak in support of the appellant and their docket numbers today, the challenges by the City Club of New York and Landmark West against the building permits allowed for 36 West 66th Street. There's no question about it. The 775-foot tower proposed for the site is out of character, it's unacceptable, and it is, in fact, absurd. The purpose of the special Lincoln Square District was, in fact, to preserve, protect, and promote the existing nature of the neighborhood. If built, this will be the tallest tower on the Upper West Side. How is that in character and aligned with the 1993 special zoning text? The height of the building will cast shadows across Central Park. That includes recreation space, trees, and lawns that my constituents have fought generations to keep. How is that acceptable? The proposed building utilizes 239 feet of mechanical void space, or mechanical space, or void, or whatever you want to call it, that boosts the tower's height and will extract the most money the developer can for luxury apartments with views of Central Park. In my opinion, that is excessive, dangerous for first responders to have to traverse, and should be against the law. We are looking in Albany to change that law. It's a shame that we have to do that in Albany when the city could be doing it already. How is this building's construction predicated on flagrant exemptions from zoning not plainly rejected by you? It is absurd. The bulk packing of such a tower flies in the face of the special Lincoln Square District. Allowing building permits to remain valid would be a horrendous precedent to set, rendering zoning text practically useless and community interests void. And I wanted to thank all the community members who've been fighting on this issue, Community Board 7, Landmark West, the City Club of New York, the West 64th and 67th Street Block Association, and Save Central Park, NYC, for their continued work. A tower of luxury condominiums is not what we need or want. I join with my elected colleagues and neighbors in urging you to uphold the community's challenges to 36 West 66th Street's buildings permits. And let me say that the Extel Tower will be your legacy as your term members on the Board of Standards and Appeals. If this plan proceeds, you will have flouted the common sense readings of the building code and allowed a developer to take advantage of a loophole that will obliterate the intention of lawmakers who helped create the special Lincoln Square District. This new 770-foot tower will not only be a monument to greed and the patent disregard of our community's concerns, but sadly, I think, a monument to your bureaucratic fecklessness, succumbing to the wishes of a wealthy and powerful developer who will destroy our neighborhood. I urge you to reconsider and support the appellant's application. Thank you.
I just need to correct the record a little bit. So the Board of Standards and Appeals in this particular situation, we're kind of like a court. So in this type of situation where the Department of Buildings interprets the zoning resolution, which is what's before us, and then we look at whether or not we believe the Department of Buildings properly interpreted the zoning resolution. This is not a variance. It's not a situation where a developer is coming to us to ask for permission to do something. It's simply a question of whether we believe that the zoning resolution, which is a statute, says what DOB thinks it says. And sometimes DOB opposes the developer, so sometimes it's the developer who brings these challenges. So our only question is, was DOB right? And when we look at it, we're like a court, if any of you follow how the Court of Appeals, the Supreme Court makes its decisions, we look at what does the text say, and if the text is clear, the Supreme Court will say, well, it says right there in the text, or it says right there in the Constitution, right? But when the text isn't clear, then we look to what it is the legislature, which in this case would have been the City Planning Commission or the City Council, what they had in mind when they were doing it. But we're only doing that when the text is clear. The reason that that's the method that we apply is because the Court of Appeals, which is the highest court in New York State, orders us to do so. So when we have just made decisions, for instance, there's the case that we keep citing to, which is called Raritan, I guess, versus Board of Standards and Appeals. That was a famous case, which I love to tell about, where the Department of Buildings was interpreting that the definition of cellar, when used in the context of a residential building, is floor area, even though on the zoning resolution was incredibly clear that it actually said almost words to the effect, cellar space is never floor area. It actually effectively said that. And the Board of Standards and Appeals agreed with DOB, who was interpreting cellar space to be floor area, because that's just the way the DOB had been doing it all along. And so BSA agreed with DOB, and the court threw that back at BSA and said, what are you talking about? It says right there that cellar space is not floor area, it's not floor area, and they overturned the decision of the BSA. And we are continually reprimanded by the courts when we don't follow their very clear instructions. And so we're not the legislature. When the legislature decides that the zoning resolution is unclear or ending up with negative results they view as being negative, then it's the legislature, therefore, City Planning Commission and the City Council, that changes the text. In the case of the mechanical voids, they agreed that the text was unclear, and they actually changed the zoning resolution to limit the heights of mechanical spaces. The problem in this case is this building was already under construction by the time the zoning text was changed to limit the heights of mechanical spaces. And so creating a bad precedent isn't probably what because your real concern is about height here and the mechanical voids. You won't in districts like this one to which that new zoning text applies. In districts like this one, you won't see stacks of mechanical voids anymore because it's not allowed as of whatever that date was, May something, right? Okay, so I just want to be clear, and we're not looking at the mechanical voids. That was already decided in another case and changed in the zoning resolution. We're only looking at what's known as this bulk packing rule that has to do with the amount of coverage of a tower and how much floor area has to be located below 150 feet. I just want to make it clear to everyone what's before us, what we're looking at in this case. Okay? All right, next speaker, please.
Chair Perlmutter, I appreciate you.
State your name, please.
My name is Helen Rosenthal. I'm a member of the New York City Council representing this building on the Upper West Side and all the people who live in the district around where this building will go. And to the point you just made, I do just want to mention that the City Council's hands were completely tied when we passed our new law having to do with mechanical space, because it was this administration's city planning that presented the city council with really only one option and did not listen to the community that did not want that one option. And so as a city council, we were really forced to accept something that I think all of us in this room wholly reject, which is allowing a lot of mechanical void space. So I want to start by setting the record straight on who drove that process. It was absolutely driven by this administration. Just to piggyback on State Senator Hoylman's point, I would like to make 3 points. And first is that I actually object to the BSA's admonishment just before the public session started to stay within what really, while I heard the words you said about courts and the Supreme Court and decisions and overturning BSA decisions, I would like to similarly assert that these parameters are subjective, that on its face, these parameters that you've given us favor the developer and reflects a meaningful bias that does not serve New Yorkers and does serve for-profit luxury real estate developers. And it calls into question the ability of BSA to be impartial in its decision-making. It is too cute by half to hear the lawyer from the developer say that this building is 35 floors and therefore falls within the original parameters of the Lincoln Square Special District Rule. He mumbles under his breath that that does not include mechanicals, those 35 stories. The special district...
No, I think he's talking about the mechanical penthouse on the top. I think that was the reference.
That was
Okay.
the whisper under the breath? Okay. Perhaps. Look, when the special district rules were written that referred to an expectation that buildings would not be taller than 20 to low 30 stories, there was no contemplation that technology would advance to the point where it is within a developer's budget to build a nearly 800-foot building. And I believe now that we're in the land of subjective parameters, that we should contemplate what the CPC would have stated in their rules had they known that we could build a nearly 800-foot tall building that is called 35 stories. And lastly, picking up from the last hearing, and this gets back to the first point, but it's important to reiterate, because I already gave testimony and gave that to you, I'm not repeating that. But at the last hearing, the BSA seemed to indicate that there was a rule somewhere that said they had to, in the case of a tie, side with the developer.
It's a Court of Appeals decision. It's not to side with the developer, that's not what the case says.
Please.
The case, and please, counsel, correct me because you're better at citing exact text, but it's that laws that essentially deprive people of their rights, it's a kind of a general theory, right? That deprive people of their rights. When a person has been deprived of their rights and there's a question about the clarity of the case, of the statute, that we have statutes that are ambiguous, right? When an ambiguous statute has the possibility of depriving somebody of their rights, whatever their rights are, the right to walk a dog, the right to hang your laundry. In fact, I think the case might have been a laundry case. Then the statute should be construed in favor of the person who is being restricted by that law, because it's an ambiguous situation. But in an unambiguous situation, you don't have any ambiguity. You do what the statute says to do. And if the person didn't do it, it's their fault because it was clear what they should have done. So they were in error.
I hear you. I appreciate.
Right.
I appreciate your taking that time.
And by the way, this person could be a developer, it could be like a private citizen.
A homeowner.
It could be you.
Exactly.
A dog walker.
Right.
So it's not necessarily a developer.
That's right. In this particular situation, it is a gajillionaire real estate developer whose rights we're protecting to the loss of the community. And I am no lawyer, and I am no judge. I am no judge, and I'm not going to be the one arguing this case as it moves forward. But I would ask you to consider the rights of the community. You have a unified, not always happening, a unified elected body, a unified community board, unified community residents who are here time and time again, who are saying they are the ones whose rights are being taken advantage of. I'm no lawyer, but I would ask you to consider that in the way that you can, to take leadership in reflecting the needs and desires of a community that has spent the last 6 years fighting this development, has brought to bear, this community is responsible for getting DOB to reverse its decision, saying that had they had information, they would not have allowed the building to go forward. This community has fought for responsible mechanical void limits, which I am sorry to say we did not achieve, and I am sorry about that. But that was truly driven by this administration. It is a point of fact that you represent the administration here at BSA.
I need to correct you on that. There is even a rule that was passed recently by us. This is an independent body. Though it's true we're appointed by the mayor, we serve independently, completely, and the mayor's office and any elected official and any outsider is not permitted to speak to any of the commissioners during the pendency of a case. We are an independent body, and we do not represent the administration. So we exist as a relief valve, effectively, from some kinds of agency action. And I really wish, because you are indeed an elected official, that you properly represent what it is that the Board of Standards and Appeals and its independent body of commissioners does, and that our decisions are based on what the law instructs us to do, and what, we have regulations about when an application is ripe for us to be heard, when a question is ripe for us to consider it, and because we are constantly having counsel defend our decisions, we need to make sure that our decisions are well-founded and based on the law.
I just want to say one thing we're not. We're not legislature. And I'm sure I'm not the only board member that wished this was written differently. But when faced with it, written the way it is, there's case law that basically ties our hands. We have to interpret it that way.
I will take that admonishment with deep respect and with which it was given. And I really appreciate what you've said. This community has heard that excuse for the last 6 years. I hear case law. I hear your hands are tied. We've been hearing this administration's hands are tied for 6 years. And so you'll forgive our frustration. Thank you.
Thank you.
Join you.
Do we have other
Someone
elected
from Scott
officials?
Stringer's office, please?
What?
I'm sorry, what did you say?
Thank you very much.
Is there any more elected officials that are, oh, that's right, I'm sorry, I apologize.
Thank
Go
you.
ahead. I'm sorry.
Thank you, Chair Perlmutter and Commissioners, for the opportunity to testify today on behalf of Comptroller Scott Stringer. I believe the proposed building
I'm sorry to interrupt
permit...
you. State your name for the record.
Michael Stinson.
Thank you.
I believe the proposed building permit issued for this building by the Department of Buildings was simply issued incorrectly and must be revoked. This is not simply a case of a developer exploiting zoning loopholes to produce a building larger than expected. This is a case of a developer creating zoning loopholes to produce a building whose height is unsafe, grossly out of context with the surrounding community, and blatantly contrary to the intent of the zoning resolution and the associated environmental studies as adopted for the Lincoln Square Special District in 1993. If the commission allows these loopholes to be codified into law through their decision, it would represent a backdoor rezoning whose impacts on the community and the environment have not been studied. In 1993, New York City adopted changes to the Lincoln Square Special District by implementing bulk packing and tower coverage rules. These rules were explicitly intended to regulate height and limit new buildings' ability to exceed 40 stories. In the rezoning report, the commission stated its belief that the regulations should predictably regulate heights of new development and produce building heights ranging from the mid-20 to low 30 building stories. By misinterpreting these rules and creating new loopholes, the developer has proposed a building rising to a farcical 776 feet, nearly 3 times the height that was intended. The developer is able to achieve this height in 2 ways. First, by misapplying zoning resolution sections 82-34 and 77-02, and secondarily by allowing large, unsafe mechanical voids in the building. The Lincoln Square Special District requires through 82-34 that 60% of all bulk in a building be located below 150 feet in height. The zoning lot is a split between 2 zoning districts, a C47 and an R8 zoning district. If these lots were developed individually, then both sites would need to comply with the 82-34 and any other bulk provision. The owner has interpreted that density in both districts should count towards the requirement that 60% of the bulk must be below 150 feet in height, but otherwise chosen to interpret bulk provisions, such as tower coverage and setback regulations, to only be analyzed based on the C47 or R8 zoning districts respectively. This is fundamentally a misinterpretation of zoning resolution 7702, which states in part that whenever a zoning lot is divided by a boundary between 2 or more districts, and such a zoning lot did not exist on December 15, 1961, or any applicable subsequent amendment thereto, each portion of zoning lot shall be regulated by all provisions applicable to the district in which such portion of the zoning lot is located. Simply put, when a zoning lot is split by 2 districts, each portion of the zoning lot must comply with all bulk regulations of that specific district unless otherwise noted in zoning resolution. The tower portion of the building does not comply with the requirements of the C47 district, which requires that 60% of the bulk in the C47 portion of the district will be below 150 feet. This alone is grounds for revoking the permit. However, the developer has further added large mechanical voids to artificially boost the height of the building. The owner has added a total of 196 feet of height dedicated to mechanical spaces, or nearly 25% of the building's total height, before one includes the rooftop mechanicals, which add another 33 feet of height. Zoning Resolution Section 12-10 stipulates that all accessory uses, such as mechanical uses, must be clearly incidental and customarily found in conjunction with the principal use. The owner originally proposed 160-foot mechanical void. Once this void was found to not be customarily found in connection with residential uses by DOB and unsafe by the FDNY, the owner then divided the space into 3 mechanical floors with a total height of 176 feet and added a 4th mechanical space with 20 feet of height in the building. The fact that 1 floor of floor space can be divided into 4 simply to subvert an objection by a city agency bring into deep question of whether these spaces are clearly incidental and customarily found in conjunction with the principal use. In addition, the recent Department of City Planning survey of mechanical spaces found that in the equivalent R10 zoning districts, mechanical floors typical height was 12 to 15 feet. The proposed building at 50 West 66th Street has four mechanical floors, all between 3 and 5 times larger than the typical building. This survey places further skepticism as to whether the proposed mechanical spaces meet the standard that they're customarily found in conjunction with primary use. Simply put, based on all available evidence, the mechanical spaces the owner has proposed are both more numerous and larger than necessary. Based on the proven previous subterfuge that the owner needed a 160-foot tall mechanical space and potential current subterfuge that they need 4 spaces at 196 feet tall, the owner must provide proof positive that these spaces must meet the basic definition of mechanical space. This is supported by the New York County Supreme Court finding, since there is no specific definition of mechanical equipment in the zoning resolution or any definitive finding by the DOB on this issue, it demands administrative determination in the first instance. Given the owner's silence on the specific designs for these spaces, despite the objections by agencies in the community, it is reasonable to assume they cannot do this, and this is another subterfuge to get additional height. Based on the available evidence, all building permits should be revoked. Thank you.
Thank you.
One more. And then we have the public.
My name is Paige Cowley, and I have the honor of reading Assemblymember Linda Rosenthal's statement. She represents the Upper West Side. Forgive me, but I'm reading type that's about 4-point, so I'm going to try to edit as I go along. First of all, she says here that she's sorry she can't be here today, but she has been a longtime opponent of overdevelopment, an outspoken critic of the zoning lot mergers that have heretofore allowed the construction at 200 Amsterdam to continue in her district, and the author of state legislation A.5026 to close the mechanical void loophole. I've strongly urged the New York Board of Standards and Appeals, BSA, to appeal the New York City Department of Buildings, reject Extel's proposal at 36 West 66th Street. Extel has reserved an astounding and excessive 161 feet of interbuilding space for mechanical infrastructure. Knowing that mechanical void space is not counted towards the total building floor area, FAR, Extel is attempting to circumvent the letter of the law to stretch the building height so that the units above the void will have access to better views and thereby fetch higher prices on the market. Extel has not proven that this mechanical space is necessary to their operation, and it is clearly only in place to boost their height of the building. Earlier this year, the New York City Council passed a law to clarify the law on void space and set clear limits on the amount of space within a building that could be used for void space before being counted towards FAR. While Linda and more than 40 of her colleagues in the New York State Legislature, who represents parts of New York City, believe that the City Council effort did not go far enough, the effort did clarify the intent of local lawmakers to circumscribe this kind of development. The BSA cannot possibly allow for a plan for a development so contrary to the spirit of the zoning resolution to move forward. Doing so would signal to the developers they could calculatedly flout zoning rules so long as plans are filed within a certain timeline. Time is irrelevant in this particular case. If it weren't enough to add 160 feet of empty space to the building, Extel also proposed to use a series of other developer tricks to do an end run around the zoning rules. The zoning lot merger that Extel utilizes to cobble together development rights, enabling it to achieve its current 775-foot height, violates the rules of the Lincoln Square Special District, which limits building height to approximately 30 stories by controlling FAR. By merging zoning lots and selectively applying the special district rules to different lots, Extel is constructing a building much taller than would be permitted if it followed the rules of the special district. I'm almost done. In addition to the obvious developer overreach, this building represents the kind of short-sighted urban planning that New York City must abandon. The zoning rules are in place not just to protect our access to light and air, two precious commodities in our concrete jungle, but also to ensure that all new development is contextual. A 775-foot tower may make sense for Midtown, but not in the middle of a much more residential Upper West Side. Development of this scale will have tremendous and unplanned for impacts on local infrastructure such as schools, transportation, supermarkets, sidewalks, just to name a few. Rubber stamping the plans for this development now doesn't just allow construction at this site to move forward. It broadcasts to developers citywide that the BSA is weak, and when challenged, it will stand with developers who violated the letter and spirit of the law and not the people in the communities they serve, or should serve, sorry. All across the city, people are rising up against this kind of system of broken government where the wealthy and the well-connected...
Sorry, you've exceeded your 3 minutes by a lot.
I know, but it's not...
Can we just finish this up quickly, please?
I can't edit somebody else's text.
Yeah,
This is an
you
assembly member.
Okay.
Anyway, she talks about her district, the last two major sentences. And despite these grim statistics, we are here today to fighting to stop a building with 16 stories of empty space. The space should be used to provide homes to hardworking New Yorkers, but instead it is being used so the residents in the top floors can literally look down on the rest of us. Last sentence. There are few dichotomies that more clearly and sadly embody the tale of two cities narrative that City Hall has sworn to fight against. I thank you for the opportunity to testify again and renew my request that the BSA reject Extel's proposal at 36 West 66th Street.
Sorry, you were representing the senator? You were reading the Senate?
Assembly members.
Assembly member.
Rosenthal, Linda Rosenthal.
Okay.
Thank you.
Okay, thank you.
Thank you, Commissioner.
Okay.
So
3 minutes, right?
3 minutes.
Okay, so now, assuming no more representatives of elected officials, true? Then everyone else is invited to speak. You're limited to 3 minutes. When the beeper goes off, wrap up quickly, please.
Yeah, just please state your name for the record.
Good afternoon, Commissioner. Sean Corsandi for Landmark West. Landmark West is short of words. We've been saying it all for nearly 5 years. We've talked about this in various forms, through placeholder buildings and an unsatisfactory DOB challenge, to an initial BSA filing without a single issued comment, to a DOB notice to intent to revoke, mysteriously cleared yet simultaneously unresolved in any accordance of semblance to DOB's own enumerated procedures, and now a second BSA filing where we know that even a tie favors the developer over the community. Thus, tie equals community loss. All the while, we examine the voluminous record of what city planning intended. However, intent equals irrelevance. Today again, city planning, who called this project obscene, is again absent. So Central Dark Tower equals obscenity. We must ignore city planning intent as we await a tertiary agency's interpretation of the DOB's interpretation of city planning zoning resolution, AKA their intent. We argue over futile meetings, ceiling height, void, foundation, vesting, words we know but must unlearn as their planning definition is purposely absent in a 1,300-page zoning resolution and thus ambiguous. Conveniently, ambiguity equals carte blanche, and unfortunately, zoning equals fake news. We argue over basic language, but we understand what this is. We know from last session that expecting the text to follow meaning is, quote, strange, and a, quote, 90s argument because nobody could imagine that anyone would build like this. Nobody. Yet this follows trends begun by this developer a decade and a half prior. And although incongruous with expectation or plan is somehow not absurd. We are schooled that a 161-foot void in the belly of a building, an unjustified greater than 10% loss factor deduction, a more than 30% void for vertical rise, a single building casting shadows across the park is not absurd. By way of antonym, this scenario must then be deemed logical, practical, reasonable, responsible, sensible, and wise. There are so many words, but it's merely a limited vocabulary without mention once of community, neighborhood, health, quality of life, or even life safety to be found. It's time that New York stands for something meaningful once again in order to restore intention, rationale, and predictability into planning. This is not it.
Next speaker.
Thank you. Please refrain from clapping.
Sometimes I got to.
Actually, we developed something that is much faster. Click. It takes less time and it's not as noisy.
Or glad
okay?
hands or any whatever it is. Okay.
Hi, Chris Giordano, West 64 through 67th Streets Block Association.
Repeat your name in the mic, please.
Chris Giordano, West 64 through 67th Streets Block Association. We wanted to
Can you
introduce...
just lift the mic up so it's closer to you, because we have trouble hearing on the...
Chris Giordano, West 64 through 67th Streets Block Association. After all these meetings and hearings, we decided we wanted to introduce you to our neighborhood. As you know, the community came together in 1993 to create the Lincoln Square Special District Zoning Resolution. At that time, it's clear that city planning stated the controls in place should predictably regulate the heights of new development, and these controls would sufficiently regulate the resultant building form and scale, even in the case of development including zoning lot merger. City planning stated the intention of the zoning resolution included limiting buildings to mid-20 or 30 stories tall, which would complement the district's existing neighborhood character. We don't take city planning's words lightly. They promise predictability in zoning. In fact, the community relies on them. They also met with us on September 4th of last year, and they told us, in their opinion, the building was egregious, even obscene. At the August 6th BSA hearing, Excel's lawyers argued that the proposed 775-foot mid-block tower would not be an absurd result based on the intention of our special district zoning resolution. We were struck by the language, absurd result. So we built a model of the neighborhood so that we could share that with you, because it's where we live. Excel submitted designs for a 290-foot building in order to get permission to begin demolition. This is that building. But it's a 775-foot building that they intend to build. Just for perspective, this is Columbus Avenue, this is 66th Street, this is 65th Street, this is Central Park West, this is the park. So our community is here to ask you, does this look like what city planning and the community intended in 1993 when the Lincoln Square Special District Zoning Resolution was created? Can you tell us this is not an absurd result? Thank you.
So I just want to point out, please, we're clicking, right, not clapping. I want to point out that the central portion, which is the mechanical void, is the issue that's no longer before us, that city planning agreed should not be allowed to continue that way, and they changed the zoning resolution, and with all due respect to the city council has the authority to make modifications, but nonetheless, and now that's no longer permitted. This building started construction before the zoning resolution was changed, and you can no longer, in this district anyway, I can't speak for all the districts, do that, okay?
But we understand that there's still 293 feet of, we'll call it mechanical void space in a 775-foot building. And we have not been yet told whether it's been vested yet.
No,
or what the vesting date was.
That's not a question before us, except to say that the Department of Buildings apparently is considered the building vested, so it is not subject to that change in the zoning resolution, but going forward, other buildings built in your district will not be permitted to do that.
Is there a vesting date that's been established? Because I haven't seen it.
That's a DOB question for, it's the May, whatever the date that the
text
change occurred, which I could look up, but I can't remember
That's
offhand.
for the change to the zoning resolution, but what date was the developer vested?
That's how you vest. So the building has to have been, the foundations completed by the date that the zoning changed, which was May something. So DOB determined that the building had vested. So that's not before us, but that's how the rule works. Okay. Next speaker, please.
Hi, thank you for, I'm Roberta Seymour, I'm Chair of Community Board 7 on the Upper West Side. Several weeks ago, my testimony that CB7 has generated resolution strongly opposing the erection of this building was presented. Today, I'm here to discuss the effects on our Upper West Side community. I believe very strongly that community boards are tasked with ensuring that their communities thrive. As chair, I take my responsibility to all members of the community seriously. The building will generate oversized shadows on Central Park. It will deprive large swaths of the park and surrounding community of much-needed sunlight and daylight. It will create major health consequences. Open space must be protected. In many cities, there is legislation to protect parkland. Open space, trees, and other greenery are essential to the physical and mental health of residents, workers, and tourists. Light and air must be protected. The neighborhood must remain resilient. The proposed building will remove sunlight and daylight from surrounding buildings, increasing the use of electricity, lighting, and gas heating, and other resources. There will be a decrease in essential services for all members of the community and deleterious effects on the environment. Health of residents must be protected. Tall buildings prevent air from circulating and increase particulates in the air at street level, leading to increased rates of asthma, bronchitis, and other life-threatening illnesses. Affordable housing is essential. The proposed building stands in the way of much-needed affordable housing being provided for our community. Every year we lose affordable housing. And lastly, safety for all. We worry about the safety of residents, firefighters, and other emergency responders. How will the building do local law 11 work? What happens in a superstorm and other disasters? Thank you very much.
Thank you.
Thank you.
Next speaker. Could you sign in, please? I don't see your name on the list.
I'm Sheila Kendrick with Save Central Park, NYC. I have a prepared statement, but I heard a comment from the attorney for Extel that said, and this is consistent with the language that's been used, that once you look at the zoning resolution, you don't go digging deeper to find alternative interpretations in other outside sources. He used the term extraneous sources, but I just wanted to point out that the comment about 20 to 30 stories is in the executive summary of the Special Lincoln Square District. You don't have to go very far past page 1 to see that language. Now I'm going to get to my prepared statement. I'm responding to the abusive tactics being implemented by developers around the park. We can already see a wall of super tall towers across Central Park South and the resulting shadows. The impact is both obvious and detrimental. In the August 6 BSA hearing, as we've heard, it was stated that all things being equal, the decision will favor the developer. How can this be a result of the fair reading of the zoning code? There seemed to be an argument for not having a thorough understanding of the Special Lincoln Square District specifications and intent, even though the language clearly says, in not an extraneous way, that it would top out, construction would top out at no more than 30 stories. Did the developer, who singularly is redefining the New York skyline, not have the legal and zoning resources to understand every word of the underlying zoning when they have billions of dollars at stake? Is that reasonable? Is it reasonable to think that they did not understand that the bulk distribution and tower coverage rules are always applied together? Or is it more likely that they wanted to break into the neighborhood of the Upper West Side with a mid-block mega tower and they looked for a workaround in the law? Why did they create a rendering and submit plans that were compliant with the underlying zoning and the Special Lincoln Square District? Did they really not understand the depths of the zoning? Then we ask, since when is ignorance an excuse? We might recall a beautiful Art Deco building on Fifth Avenue that was destroyed under the cover of darkness by a developer who was intent on bending the rules to suit his needs, claiming ignorance. That resulted in Trump Tower. The letter and the intent of the special Lincoln Square district is clear. To let it be obliterated is to acknowledge that we are being trumped.
Next speaker,
Thank you.
please.
Thank you.
Thank you. Next speaker, please.
I'm Olive Freud, President of the Committee for Environmentally Sound Development. I want to go back to square one. How do the mechanics get out of the basement and into the middle of the buildings? A 35-story building should be 350 feet high. If it isn't the law, it's the tradition. That's how we determine height on the Upper West Side and in the city. You take the number of stories and you multiply by 10 and you get the height. So why and how is this building 775 feet high? Mechanics belong in the basement. They were free there. They didn't have to use, they're not counted against the square footage. But put them in the middle of the building, and what you're doing here is taking the freedom and putting them up in the middle of the building. Taking along their free status and adding voids, which makes it possible to put them into up high, you have obtained a very tall building with very luxurious apartments that increase the developer's profits. Never mind that the rest of the community has lost their sun, their sky, their space, and it has been taken from them, that they are subjected to long, dark shadows. Who has more right to space? The 135 residents in this building, or the thousands of the residents in the neighborhood? Since when are mechanics not in the basement? We are not in a low-lying area. That's when it started. After Superstorm Sandy, they allowed the low-lying area to put their mechanics up, but we're way up. There is no reason for this. There's no one has challenged it. They just let it go. The mindset that allows this to happen is like that of the greedy owners of coal mines in oil fields. That mindset is exhibited here. They're not harming anybody because there is no global warming. If that's what you say, there's no global warming, why can't you dig for coal? For developers of real estate, their maximum profit comes before any concern on damage they may do to existing populations. Our rules and regulations are here to protect those of us who live here now, not to enrich the wealthiest. There are numerous, and even more than this, it's more important. There are numerous new buildings that have gone up in our neighborhood that are built without voids and without questionable zoning lots. 200 Amsterdam Avenue.
Please
That are
wrap up.
profitable.
You exceeded your 3 minutes, please. We need
That
to.
are profitable and acceptable to these communities.
Thank you. Thank you.
I
Thank
think
you
it's
very
up to
much.
you folks to answer these questions and to stop this outrage.
Thank you very much. I just want to add, though, that in general, mechanical equipment has been located on the roof of buildings since the Empire State Building. That's where the water comes from. That's what powers the elevators, the air conditioning systems, and so on. And as we got towers, they started to be located in the middle because it became less expensive to manage sections of buildings. So they put, and if you look at lots and lots of towers that have been built over the last 40 years, there's a mechanical system in the middle of the buildings as well. It's just that they're not, 45 feet high. They're something
In our
like you.
neighborhood, which is 20 and 30 feet, mechanics
Okay.
are in the basement.
Okay.
Good afternoon. My name is Linda Sennett. I'm a supporter of Landmark West,
and the important work they do to ensure that New York is both a livable and prosperous city. I'm a 20-year resident of the neighborhood and live on West 66th Street. I'm protesting this development because it's a mid-block building that is huge, will completely overwhelm surrounding buildings, and is completely out of context with all its neighboring buildings. This obviously contradicts the stated, very clear goals of the Special Lincoln Square District, which in Article 8, Chapter 2, Section 82-00, General Purposes, says it is, quotes, to encourage a desirable urban design relationship of each building to its neighbors, end quotes. It's obvious from this model that this monster building is totally and distinctly different from any other building in the whole Special Lincoln Square District. Other words in the creation of the Special Lincoln Square District that are used to describe the anticipated development, they knew it would develop, the anticipated development include the words complement, consistent with, and enhance the aims and concept of the special district. This building does not enhance the neighborhood. It's neither consistent with the surrounding area, nor is it complementary to it. It is jarring and literally sticks up like a sore thumb. Surely you cannot completely disregard the clearly stated reason for creating certain building zone areas. If you allow this building, it's going to be the first domino. The whole of the Special Lincoln Square District will be overwhelmed with huge buildings. I'm not against development, on the contrary, but please ensure that the development of this area complements, is consistent with, and enhances this lively, diverse, and attractive neighborhood. As someone who moved to this city because of its wonderful mix of people and neighborhoods, of arts and commerce, I beg you to protect this unique area. Keep this special district as the city planners intended it. The Special Lincoln Square District is valued by people all over the state and city who come from all areas of the 5 boroughs, and in fact from all over the world, to enjoy the arts and its very special atmosphere. It's in your power to destroy that right now with this project. Please don't do that. I beg you, please protect the health, safety, and life quality of New Yorkers.
Thank you. Next speaker, please.
Good morning, Commissioners. My name is Robert Gottlieb, and I reside at 10 West 66th Street, approximately 40 feet from the proposed building. I appear in opposition to this project. The clear intent of the zoning regulations enacted by the City Plan Commission were to control the size and height of new development within the Special Lincoln Square District. It is obvious that the Extell building, as you see it, is completely out of context with the neighborhood. And I believe that all of you instinctively realize that this building, with its huge bulk and height, does not belong within the special district. I submit to you that the building department did not properly interpret the zoning resolutions regarding this building. Section 8234 measures the bulk of the building by the floor area which is permitted on the zoning lot, and the word zoning lot is used. The zoning lot created by Extell is 54,687 square feet. From this zoning lot, Extell created this huge building of 548,543 square feet, spread out over the entire lot. The tower coverage of the special district, 8236, provides the method for determining the size of the tower, how much of that tower actually can fit on the lot. The section says that the tower must occupy no more than 40 and not less than 30% of the zoning lot, the same language that is used in 8234. The zoning lot is 54,687 square feet. The zoning lot that is used to determine the size of the building. Based on this, the tower portion of the building should be computed as between 16,406 and 21,874 feet. Despite the very clear language in this section, the developer states the tower should be smaller. The footprint should be predicated only on the C4 section of the zoning lot, not the entire lot. Now we have a question of intent. Despite the unequivocal language that states that the tower must be measured by the size of the zoning lot, which is 54,000 square feet, the developer states it should not. It should be measured by a different criteria. Every statement of the City Plan Commission points to the conclusion that the tower and bulk regulations were intended to be applied over the same lot area. This word zoning lot has to be interpreted the same in each section in order for this to apply. We request that you follow the intent of the special Lincoln Square District, that the bulk and regulations be measured by the same lot area, and that accordingly, the building permit for this should be revoked. Thank you.
Thank you. Next speaker, please.
Hello, my name is Joan Cohn. I'm a member of Save Central Park NYC. My name is Joan Cohn. I'm a member of Save Central Park NYC and have owned an apartment at 10 West 66th Street for 25 years. I would just like to share an interview from globestreet.com on February 21st, 2018. They had interviewed John and Richard Calico of Gamma Real Estate after one of our partner organizations, the East River 50s Alliance, had great success in obstructing a 950-foot-tall, 87-story building that was planned for 3 Sutton Place with the help of their city council member, Ben Kalos. One of the executives of Gamma said that a different, and I quote, "A different developer did something very smart at a site we looked at on West 66th Street. The developer filed for a building that was this high. John motioned a short length, but once he had his plans ready, he amended the tower to make it that high. He then continued, and I quote, his belief and hope, and he's probably right, is that the community cannot muster the resources to stop him. But these are the kinds of tricks you have to do these days if you even hope to be successful," John Calico stated. We, as residents of New York City, depend on the BSA to do the right thing. I implore you to protect the health, the safety, and life quality of all New Yorkers. Thank you.
Thank you.
Next speaker.
This one is 150.
Hi, my name is Holly Rothkopf. I'm a resident of the Lincoln Square neighborhood, a board member of the West 64th through 67th Street Block Association, a board member of the Upper West Side Community Emergency Response Team, a supporter of Save Central Park, Landmark West, and City Club. I have a prepared statement, but just the discussion before where you mentioned, oh, it's only a few stories difference that you're talking about. You can just look at it and see it's not just a few stories.
No, but again, the focus is on, your focus, which I understand completely, is on this mechanical void, but ours is on the bulk packing rule. The mechanical voids were already decided and dealt with the city council and city planning, right?
Well, the actual zoning, the intent of the zoning, and the public's right to protection should take precedence over a whim of a developer. Nothing of the new proposed height is north of 60th Street nor mid-block in Manhattan. The language in the special district says that as a result of the rules, buildings in the district should be no more than 30 stories, or around 330 feet. As City Club and Landmark West have shown, I think it's absurd that the developer didn't know the tower coverage rule and bulk packaging rule are always applied together. The incorporation of so-called mechanical void space to circumvent the zoning code and incorporate needless no-count space is absurd. The Department of City Planning itself called the incorporation of mechanical voids of 239 feet, or 30% of the building, obscene. It's absurd to allow a developer to pull a bait and switch by submitting plans to the DOB for a building that they appear to have had no intention of executing, and then developing a tower 3 times the height. The relief the developer is looking for, or in this case, would want if the appeal is denied, is it's just not right. We urge you to deny the request by the developer to deny this appeal. Sorry, that's got jumbled. But protect the health, safety, and the quality of all New Yorkers.
Thank you.
Next speaker.
My name is Susan Simon, and I'm the founder of Central Park West Neighbors Association. I'm here today to fight for our community and all New York communities where developers with no real aim but to accumulate more and more money continue to exploit our neighborhoods. Extel came to the Lincoln Square community with a proposal to build a complex of an entirely different kind. They applied to the DLB for permits for a 25-story building. I'm quite sure they did so because it was within the regulations of the Lincoln Square District zoning law, which was an easy way for Extel to get their project off the ground with little friction, as it was within the law. But Extel's real intent was to build a nearly 800-foot tower and not be bound by the zoning law, but circumvent it. As if that were not enough, the developer has incorporated over 160 feet of empty space within this tower to prop up higher and more expensive views with a plan to build only a total of 127 apartments. Wow. I've wondered whether each apartment comes with its own four-car garage. But what's lost in this whole drama is while everyone seems to be reacting to some distracting part of the story, this working around the zoning law should not be thought of as normal. Not by this body or anyone else. What it is a manipulation of the law and a way not to follow it. This is high-stakes casino gambling with our communities. And when the developer takes the house, the community is left bereft, robbed of essential light, air, and human scale, robbed of sunlight in the magnificent Central Park, another assault on an entire ecosystem that would sit in shadow all the way to Bethesda Fountain. That's a price no one should be willing to pay. The zoning laws were enacted to protect our communities from all sorts of potential predations, yet routinely they are ignored or obfuscated. The mandate of this body is to assure that doesn't happen. The mandate of this body is to read the clear language of the zoning law and not to slice and dice it and quibble about what the meaning of is. I'm asking something really simple. I'm asking the BSA to do the job you were appointed to do. I'm asking you to consider that once upon a time, a Robert Moses tried to divide the village and Washington Square Park with a giant highway. And it was activists and neighborhood residents who fought and stopped one of the most powerful men in New York in his day from destroying the village. Just for a moment, imagine if they had not succeeded. We cannot allow greed to destroy the future of this great city. Thank you.
Next speaker. Next speaker, please. Oh, thank you very much.
Hi, I'm Sue Mellons. I live at 22 West 66th Street, in the building that is right next to the proposed building. We have, from the beginning, we were told that it was going to be 25 stories, and I just want to point out the deceit of the developer in telling us this. There was no transparency during this time. That was what we were told, and we accepted it. And then it turned out that they were going to do this 75-story building. I can only say that the possibility of a really dark city in the future, if these buildings are allowed to go up above the height that's in the zoning law, it just, the darkness in the city is unimaginable to me. And I think of these buildings as not as skyscrapers, but really as sky rapers. And I also think about the health of the people in the community. I'm speaking for the people in the community. We have precious little power at the moment, so they think. But we are a voice, and I am begging you to consider this voice very seriously, that we are all opposed, most of us are opposed to this type of structure coming in, destroying the whole character of the neighborhood, the whole community, the whole feeling. Moreover, these buildings, when they go up, are not inhabited very often by residents of the city because they're so expensive that people can't afford to live in them. So they are inhabited by people who come from other parts of the world and live in them for maybe a week or a few days of the year. What benefit is this to the city? They don't pay taxes. What benefit can it be to the city to have such buildings there? We need buildings that people can live in. The city needs more housing, but we need things that are consistent with the neighborhood and not these things that stick up out of there, which is sort of, to me, just an example of sheer hubris. And it's almost a dare, knock us over. I just, not for me to knock over, but for somebody which has happened in the past, as we know. But I just beg you to consider the needs of our community and other communities in the residential area around the city. The residential areas don't deserve buildings like this. Thank you.
Thank you. Next speaker.
My name is John Day. I support Central Park NYC and also a member of Landmark West and City Club. My wife and I are neighbors of the disputed 50 West 66th Street project. For 21 years, we've loved living in the special Lincoln Square district. We support both of the appeals before you. They contest the merged zoning lots and the absurd, massive mechanical void loopholes for the planned mid-block 775-foot building, 3 times taller than any others in the area. I'm in Central Park every day. This building will cast shadows as far as Bethesda Fountain, across the park, and across our neighborhoods. But really, my primary concern is safety. Please record this Uniform Firefighters Association of Greater New York memorandum. The firefighters' statement, quote, strongly opposes construction methods that are inherently dangerous and for no valid reason increase the threat to the lives of the public and our members. Today is the eve of 9/11. Can we forget the firefighters' lives lost then or their continuing heroism? I was 3 blocks away on the street when I heard and felt the sonic boom, saw the first and second towers hit, and neighboring buildings destroyed when they fell. Our brave public servants' warnings merit your most serious consideration. Enormous vertical voids, like the ones planned, are far greater than in any other New York building, and I believe unknown globally. They are untested and potentially deadly.
During Superstorm Sandy, friends of ours were ripped from their homes in a 3-block radius of 153 West 57th Street when the multi-ton crane atop that project blew over, risking the area's destruction. That crane, if it had fallen, would have hit a major gas main. The developer and contractor on that project are the same as on 50 West 66th Street. Okay? Do you feel our fear? Do you understand why we're concerned? The project architects on this appear creative, they're well regarded, they even designed the 9/11 museum. Yet their website indicates they've not completed a building of this height, nor do we know of any architect who incorporates voids this high or with this potential risk. Yes, we are afraid for our and our community's safety. In your own words, the BSA stated that it should consider, quote, the health, safety, and life quality of all New Yorkers, end quote. We implore you to do that now.
Thank you.
Thank you.
Next speaker. Next speaker.
And this is the statement.
Thank you. Thank you. Hello, my name is Beth Linke. As a new New York resident, my husband and I carefully considered the myriad of locations to live in this vast city. It was obvious that Lincoln Square and the Upper West Side were a perfect fit for our family. I would like to refer to a letter written by Gail Brewer, Corey Johnson, and the entire delegation of the City Council dated August 16th of last year. In it, they speak of the integrity of the zoning resolution, and I quote, "All across our borough, developers have found numerous novel workarounds to circumvent the limitations that we commonly misunderstood to apply them under zoning. The zoning resolution is meant to provide consistency and predictability for both the developers and residents. But again, we have seen buildings constructed that defy our expectations and long-held beliefs of what the rules are," end quote. Usually appeals come to the BSA because clarity is needed where parties differ as to interpretation. But the case of the mid-block tower, now slated as 775 feet on West 66, is very different. This building sits in the special Lincoln Square district, where the building height regulations are clearly defined and then clarified. It specifies that when the rules are followed, the buildings would not exceed 25 to 30 stories for a maximum of 130 feet. The rules that result in the buildings of 30 stories or less are concurrent use of the tower coverage rule and the bulk package rule. I believe Extel knew the rules when they submitted the 25-story plan. The original contextual building plans were consistent with the special Lincoln Square District rule usage and seemed reasonable given the block placement. City Council member Helen Rosenthal called out the developer when they changed their plans to the massive tower that is 3 times the original height and even called it bait and switch. Diversity, the arts, the architecture, and just the right amount of noise and traffic made it easy to fall in love with the Lincoln Center area and the Upper West Side. We never doubted that New York City would make sure our area remained neighborly and that buildings would be consistent. Because developers are being allowed to move around zoning regulations, much of which we took for granted is being compromised. A perfect example is the effect on Central Park. The massive tower in its present form, has been talked about in multiple times, is expected to cast afternoon shadows across Central Park up to the Bethesda Fountain, right in the heart of our park. The novel workarounds might be inconsequential in some cases. My family and our neighbors believe that in the case of the massive tower on West 66th Street, circumventing the limitations will have devastating and forever lasting impact on our life quality as residents of New York City. Board of Standards and Appeals, please be the relief valve, as we heard today, and protect the health, safety, and life quality of all New Yorkers.
Thank you.
Next speaker.
My name is Mary Kresge. I support the appeals by Landmark West and the city.
Speak louder and direct to the mic.
Thank you. And the city council. and support zoning resolutions designed to enhance sound and careful development. I'm also a native New Yorker and over a 45-year resident of Lincoln Square area. Today, I want to step back a moment and look at how the BSA approaches its decision-making. What goals, what principles does it use as a guideline? What should it consider when making rulings regarding questions such as, is the language clear? Is the application now proposed in accord with the language? This is particularly difficult when an expert such as George Danes challenges the views of others, as some have said today.
Sorry, speak up.
Sorry. Okay, sorry. Another question. If the application involves a zoning district that was created because of a unique situation, should the reasons for that and other background information be included in the deliberations? I do not minimize the challenge such questions and others pose. It's extremely difficult to draft language that will, over the life of the law or resolution, ensure that the implementation will continue to be in accord with the purpose. Thus, it is essential, it seems to me, that the BSA look to what it has said are its goals, purpose, and what, in making a decision, it should consider. To determine this, I quote from a statement from the BSA itself. Please be patient. The New York City zoning resolution, building and fire codes, the New York State multiple dwelling and general city laws were enacted to protect the health, safety, and life quality of all New Yorkers. Continuing the quote, consequently, BSA's authority to vary these regulations must always be tempered by the agency's consideration of the impacts that the insertion of a building modified by such waivers will have on the urban fabric surrounding neighborhoods and neighbors, as well as on the greater vision of our city that has been conceived of by its urban planners, architects, and engineers, and codified in these regulations. The specific appeals now before the BSA involve the use of loopholes relating to combining zoning lots and mechanical space, which, if allowed, would result in an over 750-foot mid-block building. In considering these appeals, it seems to me incumbent on the BSA to consider their, quote, impacts, close quote, this would have, as it has stated, on the urban fabric surrounding neighborhoods and neighbors, as well as on the greater vision of our city that has been conceived of by its urban planners, architects, and engineers, and codified in these resolutions. The fundamental question then, it seems to me, is what will best help, quote, to protect the health, safety, and life quality of all New Yorkers? Thank you.
Thank you.
Next speaker.
Thank you, Madam Chair. I'm Howard Euro. I wish to offer a different vision of the proceedings. And in my vision, the BSA is relieved of the onerous task, such as it is suffering through this morning. Because in my vision, the City Council of New York takes global leadership and passes a moratorium on monster towers. The rationale being, as I said last month, that in the global climate crisis, which we all appreciate we are fully in at this time, there is no longer room for the building of such buildings. They are not sustainable in any way, shape, or form, and their spread within our city and around the world is a recipe for disaster. So I'm calling on the City Council of New York to pass a moratorium and to this effect, and to relieve the BSA of the onerous tasks such as is exampled by this morning's proceedings. Thank you.
Thank you.
Hello, my name is Arlene Fauser. I live on West 67th Street. I belong to Landmark West, the Block Association. I'm here as a neighbor who is extremely concerned about what's going on now and in the future. What your decision could mean is a death sentence to our Upper West Side neighborhood, population in the thousands. I recently read a book by a gentleman named Byron Stevenson who talked a lot about the prisoners on death sentence, and mostly in the South, where timelines and statutes of limitations and 30 days were completely ignored over the incredible logic and the obviousness of what was going wrong. You have the authority to not render a death sentence to this neighborhood, to not undo the purpose of Lincoln Square's zoning intent. What will happen in the future, river to park, in the 60s, 70s, 80s, 90s, and upward? There are also at least 4 public schools in the immediate area. The decision you are tasked with could affect the future of well over 50 city blocks, thousands of school children, and committed Manhattan residents of long standing. This decision will be impacting the probable team that is now working, experts now preparing the plans for West 66, West 67th, and Columbus Avenue, now known as the ABC campus. Our beautiful Upper West Side residential and landmark streets are about to be turned into the greed of the extremely wealthy real estate developers. BSA, your mission is to protect our health and safety and the life quality of all New Yorkers. Thank you.
Thank you.
Next speaker. Next speaker, please.
Next speaker, please.
Thank you. Is there any more after this lady? Any more speakers? Okay, thank you.
Hi, my name's Eileen Vasquez. I'm the president of the West 69th Street Block Association. I want to start off with 2 things. It's very disgraceful and disappointing that we all have to come here and fundraise and stay up all night and do turnout and all these other things to plead with you guys to enforce the laws that are supposed to protect us. It's ridiculous that we have to do this. I haven't slept out all night. I don't know what condition Chris is in. I'm exhausted just trying to get people here and trying to get this to fall on your ears. Secondly, regarding mechanicals, though I know the new law is passed, no matter what side of the argument we are on about mechanicals, it's 2019, not 1819. We all know that mechanicals are slimmer, they're more efficient, they're smaller. Nobody in New York needs that much mechanical space for mechanicals.
Please. Thank you.
I want to say, as my block approaches its 50th anniversary, I'm reminded with great pride the courageous advocacy, beginning in 1969 and continuing till today, of my block association. For over 5 decades, we have stood together to support our block and our neighbors. Today, we are here to continue supporting our neighbors in their struggle regarding this building. I'm reminded of the rules regarding this meeting, and rules are funny things. There seems to be rules when rules apply. So certain rules have rules. Some rules can be broken, but some can't be. Some rules only apply to some people. Some rules are considered more important than other rules. All of this reminds me of a conversation I had with my son many years ago. We were discussing the consequences of broken rules. Truthfully, I cannot even remember the details, but I do remember clearly my son turning to me with an earnest face that only a 6-year-old can have and saying, "There are rules for a reason, Mommy." The reason for the rules we are discussing here are to protect New York City residents, protect the architectural integrity of the neighborhood, to not overload our already heavily burdened infrastructure. As I live on the street where a $100 million home featured in the New York Times recently is being built, I can tell you what the consequences of rule breaking are. A street filled with dirt and dust, construction material and machinery beyond permitted areas, construction debris beyond permitted areas, up to 17 cars stopped at once to make room for their equipment to move, noise of power tools on weekends, damage to parked cars, damage to trees. Within the rules, we suffer daily, all of the above, but in addition to pneumatic drilling that takes a subterranean route up to 200 feet from the
Please
site.
wrap up, your 3 minutes is up, okay? Thank you. Please wrap up quickly.
Workers urinating on the street, up to 4 concrete trucks a day, a team meeting of 30 workers outside of our windows at 7 a.m. The list goes on and on. The point remains, there are rules for a reason and they apply to all.
Thank you.
Thank you very much.
Hi, I'm Carol Gaston. I live at 10 West 66th Street. And quite frankly, I am sorry to say that I've not been more involved in all of this. It really, when I see this model here today, you know, I know it's going to affect me living at 10 West 66th, but I now see how it's going to affect everyone here. So I'm going to take another close-up photograph of this, send it to 100 of my best friends on the Upper West Side, and I would suggest that you all do the same, because this is enough. Everything. Well, you all have some.
Please address us.
Anyway.
Please address us.
This tells a story right here. Talk about bulk and some of the other things that you're addressing here today. You are destroying our neighborhood. So I'm going to take one more picture, a close-up, and make sure that everybody I know sees this model, which doesn't show one tower by itself, but shows the effect on all the other buildings in the surrounding area. And I thank you all for being here. Thanks.
Are there any other speakers on this? Any other speakers, members of the public on this?
Okay, the appellants, please come forward.
And while they're assembling here, one of the speakers brought up the subject of legislation that I wasn't aware of, which was introduced in February, was introduced in February to the state legislature. I think it was introduced by the Assembly, and then it was brought to the Senate, State Senate. It's an amendment introduced in February, and it seems to have been introduced to the Senate in May, which is an amendment to the multiple dwelling law, and council member Councilmember
Councilmember Helen Rosenthal.
No, the other one.
Linda Rosenthal.
Linda Rosenthal. See, that's a problem. We have too many Rosenthals, so it's a little confusing. Anyway, so the council member said that she was not able to amend the zoning resolution the way they had in mind for the mechanical voids, because city planning didn't introduce whatever it was they preferred to see introduced. But the multiple dwelling law, which is a very powerful state law that affects all multiple dwellings, which includes hotels, is proposed to be amended. And for those of you who don't know about it, and you should be active in that subject, it's proposed to be amended to talk about the maximum height of a floor. Whether or not this will go ahead, who knows, but you should be aware that the state legislature is working on that subject with state law if the city council is unable to accomplish this with local New York City law. Okay? Okay. Did you want to add anything? And I actually think that Commissioner Shanda has been doing some research while we talk about the character of the neighborhood and so on.
I think keeping in mind what the intent of the proposed text was, I was looking at various buildings that has been built in this area within the Special Lincoln Square District and outside the Special Lincoln Square District, but are in Zone C47. And I was just trying to do a comparison, a quick comparison, and I know I didn't, I'm not getting into the details of the zoning for each one of those sites. When looking at this information, those developments that were built prior to the adoption of the 1994 zoning text, which is what we are contesting today, sections of it, that is. For example, the One Lincoln Square Plaza that was built in 1970, rose to, had 42 stories, and it's built on a 59,000 square foot of lot area. A similar comparable lot area that is one block to the south of it is 15 Central Park West, which has a similar lot area, but the number of stories on that one is 37, and that was built in 2005. That goes to show that the text that was proposed did have an effect in terms of the comparable lot areas, but you're resulting in a shorter building. So the text did apply.
I'm sorry, that was built in, and how many stories was it?
37 stories, built in 2005. And if I were to compare that to what the applicant is proposing, keeping the mechanical void out of the question. It's not before us, I'm
Ladies and
sorry.
gentlemen.
I'm sorry, it's not, we have dealt with that in a previous action. This proposed project, similar lot area as, actually lesser, similar lot area as Central Park, would also result in 35-story building. So, you know, I'm just looking at the various numbers. Again, another one, 1992, in 1992, actually, 1995, 144 Columbus Avenue. That had a lot smaller lot area, but it had a 30-story building. It was an 18,000 square foot of lot area, but had a 30-story building.
Please, sir, you'll be removed if you do that, okay?
So,
please.
I'm just kind of laying out the various numbers for me to help understand what the intent of the text was and whether the text did work. And when I'm looking at these various developments that have been built prior to the enactment of the text and after that, and during the comparison, I feel that the text has been effective. And I just wanted to state that, that's all.
And again, we need to repeat again and again for the public, the question of mechanical voids is not before us today. We decided that on another case, and city planning reacted by changing the zoning resolution. And so we don't look at those cases twice. It's called an issue preclusion. We don't look at cases twice when the same question is presented in another case. So we're only looking at what's known as bulk packing, bulk distribution rule, which is what Commissioner Shanda is referring to right now. Okay?
Okay, I just very briefly, you know, you've said several times that your hands are tied and you interpret the zoning resolution as written. And, you know, I only bring it up because it's the one case that I'm particularly familiar with. But, you know, in the Peyton case, the language of the zoning resolution said that the open space on a zoning lot has to be accessible to and usable by all residents. You found
We can't speak about that case, it's in litigation.
The
so
city
you can't-
has a strict policy against discussing pending litigation.
Against what?
Discussing pending litigation.
That case is in litigation with the
Well, I
BSA,
know.
so we cannot discuss it. So you can raise it, but we can't comment.
Well, okay, I'll just,
Okay.
I don't expect you to comment. I'd just like to say that you found an ambiguity there, whereas subsequently, you know, at least the appellate division said there wasn't one. So, you know, I would, and of course, as the attorney for the petitioners in that case, I also believe there was no ambiguity. So, you know, I would question whether it's always the case that you know, I mean, I believe this was done in good faith, but somebody looked at what was happening there, and I know you were the only one who's still, well, Commissioner Otley Brown, but she's not on this case. So, in any event, I'm sure that was all done in good faith, and you did find an ambiguity, and you did not follow the plain language of the statute, and I'm sorry to bring it up if you can't respond to it. I wasn't aware of that, but anyway. Let me also say that in Stringfellows, it's true, as Mr. Karnofsky said, that the court said that the intent of the statute is to be ascertained from the words and language used in the statute, and if the language thereof is unambiguous and the words plain and clear, there is no occasion to resort to other means of interpretation. However, a sentence or two later, the court said, however, a court in construing a law will sometimes be guided more by its purpose than its phraseology. And in fact, in that case, I submit that they were. I think that's all I have to say about this. I'm sorry about this rabbit hole of 1865 Broadway, but as I was saying, I think that if you look at the real tower coverage in that case, it was less than 30%. It was 28.9%, and that building is also taller than it legally should be because of a loophole that was exploited. Thank you very much for your consideration. And, one other thing. I have no objection whatsoever if you decide to sever the City Club case from the Landmark West case, but I do urge you to decide our case as quickly as you can. Thank you.
Okay, thank you.
Good afternoon. Again, Stuart Klein on behalf of Landmarks West. Two questions have been raised by you in the course of today's proceedings, or two arguments rather. One is the timing of our appeal, and the second is the substance of our appeal, and whether or not you have the jurisdictional right or obligation to review that. To tell you the truth, I'm reminded of a quote from a Court of Appeals case you previously cited to, and the question posed to the board then, and I pose to the board now, is what are you talking about? This was filed in a timely fashion. This was filed within the 30 days pursuant to a final determination made by the Buildings Department, which was further defined by a permit. That is a final determination made that is appealable to the Board of Standards and Appeals. In our application, we specifically said the owner's attempt to exempt the voids from floor area should be rejected, as the voids are neither used for mechanical equipment nor are they accessory to the residential uses in the tower. No mention of height is made in there. You're basically conflating void with heights. We couldn't even address whether or not a void was involved because the plans don't show the height of the mechanical space. So that was hidden from us. It's been hidden from the Buildings Department. It's been hidden from this board.
Where is that? I'm sorry. What page is that on?
That's their initial
That's the
submission.
initial 5/13/19.
Okay.
So it is a core issue, and core issues must be addressed by this board. I'm not talking about the myriad of outlier issues that come before you in something of a staccato fashion over time. This was presented to you in our first application, and it's clear on the language. There is no ambiguity here. Just like you're arguing there's no ambiguity with regard to the bulk resolution, there is no ambiguity here. We argued that this mechanical space was improper and an improper deduction. So therefore, it is before the board. Now, the Buildings Department did, as a matter of fact, in the Sky House case, say that it was able to approve those mechanical drawings because, as proposed, especially in light of composite mechanical plans for the proposed building illustrating the mechanical proposed for the second, third, and fourth stories, it's found that it conformed to code. Here,
What are you reading?
I'm reading from page 4 of 2016-4327A resolution.
The resolution on that case.
That's correct. So the Buildings Department said it had complete plans in that case. It also said, during the context of that case, that it reviewed each and every mechanical plan to determine whether it conforms to the code and whether or not, in this instance, the 5% could be reduced. Here, we're talking about a lot more than 5%.
I mean, it's off the board percentage-wise. So then the building department now comes to you today, and it says, well, we didn't review plans. The plans aren't here. In fact, the fire department has plans that I made up that indicate that not a single item that's required in code was contained in those plans, yet the buildings department passed them anyway. And now the buildings department is saying to you, well, if they do apply again, based on the illicitly, or the argued illicitly issued permit, we will not issue a final determination. That is a perversion of law and the judicial process. It in effect is saying that we're not giving you, the board, the power to review, and we're not giving the people in the neighborhood or Landmarks West the ability to appeal because we're never giving you a final determination to take to court. So basically, they didn't follow their protocol as set forth in the Sky House. They didn't follow the building code. They didn't follow the in-house protocol established by Tom Farriello. And on top of that, they're saying, ha, we're tying your hands, you can't do anything beyond this. Now, in order to do that, the Court of Appeals in the Field case said that if an agency breaks from long-established protocol, it has to give a reason why it's doing that.
Can you give us a citation? What's the Field case?
Field case, I'll give you the site later.
Okay.
There's a Court of Appeals case that says if a governmental agency breaks from protocol, it has to give a good reason determination why it broke from protocol. None was given here. So right now, the building department didn't look at these plans, and if it did look at these plans and didn't see anything, because nothing was contained in it, those plans violated the building code, violated building standards, violated buildings protocol, and now they're backing up by saying, and oh, by the way, we're not going to give you the right to appeal. I think it's incumbent upon you to demand the buildings department receive those plans so we can determine whether or not the mechanical deductions, not the height, that the mechanical deductions were in fact properly taken off and this permit is valid. Thank you.
We hear you. Okay, thank you. Mr. Karnowski?
Just two quick points. Stringfellow speaks for itself. That case involved the question of what the term customarily should be understood to mean, and the point is the court looked at it in the context of the zoning resolution and made its decision based on its understanding of the zoning resolution in context. Here, understanding the special district rules in context leads inexorably to the conclusion that 8234 means what it says. With respect to Mr. Klein's arguments, the point again is whether or not these issues were raised on appeal. The question is whether or not the issue was raised on appeal. It was not, and it should not be heard.
Thank you. Okay. Okay. Any additional comments from board members? Okay, what I would like to do is close this hearing, close both of these hearings, and we will put this on for decision for next week, this September 17th, during which time we will look more clearly into this question of whether the mechanical question should be considered by us or whether it is precluded.
Should we close it?
Sorry?
Do you want me to give you the field case?
No, we have it.
We have it, okay, okay. And so we don't need additional submissions because we don't know whether that's something that we're going to be reviewing. We have to see whether it is properly before us or not, okay? Okay, so, so a motion to close?
Chair Promoter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown is abstaining. Commissioner Commissioner Shetta?
Aye.
Commissioner Shabbat?
Aye.
Okay, so the hearing is closed, no further submissions, and we'll make our decision next Tuesday. Okay, and you can hear us comment on next Monday in review session.
Okay, thank you everyone for coming.
Yeah, we need
You want to do lunch or break?
Should we do lunch? You want to?
Go. Okay, good afternoon, ladies and gentlemen. This is the Board of Standards and Appeals public hearing for September 10, 2019. We'll continue with the special order calendar. Item number 5, 539-66BZ, 6119 Fresh Meadow Lanes, Queens. You coming up? Okay, raise your right hand. Oh, there she is. Elise. Okay, raise your right hands. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to board member questions? Okay, sign it and get going.
Good afternoon. Elise Fullader from Eric Palatnik PC. I have with me Andrew Villari from Stonefield to answer the one question you had about the widening of the curb cuts.
Great.
And he is here to answer that question.
State your name for the record.
For the record, Andrew Valeri, Stonefield Engineering, on behalf of the applicant.
All right, Andrew, you need to pull up the mic.
For the record, Andrew Valeri.
Speak into it, Andrew.
Andrew Valeri, Stonefield Engineering and Design, on behalf of the applicant. These are the handouts. We attended the review session yesterday. We listened to the concern, the comment that you had or question.
It was just a clarification.
Just a clarification. So yes, one of the driveways that we're proposing on 64th Avenue has been widened from 30 feet to 40 feet. And the reason for that is to better facilitate the fuel truck delivery. What Elise is passing out right now is an exhibit that shows the vehicle path through the site. And you'll see that it needs 40 feet of width to access 64th Avenue efficiently and safely. We took it one step further by also getting the input of the DOT on this specific matter because it is an oversized curb cut. We reached out to Matt Lorenz, who is the Director of Traffic Engineering and Planning, Traffic Engineering Review, on July 10th to get his buy-in on the 40-foot wide curb cut. And in the email, you'll see that preliminarily it is addressed, or it is approved to move forward.
Okay.
That's a DOT email, that's what that is?
Yep, DOT email from the authority on driveway widths.
So,
We
but
got
the
their buy-in.
DOT sign-off letter that we got was based on a drawing that included that width,
Correct,
right?
correct.
Okay, thank you. Any other comments, questions from the board? Okay, then I'd like to make, are there any speakers on this one? I'd like to make a motion to close then.
Chair Perlmutter?
Aye.
Vice Chair Chanda? Aye. You're so bad. Commissioner Otley Brown? Aye. Commissioner Sheta?
Aye.
Commissioner
Please.
Shabeta?
Aye.
And a motion to grant, and I don't see conditions on of anything. Did anybody have conditions that should be? Okay. Motion to grant.
Chair Perlmutter?
Oh, right, I'm
One,
sorry,
two.
DOT conditions, sorry, yeah, that's ridiculous. So the DOT had conditional sign-off, right? And it says the applicant will be responsible for all capital improvements, including the closure of the two existing curb cuts along the south side of 64th Avenue, and reconstructing all sidewalks along the site frontage with full curb height, i.e. 7 inches. The applicant will submit all of the required drawings as per AASHTO and New York City DOT specifications and requirements for DOT review and approval, and DOT will participate in the review process relating to all future modifications to geometric alignment, curb cuts, et cetera, et cetera. So that's in their conditional approval, so that should be included in our resolution. Okay. So on that, a motion to grant. Thank
Chair
you,
Perlmutter?
Chief. Aye.
Vice Chair Chanda? Aye. Commissioner Otley Brown? Aye. Commissioner Sheta?
Aye.
Commissioner Shabeta?
Aye.
Great.
What time is it?
Item number 6, 13088BZ, 3602 Snyder Avenue, Brooklyn.
I think we had additional submissions on this one.
Do you, raise your right hand, do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board to respond honestly to board member questions?
Elise Fullader from Eric Palatnik PC on behalf of the applicant. Did you get my submission from last evening?
Yeah, we have it somewhere.
I can go through all of the
Yes,
changes
please.
with you. So, but I didn't print that out for everyone because I assumed they got it and I didn't want to.
Yeah, we did receive it.
138.
So let me know when it's open and I'll.
Yeah.
We're good?
You can talk
Okay.
and I'll
On
find it.
Z001, the site plans, the plans have revised to propose 6-inch pipe bollards in front of the landscaping. They felt that this was easier than wheel stops because of where the underground fuel tanks are. It would be easier to have the truck that comes to deliver, and the bollards would also protect the planting, just like a wheel stop. On drawing Z001, the site plan, the plans have been revised to show that there are 16 parking spaces now.
Thank you.
The zoning analysis form has also been updated to have the 16 parking spaces. On Z005, the lumen spread diagram, the plans have been revised to provide zero light along the property boundary, as there is a single area fixture with a light shield on it. And also, as you pointed out yesterday, it is next to a grave site. On Z007, the landscaping plan, the plans have been revised to remove former note number 4, which you asked to be removed. On drawing Z007, the landscaping plan, the plans have been revised to provide the types of plants provided in the front along Brooklyn Avenue. And then I also provided, as part of the submission, photographs of the plantings under the ID sign, so you could see it. And signage was not separated by frontage because it's a 73-11, so you're allowed 150 square feet of signage, which this site complies with.
Okay, great, thank you. Everybody okay with the various changes? Thank you so much for submitting them yesterday. It's really good. Okay. Anybody, any speakers on this? Okay. So again, all right. So I'd like to make a motion to close.
Chair Promoter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
Aye.
And a motion to grant on our kind of our standard conditions that the landscaping, paving, fencing be maintained in good condition, that any graffiti be removed from the building immediately, that the site be, well, graffiti-free and debris-free, kept that way, and anything, the lighting be directed away from adjacent property. And I think that would be it, right? Anything that I left off? Okay. All right, so on that, a motion to grant.
Chair Promoter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
Aye.
Thank you so much.
Application has been granted. Give me 1 second. Shoot. Item number 7, 19497BZ, 84-12, 164th Street, Queens. Sorry. Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, and to respond to the board member questions? Go. Thank you.
Nothing submitted on that. This wasn't submitted though, right?
Good afternoon, Pam Baton from Shell Nobel PC for the applicant. I just passed around some proposed plans that have not been submitted yet. The landscaping, the proposed plans on the second page. We attended yesterday's review session. I'm going to go through the order in which comments were made yesterday. The first comments regarding the dumpster, about pulling it back in. I spoke to the client, and the client has actually gone forward with enclosing the dumpster already. And I have photographs which will be submitted on the records when we do our final, hopefully final photographs of the site. So it was already enclosed. If it was pulled in a little bit closer, there are service bays as shown on the site plan. So we'd like it to keep where it is now.
Did you give us those?
No, I'm just, it's going to be in the final submission, but they sent this to us yesterday.
But isn't this, is there, what's adjacent to us on this side?
It's the house.
So,
Well, I mean, there's greenery over here.
so that you put the dumpster next to a resident within 50 feet of the street line, so it's everywhere it shouldn't be, right?
On the other side as well, there's also.
No, but, I mean, for instance, it could be closer to the garage. It could be closer to this, to the other street line away from the residence. It could, there's any number of other, right?
Hold on.
There's,
It's next to another manufacturing or
It's a
commercial use on 164th Street. So
This?
the site, the dumpster is proposed here.
So it's next to
Not
commercial use,
next
it's
to
not a
commercial.
house?
It's
not
on
next
the
to- the house
frontage
is
of
on the other side.
164th. It's on the
Correct.
frontage of 164th,
Correct.
not on 84th.
Okay.
So,
There's an open area, and then there was the building next to
may I
it.
please see the photo again?
Sorry.
I think when I did do the site visit, I did see it, and I'm trying to place it. Yeah, so that is, that is this business, that's that business there.
And if you look
That
back
doesn't look like a home.
No, and these homes are,
here is the site, and here's the.
yeah, it says 84th Avenue. That's the 84th Avenue intersection here, so.
What kind of commercial practice is that, do you know?
Okay. Sorry.
Okay.
And it was on the last plan set at that same location, and was just requested to be closed
Yeah.
at that time.
No, it's on the
And
house.
closed at that time.
Okay. Is everybody okay with it in that location then? 'Cause-
Yes.
Okay.
Thank you.
Okay.
As for the photographs, I apologize if there was a miscommunication, because we had been talking about the rear of the building, and the previous photographs show the site, but we'll provide additional photographs, but I know that there had been concern regarding the plantings in the rear, which is why we took the photos of the rears and to show those existing oil tanks. But, if we could get through this hearing and get to a vote next time, we'll be showing proof of the installation of the landscaping, which will show all sides. But as noted on the plans as well and through the photos, there is a wall, and we go exactly to the lot line on 164th on that frontage.
You need to speak up, the
Sorry.
mic is really not
Sorry.
picking you up.
So we'll provide more photographs, and we apologize for any confusion with that. All right, so for the landscaping plan, it is louder now. What's proposed is what was almost previously approved on the last approval years ago. The applicant understands about adding dense shrubbery. Unfortunately, I think on the frontage of 84th Road, they meant to put in the planting originally, and you could see that through the pictures, there are trees that were previously planted. I think it was just it was spaced out, not according to the plans previously approved. So the applicant proposes to fill in those missing portions on 84th Road and add numerous shrubbery to the rear as a minimum of 4 feet in height as requested by the board, which is noted in those proposed landscaping plans. There will also be the chain link fence, which is there now, but with the fence slats, that note has been corrected in that plan set that was just shown in front of you now. So either way, there's still going to be some sort of buffer in the rear.
So the landscaping plan does not show the thing that needs to be buffered the most buffered, which is the oil tanks.
I mean, there's still, there's the whole fence, which it goes straight up, that's going to have the hedges as well. You're still not going to see them.
Why isn't it buffered in front of the oil tanks? It's not something that you drive to, it's just, these are storage places, or, I mean.
They're located directly behind the building.
I know, but so why aren't they being shielded? I don't understand.
Because you still need an access point in order to get them, so.
Why can't you locate the shrubs closer to the fence instead of right up against the oil tanks? I don't really get it. You've got 4 feet between the tank and the fence.
I mean, I raised this with the architect and the applicant, and they still would need to access the oil tank. So instead of trampling over the plants, you still have in the rear, and you have the fencing that completely shields it. That chain link fence, which is going to be 6 feet high, has it's going to have the slats in it. So you won't be able to see those oil tanks.
Can I make a suggestion, Chair? Is have more like vine-like growth in that, along with the slats?
Okay, I could propose.
Something like that. Because what's happening is the thing that's the biggest eyesore, and whenever people say you can't see something, the fences are only 6 feet high. You can see unless the shrubbery is dense, right? So there's a house here that's 2 stories. So they look right into that.
I mean, from the pictures that were previously submitted in our last submission, the oil tanks don't even, other than this little portion right here, they don't go over the fence.
They don't, they're not higher than the fence, but you can see them. If you're in the house next door, you can look right into the oil tanks from there. Why not conceal them? I mean, that's the part I'm kind of not getting. The places where there's shrubbery are the places that are least offensive. The places where there's no shrubbery is offensive.
I mean, wouldn't this sort of be similar to any other mechanical that's near like a house? I think it will be buffered by having the fence. I could see if they could put like a skinnier tree, I don't know, to just so they could still have access to, I don't know, fill up or remove instead of trampling over a tree that's right in front.
I have a question. I'm looking at the plan that was submitted last night. It says there would be a 6-foot solid white PVC fence where the oil tank is.
Those were the old plans.
Those are the old.
So the ones in front of you, which have not been submitted yet.
Oh.
They realized, the architect had put it on, the owner of the site didn't realize that they were on the plans. We were on the phone yesterday discussing the comments regarding the buffer, and he's like, you can't access it wouldn't be enough room to access the oil.
I don't know, what are they doing? Is it they're pulling a hose? What is it, what kind of, I don't know what kind of access it is that you need for these tanks. Is it a hose that comes from a truck that comes across? Because you obviously don't drive into that back area. So, and you're not dealing with a door swing anymore if they're not going to make that enclosure. So I'm still having trouble with this. Why can't there be planting up against the fence in that area that allows for some clearance for physical access? And yeah, I mean, a vine might be a way of addressing it so it's not as big of a plant, as wide of a plant. But the idea of not concealing the main thing that should be concealed, I don't get. Especially when you're right next door to a residence. And if anything, these are fuel tanks, right? So fuel tanks give off vapors, and that's why we use plants. So
are we suggesting vines, or if I could find out if there's a
please don't speak.
A skinnier tree, like that could fit in, so there's enough clearance.
Something, right.
Could do both.
There's a solution there. They should find one.
Okay. All right, so that could be revised, the applicant's looking to plant within October.
Yes.
So and just other notes which were raised at previous hearings, the resurfacing is actually planned for this week. And the installation of the slabs is also planned for this week.
The installation of the what?
Of the slabs into the chain link fence is also proposed for this week. So I think we could install the landscaping in October, so hopefully for a vote in November or...
Okay. So I would say personally, make sure that the landscaping is installed to include something that conceals with landscaping those tanks. Don't come back with a photograph that shows nothing in front of the tanks. Okay? No, let's say, when I say nothing, no landscaping in front of the tanks.
Oh, and just one more comment, there are no sales.
No sales?
No sales. And I think a previous grant, not the last one, but the one before that, the original variance grant, was for auto sales, but there are no sales, and there haven't been for some time. It's just a service station.
Okay. Are there any speakers on this? Okay. So let's see. So if you're going to do the planting in October, which makes sense, then we could be here in November. Does that sound right? Or beginning, or first week of December? Yeah, that's good.
So November 26th, and it's 3 weeks versus, is that right? So November 6th submission.
And so in that submission, we will formally submit plans with proposed landscaping in the rear, and we will provide photographs of all the entire site, basically.
The entire site and the landscaping installed, right?
Well, right.
Right, okay.
It'll be taken after the landscaping's installed.
Right, okay, great, thank you.
Thank you.
Item number 8, 24503BZ, 16011 Willets Point Boulevard, Queens. All of you? Everybody raise your right hands. Thank you. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, and you respond to any board member questions? Okay. Sign. You can proceed. Oh, he's gonna-
Good afternoon, Chair, members of the board. My name is Juan Reyes. I'm a partner in the law firm Savar Shaw. Maria Papasivos-Dost, also an attorney in my firm, was here.
Can you speak up, I'm sorry?
Okay, was also Maria Papasivos-Dost from my firm was here yesterday to hear comments from the executive session. We have present today from Bola Engineering, Jared Jones, who will address the differences in the plans, as well as Ryan Vargas from McDonald's Corporation, who will talk about why this is more efficient the way this setup is. And then we also have Patrick Miller, who's the owner, if there are any questions. So I'm going to ask Jared to start talking about the plans that were here and address some of your comments, or all of your comments.
Please state your name.
Jared Jones, Bowler Engineering. So there were two plans that were submitted to address some of the community board comments and some of the board's previous comments. The first plan, which is dated Rev 2, which is August 10th, essentially maintains the existing curb cut and modifies the drive-through lane and radius to provide the two tandem quarter points. It essentially maintains the outer curb line other than a 1 or 2 foot adjustment at the
Sorry,
very property
you're
line.
talking about plans as opposed to showing plans. Do you have anything that you can, I was hoping that hint would be like drawings on the board where you could point to them and say, the difference between this shape and that shape is the following.
I could, I thought these were submitted already. I thought you had.
No, they're submitted, but I was hoping that you know, this is how architecture's done. You show a drawing, you point to the drawing, you say, this one's different from this one because of this. So hang it up because all the commissioners have to be able to see it.
Just post it on the wall, the magnetic wall. Thank you.
So the plan that Maria is holding up was the one that I was just describing that has the minor modification to the curb line on the outside, which essentially maintains that landscaping buffer to the adjacent property. Outside of that, these two plans are virtually the same. The more significant modification is we're adjusting the curb cut approximately 10 feet and adjusting that outer buffer by 10 feet as well to make a more 90-degree turn into the site. We feel that maneuver is a little more safer than what's previously, as cars kind of come in and almost make like a 110, 120-degree turn to go into the site, where the plan that Juan is holding up is more of a 90-degree turn, so it's a safer maneuver. Outside of those differences, these plans are virtually the same.
So what is it that you did in response to the community board?
The community board actually asked us for the plan that has the more reduction to that landscaping buffer.
But why? Like what was it that you were responding to?
So it was about the maneuverability into the site and how cars stack up there and essentially park on the sidewalk while they're making that almost 110-degree turn.
Why won't they park on the sidewalk with the other way of doing it?
Because it's an easier maneuver. The maneuver as it stands now, cars are literally sitting in that lane and make the right turn and almost turn 120 degrees to go back. Like the plan
Sorry,
that...
I don't understand. Can you point, can you explain?
So, yeah.
And show it so that all the commissioners can see it?
So on this plan...
So somebody
You need
wants
to
turn
hold
their
the
mic around
mic.
so they can...
Yeah. No, I need you to point,
the
because
mic
I
with
don't
you.
understand
Thank you.
really what's going on, but take the mic with you.
Got it. So in the existing configuration, somebody entering here basically is making this maneuver to get back, and they end up standing or parking somewhere in this nature to make this maneuver back. So what we did was modify based on that concern to make it more of a 90-degree turn in, so they're coming more straight in. So this, essentially, this has been straightened out.
So that's some more, I'm sorry.
Correct. That's the plan that addressed this condition to make it a 90-degree turn that the community board preferred.
And that is option 2.
That is option 2.
Option 2 is basically something that is a typical turning movement, which
Correct.
is a right turn.
Correct.
Whereas option 1 has a little bit of an angle,
Yeah.
so you're switching.
So option 1 was to limit the disturbance to this landscaping here. So it's really only in this last, let's call it 5 feet, that we're making that modification, but it's still much more of a,
And in both situations, you're maintaining this location of the existing curb cut?
no, this one requires a modification to the curb cut.
And what are you doing to the curb cut?
It's basically going to be shifted 10 feet.
10 feet closer to the resident?
Correct.
So you're imposing all these cars on this resident?
I would say that those cars are already imposed on the residents, and we're still maintaining the zoning requirement of the 18 feet separation between curb cuts.
Between the curb cuts of the
Correct.
resident, you
Yep.
mean?
Yep.
Yeah. Well, don't forget, this is a variance, and that would be true if it was in a commercial district, but it's not, right?
Only the driveways and the residential.
Only part, yeah, part of it, yes.
Both options provide for 10 reservoir
Yes.
spaces.
So I had a question, where would the loading be done, and which curb cut would be used for loading?
So right now, they're going to load the same way they do now. They load from the street.
What does that mean? They park on the street?
Yeah, typically what I do, the driver pulls up here, they're there in the morning between 8 and 10:30. They load right into this door, and then they're out of there. Yeah, it's permitted by, I mean, it's pretty typical.
So what do you do about shielding, protecting that resident who's underprotected as it is?
Well, right now, there's a landscape buffer and a fence along this whole property line.
Right, but you're tearing it down.
No,
right?
no.
Well, you are. You're moving everything over and reducing it by 10 feet, right?
So the fence is remaining. Most of the landscape buffer is only in the first 10 feet or so. We're not touching that. It's only in this last section here that we're modifying, which that is only grassed.
No, but it shouldn't only be grass, is the point, is it's under landscaped right now. The resident is very exposed to all of this traffic and fumes and noise and everything, and that's the point, is that landscape buffer is not a buffer. It's more of a decorative flower bed, which is not the same
An
thing.
actual buffer to preserve the residents.
I think the applicant would have.
Correct me if I'm wrong, but even if we did put higher landscaping by this corner, that would kind of create a safety hazard as well going into
Well,
the driveway.
You're talking about you're talking about more, basically dressing this buffer up on this side, correct?
Yeah, when I say dressing it, making it a dense buffer so that the resident is not imposed upon as much by all of these cars coming in.
Yeah, I think we could figure something out and put something in that the board would be happy with.
Regarding moving the curb cut 10 feet closer to the residents, why would you do that? Why wouldn't it be possible to keep it in the same location and just straightening? You see this curved portion? Why
Well,
wouldn't
that's what this option is. So there was two options. One of them was moving it to 10 feet. This one holds it exactly where it is. There's only a 1-foot adjustment just to make a more of a 90-degree turn.
No, but what I'm saying is, if you straightening that curved portion like straight ahead, all the way up, and just keep the curb cut in the same place, that would be.
So it shortens the queue. That will shorten the queue so you don't have to require a 10-car queue.
Right.
Yeah, like you make it like
So you need
that,
to
and then
maintain enough
you
of
just-
a
Please don't all talk at the same time, one at a time. Sorry, Commissioner Shaitan, finish your sentence?
Yeah, just,
Move this forward like that.
yes,
correct?
yeah. So as you pull that closer to the building, you're going to reduce your amount of cars in your queue, which we're at the 10 now. You would definitely go below the 10. Also, will make the maneuver much tighter.
Because of what? Because of the difference between the length of the curve,
Correct. Correct. Because you would basically be extending this line straight up. As you do that, you're going to adjust this radius to make it work, which is going to make this turn tighter. Like, there's a couple of variables to it.
That's what you very much did in the other option, right?
Yes, but this option slid everything over. That's why we're sliding it out. If you could see here, and it's a little hard to see, but the difference between this concrete sidewalk is what is going out this way. So that's at 10 feet.
One car.
So as we're moving out, you get the better radius here and the one car.
Okay, you got it, thank you.
When
I
it
do
comes to the
have-
barrier,
Sorry.
please,
Go ahead, no, go ahead.
when it comes to the barrier, I'd like you to keep in mind sound attenuation and also visual for the residents on the other side.
So I have.
Yeah, oh, I'm sorry, just to pick up on that sound attenuation, because the menu board makes, makes noise, right? There's an enunciator, and we haven't addressed the distance from the residents and how the sound's going to be controlled and the auditories, what is heard at the property line. We need to address.
So right now, there's sound studies that McDonald's haven't done. I don't have the exact answer decibel-wise for you at the moment. But I think, no, that's going to be something that they're having studies done for this particular thing.
Well, let's just say we need that, right? So we
Correct.
need to know that there's no sound on the residential property, right?
And if there is sound, handle it with the sound attenuation on the border.
Right.
So what's not clear, and my apologies, somehow or the other, the file didn't download when I tried to download. I didn't see it, but what is the height of the fence between the residential and?
The existing one's 6 foot high.
Okay, I think the building, the residential building is on a higher elevation. So you may want to make the height of the fence a little bit higher to make sure that at least the first floor window is not going to be impacted by the sound.
So if I remember correctly by the zoning code, we can't, because that violates zoning. You're only permitted a 6 foot high fence without.
Other than becoming a floor area?
Correct.
I think the evergreens require.
The evergreens
I
are
think we need to provide a requirement that the evergreens reach 6 to 8 feet.
Yes.
Okay.
Yes.
Right.
And I would say the fence should be made out of a sound attenuation material.
Yeah, either
And
way.
sound
even-
absorbent material.
Either way, even if it's not through the display, that the ordering, you're still going to get noise from the cars coming in, so some
Right.
sound attenuation is appropriate.
Yeah, and we require that in most of our applications, actually.
An acoustic fence
Acoustic
panel
fence,
would
yes.
help.
Right, acoustical panels.
I think you're familiar with it, you had done the
I
other
am.
McDonald's
I am. Yes.
in the Bronx. So
Yes, I am.
you please apply the acoustic fence there. And I would say now that you're not providing the landscape, the loading area, and per existing plan, there was supposed to be landscaping, which is not there. I think that also calls for landscaping, which also would help in some more sound absorption.
Just to be clear, you're talking about in this area?
Yes, yes. And if you want to put some picnic benches along that with landscaping, do that. Tall trees with benches underneath, do that.
I think
don't know.
operations-wise, they would
Are you
prefer not
looking
to
at me
have-
saying, who would want to sit
Yeah.
there and eat? That's fine.
Just from operations-wise, I would think they would prefer not to have benches just because it's a bad
Then
spot.
just
but,
have dense-
landscaping, that stuff can be arranged,
But
yes.
not low shrubs, something that will absorb the noise.
Right. Okay, no, that's good. So then, what's the dimension of the landscaping area between the residential property and the curb?
In the
It's
proposed.
not shown on the submission we have.
At the narrower part, it's 6 feet, but at the wider part, it's going to be 11. Existing, it's more in the neighborhood of 24 feet at the widest.
Please, people can't speak in the audience. If you want to speak, please go outside, okay? We pick it up on the mic, and then no one can hear what our people here are saying, okay? Okay, so okay,
at
6 to 11.
Yeah, 6 to 11 in this proposed condition, the existing area goes out to 24 feet.
Okay, so then you need a landscaping drawing that shows a dense buffer created there, and to the extent that there's any sightline issues, I mean, there's a fence, so you can't say that they have sightline issues, because there's a fence going all the way to the corner of the property, right? So it needs to be densely planted, okay?
The other question I think all of us had was, we were not clear how one accesses the secondary lot from the site and what kind of signage is being provided that will ensure that.
So there's actually, right next to the trash enclosure, there's actually an entrance or equipment where they can just drive through.
How do you know it's there?
There's signage up, which we have a picture which we can submit for it.
Okay, because the community board made the same comment as we did, and we saw no signage.
I don't remember seeing the sign.
There's a picture of the sign we'll submit for it.
And you know, the fact that you're using these, these kind of gates that instruct drivers to do the following thing as you drive through that part, why not something that's equivalently bold in terms of graphics for accessing the additional parking? Because we often see that just these few parking spots here are full, right? Okay, and then there was another question.
Right, so, and I really honestly don't know how you would be able to implement it, but I was just asking for it. Oftentimes to control for the cars backing up onto the street, which even though you have 10 reservoir spaces, still could pose a problem. A lot of these drive-throughs implement those temporary spots, the pull up into number one, so that if it takes an extra long time to get your food, you could be pulled off the line and not back everybody up.
So actually, the site has those. It's just when you exit the drive-through, you can come back into the site, and these first spots, those would be what you consider your large order spots.
Oh, so there is a curb cut there?
There is. Yeah, there's two curb cuts. There's one curb cut here and one curb cut here. So you could enter, or you can exit and enter back in here and park, which is how operations-wise typically how they handle it.
Oh, okay.
So they send you out, go park over there, we'll bring you your stuff?
Correct.
Oh, okay. So how do you prevent people from just parking there?
They're signed appropriately, so they say curb pickup only. I mean, we can't 100% stop people from parking there, but typically those stalls are left vacant.
Okay, so please let us know, show us the signs, because I don't see any indication of that, right? So the signs say parking only for, like...
Yeah, they say curbside parking. Yeah.
And two.
Yeah, exactly.
I'm embarrassed to say I know this,
Yeah,
but
you have a
yeah.
lot of information about this subject.
Yes, I do.
Okay. All right, are there any speakers on this? I think that was all, right?
Honestly speaking, I have to say, when I went to the site, even the handicap parking spaces were not being used by handicap vehicles. They were, instead of 2 handicap parking spots, there were actually 3 just regular vehicles that were parked there. So I have a little bit of concern about the signage that you're saying it's there. A, I did not see it, and B, if it's there now, between my visit and since then, you need to show that not only in the plan, but also provide photographs, and it needs to be really clearly visible.
Absolutely.
And the access to additional parking. Okay. Are no speakers, because are there any speakers on this one? We specifically, I'm just going to say again what the address is.
I'll do. It's 16011 Willets Point Boulevard, Queens. This is a eating and drinking establishment, McDonald's.
No, no one's here for that? We specifically reached out to neighbors, especially the immediate neighbor, to see if they had any problems with this operation, and I wanted to make sure. Okay, all right then, so we need to get you to amend the drawings as discussed, and then we want to actually see the work done. We want to see the landscaping installed and so on according to the drawings, right?
And the acoustic.
Because you're not building anything new here, this is just an extension of term, right?
No, this, yeah.
to do the new layout.
All of this work is new.
Right. It's new in our direction.
Right.
Yes, but the building department won't issue us our permit without the BSA's approval. For this work?
For the landscaping?
For landscaping ones?
For all the site works that's going on, the curb cut, DOB won't issue.
Well, then, let's see your drawings first, and then maybe we would issue a few months' approval, but I want to see the work in. All right?
Okay.
Okay, thank you.
Thank you.
So, whatever we can do.
How much time do we have?
How much time to amend the drawings? What'd you say?
Has this been filed as an amendment? Does it need to
Was it?
Oh.
Okay, Bowl Engineering saying.
Good point.
Need 2 weeks.
No, so
it's just an extension.
this was filed as an extension of term, and I don't know if it rises to the official case of an amendment that you need to.
Carla said board discretion?
Yeah. Board discretion to treat it as an amendment, you mean?
We kind of raised that.
I'm sorry, I can't.
I said, I believed that we thought it was an amendment also, but I don't know, Carla didn't seem to think.
Okay, so we'll be in touch with council about whether this needs to be filed as an amendment as opposed to just an extension because you're making major changes to the site plan?
Yeah, so it will require a revised statement of facts and a filing fee.
Okay. Okay, so we'll follow up on that. In fact, you follow up by contacting either Carlo or council or Tony, right? Okay? Okay.
So how about November 26th with the November 6th submission?
That's fine.
Okay, thank you.
Thanks.
Appeals calendar, item number 9, 205-15A through 214-15A. This is Hookery Boulevard and Fortune Way, Queens.
Good afternoon, Todd Dale for the applicant. So from review session, I know there were 2.
Move the mic, Todd.
Is that better? 2 key items that were raised. First, we did make a submission yesterday, which I hope was received. With respect to the declaration, we received comments back from council Friday and made all of the changes that were requested and that are reflected in.
You made the corrections that were requested of council, by council on Friday, which, you know, you could say, why were we waiting so long? But there were clear instructions during the course of the several hearings and all the adjournments and so on to do certain things in the restrictive deck, which were not provided and still aren't. So since yesterday, the restrictive deck doesn't say, and I'm just gonna, and this is the frustration and the reason that I think that this case should actually be either dismissed for failure to prosecute or whatever, and that you come back when your client is ready to really focus on this case. And I know it's not you because you were only brought in fairly recently on this HOA restrictive deck question. But for one, fire department required a wider turnaround on the drawings. We don't have that. Fire department required sprinklers. I see sprinklers now only on the buildings that are surrounding Fortune Way, which may be what fire department had in mind, so I'm not really sure about that. But we also had requirements about the way that Fortune Way was going to be treated and signed. It's treated in terms of material change and signed, and all of that was supposed to appear in the restrictive declaration. And that didn't appear in the restrictive declaration. And as I said yesterday, this has just been going on forever, and we sent a notice of dismissal at the last hearing, and therefore that means you get dismissed unless everything is answered the way the videos in the review session and in the hearings are responded to. And, you know, unless all the changes that are required can be made now, for us to decide it in the next hearing, my feeling is that we should just dismiss this and your client come back when it's ready to really focus on this application.
With respect to those changes, I mean, you know, a couple of those points. First of all, the fire department did issue the letter February 19th, and we had responded. We had been working with the fire department to get some clarification on one of the conditions with respect to 129th. I spoke with Inspector Daly this morning, and he informed me of 2 additional changes that the fire department would like that weren't reflected in the letter. So we did just get communication today from the fire department. They would like a 3rd hydrant, which we're prepared to install, which was not reflected in any previous communication. And they would like the turnaround to be 76 feet instead of 70 feet, which was not in the letter. But put in there.
Sorry, the February 19th letter absolutely required a wider turnaround. That was what I was reading yesterday. So that was totally reflected. It says, I'm going to just read it. Fire department objects to those properties fronting Fortune Way. To approve this, we would need all buildings to be sprinklered. For the turnaround at the dead end to meet or exceed fire department requirements, a 76-foot diameter turnaround, and there must be a hydrant with 250 feet of all entrances, as well as a hydrant installed at the furthest point of the cul-de-sac. For all buildings on Hook Creek, fire department has no objection, provided there's a hydrant within 250 feet of all entrances. That's from February.
It's not in the letter that I have. This is the letter that we have. So, I mean, I understand what you're saying, but...
I read this at the February hearing.
Okay, but I'm just saying, this is the letter that we're dealing with. It doesn't mention it. Regardless, the fire department, we just spoke to them this morning, in addition...
That's a different thing.
Okay, understood.
But
They want
what I'm
additional-
saying is, I'm seeing non-responsiveness, and I don't like that when there's a response, it's the Friday before the hearing, or the Monday before the hearing.
Understood. Council got us comments the Friday before the hearing. So we responded to the
Sorry,
restricted
you
declaration.
can't put this on council.
And also, just all the comments have not been addressed in the latest restricted declaration.
And I would say
as
that they...
discussed, because of the notes with respect to the turnaround and the signs and all of that needed to appear in the restricted declaration.
The proposed plans show the different paving, they show the signage, the issue is addressed, the restricted declaration does speak to it. We can include a line about the signage in the restricted declaration. It's an easy and simple change. But to say that there hasn't been any response is false. Because we have responded in a timely fashion. When we're dealing with the fire department, and the letter that we have on record is this February 19th letter, these are two changes that we can make easily, the hydrant and the 76 feet. The other thing, too, is we were dealing with the legal issue of the fire department claiming that those 5 homes on Fortune Way required sprinklers by code. We presented information saying it wasn't required by code. In order to resolve the code issue, the property owner said, look, I don't want to continue to fight the code issue. We realize this has been going a long time. I will agree to the sprinklers on those 5 homes, which addresses the condition that was raised by the fire department. The other thing, too, is the fire department still needs to respond, and the board would need to address. The first point in the letter received was talking about the fire department's desire to open up 129th Avenue, which would run directly through 2 of the homes that we have proposed. We're not prepared, with our plan, to remove those 2 homes. We believe the fire department is going to change that restriction or request to eliminate those 2 homes. And if they do, then we will be satisfied. So that was an ongoing issue also. That's in the letter. If you look at the very first point of the letter, I have my own little marks in there, it speaks about opening 129th Avenue, which would run through the 2 homes that are at the south of the site.
Okay,
So we provided that we're not prepared to do that because that's privately owned property and we would like to develop that property. If the fire department stands in that condition, then the board would need to make the decision, either saying those homes need to be removed, in which case we would disagree and then we would need eminent domain action, or the fire department can rescind that particular action. So this has been an ongoing discussion.
All right, let me just put this in perspective, because at the April hearing, I said, this is the 4th adjournment requested. The application has been in hearings for a year and a half. Council has to send a dismissal warning notice, which it did, our council, which it did, right? Every time we have a dismissal warning notice, the instructions to council or to the representative for the property owner is, you must go through every single requirement that the board or any of its sister agencies requested and respond to them. I didn't hear one thing about this particular February 19th letter. I didn't hear one thing about the February email that we have that talks about the sprinklering and the hydrants. Not a comment. The only thing that was submitted in preparation for this hearing was a restrictive declaration that did not address all of the issues that had been raised. So to say, to say that what I said is false is frankly false. So this is my position on this. You have until next week. 100% of the things need to be addressed, or we just dismiss the case, right? Or vote on the merits, depending on how the board feels, because this has been going on far too long, and I don't get the impression that your client is really serious about this project, because I don't know anything about your relationship with the client, but obviously you were only brought in at the very last minute, and we don't see drawings for months and months and months. The last time we saw a drawing, I think, was in February. No, February was a completely incomplete submission. So we haven't been getting complete submissions ever. So yeah, I do want to hear from fire department, but those are the instructions.
Good afternoon, John Daly. Todd Dale and I did speak earlier about this, and of course, we did have a discrepancy regarding the dimensions of the cul-de-sac. I see it's 70, he sees it's 76, but we need to clarify that. And also, there was a misunderstanding about a third hydrant that we need, well, a second hydrant, I'm sorry, on Fortune Way, furthest away, which I clarified with Mr. Dale. The issue with, I know it's Captain Resner from City Planning Unit wanted 129th Street to go through the site to Hook Creek Boulevard. I believe he wanted that the road to go through because he thought that they were not going to increase the size of the cul-de-sac to 76th Street, 76 feet minimum, and put a third hydrant in. Once I know Mr. Dale would then need a little time to revise that plan, and I would have to go talk to Captain Resner and Malloy in our city planning unit to show them the hydrant and the dimension of the cul-de-sac. That having a week, I'm gonna hold them up.
Mm-hmm. You're going to hold them up, but they've been holding us up since...
That's true, yeah.
This is dated February.
Yes. Yeah.
What month are we up to, right? Why are we waiting this long? And it was adjourned and all of that, and I just don't want to encourage this kind of application.
Understand.
So I'm just going to say, if it can't be worked out in a week, we dismiss and you come back when your client is ready to actually have a serious application, because we can't just keep going on.
I would say we, by the end of the week, can submit a revised plan that shows the third hydrant, which previously wasn't discussed before today. That will include a 76-foot wide diameter for the cul-de-sac. We will revise a restrictive declaration to specifically mention the different paving and the signage and these other issues. However, we'll get that submitted by the end of the week. I can't control what the fire department will do as far as a response.
Right.
So we'll get that response in, and then hopefully that will satisfy the fire department to get their letter in. But those issues, we have no issues, not to use a word, but we have no problems getting that in by Friday for a hearing next week.
Okay. All right, that's what we're doing then. Are there any speakers on this? So I want to close this hearing.
Chair Promoter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
Aye.
And we're going to vote on it next week, come what may. Whatever shows up, that's how we're basing
So
our
the submission is 9/13.
9/13 Friday.
Friday 13th, okay.
And it will
Close the
include everything requested on the restrictive deck in prior hearings, and will include the 76-foot turnaround and adequate fire hydrants and the paving changes.
Make sure
Okay?
you copy directly to Kirk, to council.
No, we'll definitely do that.
Just in case
and
some-
all those, so essentially everything that's been in the record except for the third hydrant,
Okay,
which is not in
and
there.
what I would ask also is, because council needs to review the restrictive deck, get that in before the drawings. Okay? It's just because we need time to review it.
The restrictive deck has the drawing appended, so we can get the language of the restrictive deck. If the drawing isn't quite done yet,
Yes.
we'll figure it out. Okay.
Okay,
Sure.
and when you get it in, specifically let council know that you're submitting it so it's not a mystery.
Sure. and
Okay?
we'll give you the track changes version, so you
Okay.
can see that.
Good. Thank you.
Item number 10, 2017 5A through 2017 7A. This is Sharretts Road, Staten Island. No, it's still the A case. No, none. None in the A's. I'm so used to swearing. I know.
Elise Fullader from Eric Palatnik PC on behalf of the applicant. Did you see my submission from last night? Maybe, maybe not. Okay.
It's not a joke.
You revised the plans, right?
Yeah, so we took the July and the August DEP letters, and we put all the conditions we could find in each of those letters in the bottom left-hand corner.
Great.
Of both plans.
Great. All right. Sorry, just, all right, that's good. So then, are there any speakers on this? Anybody, any comments from the board? No? So I'd like to make a motion to close this.
Chair Promoter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
And a motion to grant on condition. The conditions have to do with DEP. So there's, just to point out to council, there's a 7/26/19 DEP approval letter that was addressed to the engineer. And so that brief condition should be in there. And then also the DEP sign-off letter that was directed to us from 8/9/19. That's a little longer. And all of that information is also on the plans. And then just kind of a summary, the property owner and not New York City will maintain the sanitary and storm sewers and the water mains, because they're all on their property. Okay? So a motion to grant on that condition.
Chair Promoter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
All right.
Thank you so much.
Thank you.
Item number 11, 14014A, 1016 East 13th Street, Brooklyn. Sure. He has to submit. He didn't submit anything else, right?
Thank you.
Thank you.
No, you're good, you're good, you're good, we're good. Thank you.
Elise Fullader from Eric Palatnik, BC, on behalf of the applicant. I have today with me, I don't want to ruin his name so he can say it, but he's the owner's representative and construction superintendent.
Spiro Malkotsis.
And so, unfortunately, you saw when this was originally calendared months ago's work. Now it's 95% completed.
Looks like it. Very nice tile work in the bathroom.
And also, the most recent A form we have is from 4/15/19, and I have attached that. That says 86% done, but it actually is 95%.
So you don't have a later requisite?
We're waiting till we're done to build the final.
You have to come to the microphone.
We're billing when we're, closer to completion. So right now, the elevator's being installed, and that's the big chunk of the balance of the funds.
Okay, so since April, there's been no requisitions?
Correct.
Oh, okay.
So
But you have that with you, or you handed that out? The requisition?
The April requisition is
Oh,
in
it's
the
on
back
here?
of the package.
Oh, okay.
Photos are in the front, and then the paperwork's in the back.
So now you're, what's the percent completion?
95 currently.
Okay, and what's your anticipated full completion?
2 months.
2 months, okay. And have you already applied for inspections and,
We are going for TCO in mid-November.
okay. So then, good. What's your anticipation for actually getting TCO?
Well, mid-November, we're getting the inspection, and if there are no objections, we should have the occupancy certificate by the end of November.
Wow. So then, I mean, I don't know what you asked for originally. So then, I know, but in terms of how much, you don't need 4 years, obviously.
We're flexible.
So if we gave you an extension of 1 year to complete, is that enough, or would that make you nervous?
More than enough, thank you very
Okay.
much.
Okay. Any other comments from us?
Well, my comment
Oh, the
was-
serious,
was to discuss in your statement of fact the 3 findings with the most recent information that you have, instead of just resting on the very first, vesting case.
Unfortunately, I got this information this morning, so I could put that together.
So question, would oral testimony on that be
I don't know how
satisfactory?
you could do that for the serious loss.
Serious
portion,
loss, yeah.
Because you've done quite a bit more work. you would lose.
95% of the building.
Right, so speak to what can't be reused based on the waivers, I guess.
But there's no way we can be done.
Well, could you speak to it now?
Yeah, that's what I wanted to know.
If you could speak to it now.
I wish I brought with me.
What
So
were the
just
waivers?
talk about the rezoning and what it resulted in.
Yeah, if I don't have the resolution in front of me.
So how about this? As suggested, why don't we do a second call?
Okay.
The two of you put your heads together and
Yes.
say, what did the old zoning allow us to do that the new one wouldn't allow us to do?
Yeah.
And you go through that list, and then
Yeah,
you'll
'cause I went
say,
through the resolution.
this many floors, this much floor area, this much money. You could estimate how much money it would
Okay.
take to take all that stuff down, okay?
Okay, I can come back.
All right,
I just
great.
don't want to say anything without a resolution.
Okay, good. So, second call this then.
Okay.
Thank you.
Thank you very much.
Okay, item number 12, 2016-4302A from 2016-4326A. This is Cupidity on the Adita Place, Staten Island. Item number 13, 2016-4355A and 2016-4462A, Forbury Lane and Adita Place and Cupidity Drive. Item number 14, 2017-107A. And 2017-129A, and item number 15, 2019-51A through 2019-57A, also for Mayor Lane, for Marie Avita Place, Cupidity Drive, Staten Island.
And I would ask that we turn off the air conditioner because we know that people are going to be listening to these recordings and they had trouble yesterday understanding us.
Thank you. White button testing.
Down, just push it down.
The switch.
The switch down, there you go.
Thank you.
Wow, they do all this complicated stuff at the fire department, but a switch, I don't know. So, and I just wanted, before you begin, to preface this, that, because the community might not have heard what we talked about yesterday, that we have a rule about the proper service of an application, where the community board and elected officials are supposed to be notified of these applications 20 days in advance of the hearing. Service was not proper. Service only went out on August 27th, which is not 20 days in advance of this hearing. But because we were aware that the community members might be coming to testify, we didn't want them to come and then there was no hearing. So we reached out to the community board and the elected officials and asked them if they were okay with us proceeding with the hearing. And they were, and the community board is going to be holding its own hearing, I believe when is it? October. So we, of course, will not make any decision on this until after the community.
Pull your mic down? Down.
Down? Why down?
Yeah.
Okay. Let's see what happens. Okay, go ahead.
Todd Dale.
Oh, yeah, sorry. Let him just speak and then we'll say that quickly, yeah.
Okay, I was going to say Todd Dale for the applicant. We acknowledge what you noticed about the service. We'll make sure that the 20 days is taken care of, and we will be hearing at the community board.
Okay, and then we just want to make a comment about some seeker issues. The first is that in yesterday's review session, there were some comments made about this application being reviewed in some way in terms of seeker thresholds. And seeker for the benefit of the community who's here, that's the City Environmental Quality Review Act. General City Law 36 waivers have not been treated as subject to either state or city seeker. That was the view of general counsels in the past for the Board of Standards and Appeals. So though we may in future relook at that, we can't retroactively look at this application in terms of city environmental quality review because the application was filed in 2016. So any application of seeker to GCL 36 applications might be something we do in the future, but we can't do with this case. But, so in terms of that, I don't know whether you want to re-discuss.
I want to add, I want to clarify my statement from yesterday's, and that is that the subject site, just to put it in perspective, the subject site occupies over 15 acres, and it's a size of typical 3-city blocks. In the absence of a finding for site planning for GCL 36, in reviewing this application, I look towards other planning tools used for site planning in the city of New York. And a project of this magnitude would meet the definition of a large-scale development for zoning resolution. A special permit or a mapping action would allow for a multi-agency review, including DOT, parks, DEP, school, to ensure a planned development where the development would result in buildings that will benefit both the occupants of the subject site and the neighborhood, and that the planning will ensure appropriate access has been provided from mapped streets to the zoning lot, and that the streets providing access will be adequate to handle traffic and pedestrian flow and for emergency access, and that there are adequate school seats and open spaces for the proposed development and future growth on that site.
And to that point, I just want to pick up that the advantage of a large-scale residential development or community development or so on is that some city planning has the authority to waive certain kinds of lot coverage and bulk regulations and so on to enhance the arrangement of the buildings on the lot, which is one reason why developers go to a large scale when they have a very large lot. Okay.
I just want to say
proceed.
that I don't believe that this makes a prima facie showing that makes it GCL 36 available to this applicant.
Okay. All right. Mr.
Okay. So noted.
Okay.
Okay.
Sorry.
So we did listen to a review session. Unfortunately, our microphones were a little bit garbled, so if we missed something, we'll...
Oh, I'm so sorry.
It is what it is. We'll respond to any questions that we might have missed. I know there were a number of issues raised. The first thing that I would just want to note to start is that we do agree that additional materials are needed for this application, including the statement, the BPP will provide a better street map. Just to provide a timeline, these were originally filed. The board has evolved its approach to these applications over the past few years. This application was actually originally filed in 2016. So even though this is the first hearing, it actually was submitted prior to a lot of these new items being developed. We acknowledge, that requests have been made of comparable applications, and we're prepared to submit those items, and we can address them, as we go down.
But just to clarify for the record, a notice of comments was issued, I don't know when, more than a year ago, requesting many, many things that are more like what's requested in a mapping action, because this is such a large site.
Sure.
And we got none of that. Not one thing was provided. Nothing even similar to what we get on other applications that are much smaller. We got nothing.
I would actually disagree. That notice of comments response included traffic analysis, which is not normally considered.
No,
It included an
we don't want
application map. It included an area map. It did include the BPP as a BPP is required to be filed. I understand that there's theoretical BPPs now that have been requested similar to the Taurus application that deal with the internal lot. The BPP submitted did not include that, but we, were prepared to provide that. So there was a response made. I would also say that if the board felt that additional information was needed, it could have issued a second notice of comments.
No, we issued the first, and the first was a list of very many things, and we shouldn't have to ask over and over and over again that the notice of comments is responded to. At a certain point, we just give up and we put it on the calendar. What can we do? If the applicant chooses not to answer, what'd you say?
That was the response they chose to make, to then say, well, why didn't you ask again, I think is a bit disingenuous.
I would just say that we believe that there were plenty of items that were in that response that are not normally included in the notice of comments response. And also that notice of comments was, as I said, the timeline on this is a little bit skewed, just because it's being heard after some of these other things. So we just acknowledge, we'll provide the materials, that are requested of merit and get them submitted. So in listening to the comments yesterday, I know it seems that there's really two threads that have been approached this application. I would say the first is comments regarding materials or items that deal specifically with the proposed development information like the BPP. But then there's also a thread of comments that are focused on whether the board has the wherewithal or the authority or is the appropriate venue to hear one of these applications. So I think that those are the two, I don't mean to speak for the board, but that seem to be the two lanes that the comments were in. I can speak first to the board's authority to hear the application, and we can move to the other materials. We've noted before at other hearings, we'll note here, that the board is authorized to hear these applications under State Law, General City Law 36. And that is why we've come here to file. There is no requirement within that law that a street mapping be filed.
It's an exception.
Excuse me?
If you read GCL 36,
Please
it says...
move forward and
I'm sorry,
talk
if you
into-
read the statute, it says that, it actually states the requirement that all city streets be mapped. It's, I think, the first line. Okay, so you're saying there's no requirement that it says a street should be mapped?
No, I said there's no requirement that we file a street mapping action within General City Law 36, and that the exception within General City Law 36 allows for instances of unnecessary hardship or practical difficulty for the board to review these cases in order to issue approvals, as historically the board has done for over 50 years. Okay? We would also note that with respect to the Euler process, getting right to the point, there was a question saying that there's no hardship to go through the city map. And we would disagree. We'd say that there's court cases on record, also filed, that say actually going to a city mapping, a street mapping, or a D-mapping is a unnecessary hardship.
For a lot, for a project of this size, or for one
Versus
family?
that, it says that it's an unnecessary hardship. And the reason is the crux of
And
the
how many
difference comes...
units were in that case?
I don't believe it's as many as this one.
It was like 9, wasn't it?
But the principle stands. The principle stands that...
The principle stands in Browse that it states quite specifically that this type of GCL 36 is limited to much smaller applications. And in Browse, it states 1 or 2 family homes. Nowhere close to 136 or 196 that's being placed here. So I'm not sure how you're going to reach that this is a hardship that is akin to a 1-family seeking or a 2-family or a 5-unit seeking a GCL. I'm not how that can be comparable to all of these units.
And I would respond to a couple of points to that. First of all, one of the core differences that's set forth is that the board in reviewing this is an executive agency that is executing an administrative review. Okay? By its very nature, if you request a mapping, you are not in the executive venue anymore. You're moving to legislative, because any street mapping needs to be approved by city council. So it is...
We're not requesting a mapping.
No.
We wouldn't be requesting a
If I could
mapping.
finish, I would just say that requesting a street mapping, if that were the requirement, to go through that process, it becomes a legislative procedure, because the city council would need to approve any change to the city map.
Where does it say in GCL that it can't be an act of the legislature? And by the way, it starts off as an executive agency review of many executive agencies, which is part of the point, right? Almost every agency weighs in on a mapping action, and that happens long before city council blesses it or signs off on it or modifies it or so on,
But
right?
the core difference is that for a street mapping, it is a legislative action, because the city council, the legislative body, needs to approve any street mapping action.
And
So
where-
it's a huge difference.
That's a non sequitur.
And where does where does the GCL 36 say that a mapping action, that's something that requires legislative action, even if it's kind of at the very end of the whole process, is a hardship?
The hardship is that requiring a legislative action by an administrative body, requiring legislative action creates an unnecessary hardship.
We would just be
for-
not granting the waiver. If we just don't grant the waiver, we're not requiring anything. It's your argument that this is a hardship in lieu, and it's because I have such a hardship, I'm requesting this waiver that's written and case law supports is supposedly for very limited circumstances. And if we don't find that you fall into those very limited circumstances, you're just not granted a waiver. You have to follow the law just like every other citizen.
I'm speaking to the unnecessary hardship has multiple prongs to it. And there has been discussion, not only during this application, but their application, where the talk was that it's not a hardship to go through the Euler process and to get these streets mapped. And the fact is that Ward versus Bennett speaks to the fact that it's unnecessary hardship to require a legislative review and approval of street mapping. And we'll provide that information into the record so you can review the case and take a look at it and respond accordingly. But we'd say as far as the unnecessary hardship aspect, that sets forth the unnecessary hardship because absent the relief that's permitted under General City Law 36, that's the only alternative, and by default, a property owner then would be required, in order to develop the lot to the extent that it can be developed under the zoning requirements, would be required to go to city council approval.
So what's the purpose of a mapping action? When should it be done?
I would say that if the city chooses to have a mapping action. I would also say, speaking to the mapping action, that's an excellent question. Because if you go to city planning records and do a search of available public records from 1970 until now, as for any street mapping, there are no street mapping actions that have been done by city planning by a private property. They just haven't been done for 50 years. Now, I'm not saying that it couldn't happen.
I will correct that. It has been done, but very rarely.
I'm just saying through public records, the available public records.
Yeah, I did the similar check, I would say, a year or so ago when this issue was brewing, just from my understanding. There were very few cases, granted, most of it was through city actions.
Right, and that's what I'm saying.
And those
The two-
cases,
sorry.
and in those cases, I think the sites were even smaller than this.
The two that we found were initiated by the city themselves. So I'm just saying, so there is, you speak to what's the necessity of a mapping action. I think that's an excellent question to ask, that the city hasn't felt the need to have any city street mapping actions for over 50 years by a private developer. And that goes to the question is, what would be the differences between the items looked at by city planning versus what could be reviewed by the agencies through this particular process? This particular application is referenced out to other city agencies who will go ahead and issue comment letters. And I think it's important to say, and I would like to hear what the city agencies say, what would be the difference of review for example, the fire department between reviewing it here and providing their comments versus providing their comments at the city planning level?
But that's not the jurisdictional question. And you cite Ward v. Bennett, which now I recall is a one-family. It was a one-family home. And in a one-family home, they found that would be a hardship for them to go through a whole mapping procedure for a one-family home.
And I would also then, to speak to that point, and I know you'll disagree, but the fact is, this is not one application. This is 163 applications. There's no requirement that these applications have been filed.
Please don't go there with that.
I will go into that because it's a very valid point. This application could have been filed for just a single one of these homes. We filed all 163 together for the convenience of review for the fire department and other city agencies, but there are plenty of developments throughout the city that are applied for and permitted and developed in sections, and this could have been developed in sections.
And if you review Brock Properties, you'll find that that's improper. And in Brock Properties, one of the main questions was, do you own any of the adjacent properties? And like in the case here, where you would own adjacent properties that do in fact front on a map street, that, again, GCL 36 is not appropriate for you.
Brock speaks to the fact of alternate access available. So if we talk about this, if this section were filed, and you ask about whether alternate section was available, then you could just do like sections through here and sections through here, so it's not an equivalent. It's just not. I mean, we can point to Brock, but it's not equivalent.
Brock states that if you front on a map street, or you own an adjacent property that fronts on a map street, a GCL 36 is not available to you. And in this particular case, that's what you have.
I would say, our firm was involved with Brock, so, if you want discussion on Brock, we can put that in the next submission.
Sure.
So, but it is true that this is about, this case, whatever the name of the case is, Ward v. Bennett is about a single house, right? This is not a single house. This is a 15-acre, if I've got the right number of acres, site, and it's disingenuous to talk about one individual application after the next one, when a site of 15 acres with 165 buildings on it, in fact more because we have these large buildings, is essentially a planned unit development that has gone through no planning. And the idea of bypassing all the planning programs that the city has created, this is the city of New York. It's a sophisticated city. It invented the zoning resolution. The whole idea that a property owner can bypass all of that careful let's say, legislature methodology that's been developed over 110, almost 110 years, frankly, is absurd. And I think that to try to exploit it here is,
Disingenuous.
well, more than disingenuous, it's really, frankly, not appropriate.
Well, I
To
wouldn't,
use
I think
another- to use
that
a more
speaking
polite
to
term.
exploiting disingenuous is, we would disagree with that characterization. I understand that's, the words you choose to use. But the fact is that these sections in the city planning review that the board has referenced in other cases are set forth in specific districts throughout the city that require those, the school seat, the topography, and that city planning review. City council and city planning determined that this particular lot is not in an area that requires that particular review. They set forth in the zoning resolution, okay? They also set forth in the zoning resolution that this is an R32 district. So city planning and city council has set forth the density level that they find appropriate for this area. They've also set forth the review of school seats and topography and the type of review that they need to go through for this particular site.
Please.
If city council or city planning determines that sites like this or this particular site needed something like that, they have the right to change the law. But
Right.
the fact is, the law has not been changed.
And the
So
law
we're dealing
doesn't
with the law
apply to
that is
this
here.
particular case. The
So-
law, as the case law supports, does not apply to this particular type of case. This is an exception. The general city law is an exception to a mapping action. This is not what we have here.
This is, the general city law was set forth primarily to set forth safe access to sites. And as long as we meet that threshold, we'll do that. And there's cases that we can submit to that point.
It's
That's
most
the
likely
history
for
of general city.
silos and unrelated, things that didn't have to relate to the
No,
master.
I just want to clarify the terms that you're using. The general city law requires every building to front on a map street. The administrative code, the buildings code, requires every building to have 8% of frontage on a map street. The waiver of those two provisions comes to the Board of Standards and Appeals in the case of demonstrated hardship. And there is, I don't, there isn't any case law to support, and you can try it, but there is no case law to support an argument that this site with 15 acres would suffer a hardship by going through a city planning administrative review process where DOT, DEP, fire department, I'm leaving out some, parks, weighs in on what's an appropriate subdivision of this property and an appropriate layout of streets to best, and all in compliance with the R32 zoning. I'm not saying you don't get to build your multifamily building, et cetera, but with respect to whether or not we should consider there to be a hardship that prevents you from going to city planning for them to do their job, no way that Ward v. Bennett stands for
Ward
that
v. Bennett
proposition.
does not stand for mapping actions or hardship per se. You failed to cite any hardship besides a theoretical hardship that isn't supported.
We would disagree. We believe that Ward
What hardship have
stands
you
for that
stated?
standpoint. And the fact is, when you talk about going to city planning, the only mechanism now for this site to go to city planning would be a city mapping action.
Correct.
There's no other, okay?
No, you could do a large scale, that's not true. Isn't a large scale
City-
residential
city-
development available? Which would be a really good idea, by the way, because it's a great way to lay out the properties better than you've done there.
And those end up being legislative actions. And this is a situation where an administrative executive agency is requiring a legislative action.
We are not.
We're requiring
We're simply
nothing.
saying,
Go build it as of right.
this doesn't apply, that you are not entitled to the GCL 36. We're requiring nothing. You've come to the board and asked for an exception to the rule that you don't fit into. So to say that we're requiring something legislative, that's not true. And I understand, I understand your position. I understand that you have a client you have to represent. And I understand you have to try your best, but there's nothing to do here.
Right. And I just want to also add that, please, I do want to add also that you have actually a significant amount of frontage on Fingerboard, which is a map street, and also may have frontage on something else. I just don't have it right in front of me. So there are ways for you to get into the site with what would be considered a private road that might not need GCL waiver or a driveway that might not need a GCL waiver. So it's not to say that absent our waiver, you can't build anything. There's no deprivation of a right by us
Even if there was
reviewing-
no other avenue to build
Even if there
here.
were no other avenue, i.e. a large-scale residential development or a mapping action, favoring the first because that's such a good planning program. But but you definitely have a method for developing this site, so you can't say to us that there's the deprivation.
That's fine. I mean, I understand. We'll put in our points with respect on necessary hardship and city planning and city council review. I understand the board's points. You'll have an opportunity to read and review it as you see fit. But we'd also say that, we'll provide information with respect on necessary hardship also with respect to, we'll provide theoretical plans showing what could be built absent any relief from city
I don't
agency.
think it's relevant.
That's
That's
fine.
not jurisdictional.
It's
Again,
relevant because we'd like to put it in the record.
Okay,
And so
good.
we'll put that in there, and we'll show that there would be significant property rights that were lost that could not be developed.
Again, it's not.
This huge swath here would be inaccessible and would be just left vacant and unable to develop, okay? We also speak to the fact of unnecessary hardship because we believe there's an equity component to this. There is, right here, North Drive is an unmapped street, similar to what we're proposing. North Drive has 103 buildings fronting on it. There's also a series of composer streets here that are all unmapped that have another 50-plus homes. There are more homes here currently existing on unmapped streets than there are proposed here. There's more dwelling units here on these unmapped streets than here. So from an equity perspective, to sit there and tell this property owner that they cannot
Take exception, take it.
to not take the exception when there's already other lots that are immediately adjacent. There's also plenty of map streets up here, not to the full extent, but these make the best case because they're immediately here because there's more buildings that are on these unmapped streets. To compare the two lots and to tell one private property owner that they're not allowed to develop pursuant to relief when there's these existing homes, we say is an unnecessary hardship.
Okay, so that's not unnecessary hardship. That's not what we're saying. And that's not the situation that's before us. This is one developer with 15 acres coming in on multiple applications for all property he owns, asking for an exception that has been very tailored by the case law and tailored in a way that a quarter of your program shouldn't pass by it, in my opinion.
I would also say, speaking to this, the board has had previously acted on other similarly large sites. We know Taurus came through, and I know that the board has said there's an exception, but there are 70 units that were approved on Taurus, okay? 70 dwelling units. There's also Lemon Drop and Turner has approximately 50. Also, the board has had plenty of cases, and I realize they're not residential units, but Industrial Loop, which the board is very familiar with, is not a mapped street. There's over 60 buildings there, and the board has consistently approved buildings on an unmapped street that is significantly larger and longer and of greater distance than these roads that are being proposed here.
So an industrial loop is a very long road where each of those properties is owned by a different owner who comes every once in a while. A new owner comes and because they have to go to the DOB and DOB is now requiring these waivers. It could be an existing building that needs to get a waiver or a new building that's replacing an existing building that gets a waiver on industrial loop. So it's really not a fair comparison at all. It's not the same as one developer coming in who owns all of industrial loop and saying, I'm building an industrial area and I don't want to go through a mapping action. That's the kind of, because the GCL 36 paragraph 3 allows for an individual property owner, unfortunately not a commercial owner, which I think was a mistake, but an individual residential property owner whose site is already located on a block that is not mapped, but has other houses on it, to do that, to build their house as of right? So the legislators already recognized the problems of individual property owners and the hardship they would face, hence the reason for that recent change in the legislation.
And the legislator,
right?
I agree, but the legislator recognizes the fact that the issue here, the core item to be reviewed is the street and not the buildings. It's the street that really, this is the, we talk about mapped streets. That's what the general city law is primarily about. And the fact is, though there was disagreement, there is nothing that would prevent filing a single home here and obtaining an approval. And once that home was approved, based on that exception that the chair cites, every single other one would be allowed as of right
more
by the
than
Department of Building.
approved, built with a C of O.
Sure.
That's the requirement.
I take
under
that
this,
back. You're correct.
right?
So
So
if
you
we
would
had
have
one
to do
built-
one at a time, get a C of O, et cetera, et cetera. I forget how many houses,
Sure.
5 houses or something have to be built.
So if one were built, CO issued, the rest would be allowed?
No, that's incorrect. No,
Sure, but-
absolutely not correct. If one were built facing an unmapped street,
Right, so
and then
it's
you
a-
have 5 Cs of O, I think the number is 5 C of Os? 5 C of Os, so you need 5, in which case they could face that unmapped street, but not any
I don't think
others.
the exception says 5 homes. I believe that, I mean,
Yeah,
we
it
can
is.
review it, but I believe the exception says that if there's a single home that's been granted,
No,
and then it's on the
it's not
mapped
a
street.
single home. No,
But we
it's
can
several.
include that information.
Not that this is
Well,
relevant.
if you
Sure it
could
is.
just do this as of right, why are you here?
Yes.
Because the intent was to work with city agencies and to provide convenient review. I think that's an excellent question. When we've reached out to the fire department, when we've had ongoing conversations with the fire department or other city agencies, the whole plan has been, we want to make this easier on the city. The board has talked about not having manpower to review this. Well, we're trying to provide this all in one collected bit of information so it can be reviewed. But there's nothing that would prevent that
I
being
just want
filed.
to add to that. I made the statement saying that, I do find a clear distinction between this and Teresa and Tupelo, for this reason being that Teresa, Tupelo, and even Nello were reviewed at the Department of City Planning, the planning agency of the City of New York, that deals with land use, planning, layout, subdivisions, all of that. It's in their portfolio. They reviewed it based on set criteria, and they applied those criteria uniformly, consistently, and I felt comfortable approving that because it went through a planned review. We are not the Department of City Planning, and we do not have those authorities, nor do we have those tools to exercise here. So that's where my concern lies in reviewing this project. Yes, I do appreciate fire department giving us the comment, but what do we do with it? How do we ensure we put this forward, right? And the Department of City Planning has those mechanisms to do it through large scale. In the case of Teresa and with Tupelo, it was in the Special Natural Area District or in the South Richmond District, so they were able to exercise a lot of those requirements. This unfortunately falls out of that, but it's in a lower density growth management area, and those comments, and DOT has said it, FDNY has said it, that they have concerns about this. How do we implement it?
I understand.
We do not have the planning staff. We do not have the in-house transportation expertise. We do not have the in-house open space division. We do not have the in-house community facility review team. Those are all the people at the Department of City Planning are reviewing these projects. And therefore, I sincerely would hope that you would find, and I sincerely believe that you can get a better site plan when you work with city planning if you go through a large scale. You don't want to map it, but go through a large scale project. You will get good site plan that will result in a good market value, that will work with the community and with all the street networks. My biggest concern is that you have provided only 2 access ways for a development with 160 plus units. To me, that's a concern. And FDNY has that same concern. I just got the letter today. And it just goes on and on and on. And you have heard me supporting GCL. So coming from me, you really need to step back.
No, and I understand, and I appreciate the comments, and I do listen to them, and I understand, but there's a lot to unpack what you're talking about there. So to a few of the points that you've made, you're correct saying that there is no particular requirement for city planning here. So if we wanted to go to city planning, there is no certification or authorization available to us. There's only a legislative option available to us.
Well, I think
Okay?
that's because you're so wedded to this plan. If you change your thinking in terms of the planning and where you want to distribute the bulk in a way that results in better site planning, you will have grounds to go to city planning.
I have no problem bringing up the idea of the large development to the property owner and including
Right.
something in our next response with respect to that
And
particular issue.
I would say go to city planning and say, hey, we want to do a large scale plan. How do we do this?
Okay.
Start that discussion there.
But the other issue that comes up in, some of the things you're talking about, sorry, I'm trying to back up.
Can I just say something?
Yeah.
You said those projects there. I think those are lessons learned.
Yes, that's exactly
And we, those were done without that city planning review. And now, because of that, they have developed the large scale, the low density growth management, they have developed the private road. All of those requirements came as a response to how not to allow that kind of development. And I am concerned about a 34-foot wide roadway that is being proposed in a in a complex with 164 units. I think it needs to be wider than that. You're never, I just, as a, I don't know how you're going to manage and oversee somebody not parking on the sidewalk, on the curb, right? They're just simple things that in my mind are giving me pause.
They're very fair points. I'm going to speak to a few of them here, and again, we'll supplement it in any written submission. With respect to, your comments about the design, the idea behind this, when the original design came forth, is there are two existing pathways that originally led into the site, and these two lanes are designed to mimic that, okay? The design here, by the architect, they said, is they didn't want to provide extra curb cuts and extra focus over here on these homes here, and by providing this street and green frontage, it maintains a similar appearance to what's already existing. So that was the thought behind the design. You may not like the design, but there was consideration put forth to using existing pathways and having it come in through here, as opposed to trying to come out other things. Just as a quick aside, I know there was a comment here about Lot 22. There's no plan for development of that. It's part, if you look at the original tax map, the original lot, this little outlet here is part of that. They're not planning any use for that particular lot. It's part of the lot, and it's not planned to be severed at all. It's just going to be part of the zoning lot and an open green space there. So that was part of the design as far as the two. You spoke to these other homes. We'll dig into it and we'll do some research. We just talk about poor planning. But the fact is, if we do research here and we review, available records we found so far haven't issued any complaints with respect to North Drive or the composer streets, as I call them. So the fact is, if there haven't been complaints or issues with North Drive or these composer streets, then why would there be an assumption that there be issues with these streets when there's fewer homes here?
So now we have like a serious case of amnesia of the last several years because I'm not a fan of these GCL waivers, whether they've been to city planning for school seats analysis or not. The main issue on all of these developments that have been approved by this agency over those decades has been that because the Department of Transportation does not have the authority to manage those streets, the neighborhoods become derelict because the homeowners association doesn't even really know what they're supposed to do. They don't even know that the streets are not city streets. They call up the borough president's office and say, why didn't you shovel my snow? And the borough president says, what's that got to do with me? It's your street. And by the way, we just had something recent in Queens where there was no garbage being picked up on one of those unmapped streets, and the owner of the garbage calls up sanitation and says, what's going on? And sanitation says, bring your garbage to the corner. That's the closest map street. That could happen at any moment on any of these developments. That's not the way to plan even a suburb, much less a city like New York. And so, you can, I have to say, you can submit all these materials and try to make your argument that there's a hardship, but I don't see it. We don't even know whether this project complies with the private road regulations.
It does.
R32 zoning, but how do we know that? We never received a zoning analysis.
There is a zoning analysis of the original application.
If anything, it's one of those little charts. How is that a zoning analysis?
Sure, if you need it more complete, we can do that, but it wasn't requested.
There's no zoning analysis. It actually was in the originals. That whole list, myriad list of all of those things, which you chose not to
We can provide more information, but the
respond
fact is, no relief is sought with respect to zoning. So
no relief is sought with respect to zoning. It's completely relevant because we have looked at GCL waivers where they didn't provide adequate yards, and they had to, I don't know if this was your case, but it took a long time to go back to DOB and redesign the site because it didn't have adequate yards or space between buildings.
So that's on an architect failure, and there's no assuming that this is an architected failure.
Well, it's not assuming anything. It's just we don't know that it complies with zoning.
Speaking to your point, as far as the derelict streets, you speak to it. The one thing I would say, and one thing that we would agree to for this particular application, and we've had our discussions over applications like this. But I actually think that it's a wise choice by the board, and I agree with the fact that these restrictive declarations get filed and go onto the public record to know that these streets are maintained by a homeowners association or a private group, and that these, the property owners. So I think that
What about double
that's a
parking?
smart change.
What about the, NYPD doesn't have authority to ticket these on a private street. They doesn't have authority to ticket these homes. The fire department would have to go and find the owner of the vehicle to ticket them. I just spoke to the fire department about it.
For tourists, we had a restricted declaration which made the homeowners association the responsible agency that the fire department could serve for parking
Okay, and
violations.
what about NYPD?
Well,
They have no authority.
They have no authority.
Something like that, they wouldn't be doing the ticket. But the fact is, to talk about this, and I want to speak quickly to Commissioner Chanda's comment about the 34 and the 38-foot road. I would say that the 34-foot road is what's required. It does meet the private road requirements. I did hear your comment about the 38. To speak to that, okay, we were in active discussion with the fire department up until this Friday, and the fire department provided a plan to us that said that they were satisfied with this design, provided we provided a few no parking corners. So the fire department, which I would argue is the most important agency with respect to the width of the road, had no issues with these 34-foot roads, provided that there were certain no parking areas that were set forth. So I would say that. I would also say I understand that the fire department issued a letter this morning. We were surprised by the abrupt change of position by the fire department because there had been active discussion with them, and we submitted a revised plans pursuant to their request on Friday. And we're expecting it to be reviewed. And I realize it's short notice now, but for the next hearing when it's scheduled, we would actually request that the board have the parties of the fire department who wrote that letter be available here to testify, to speak to the reasons, and to give clear points as to, first, why they had the abrupt change of position, but also, I would also like to have the fire department here available to speak to what they believe would be the tangible difference between their agency's review at this level or their agency's review if it were at the city planning.
So fire department doesn't have to account for itself, but however, you focus on fire department because they're the main agency that participates in these hearings, right? I focus on the Department of Transportation, the Department of Parks, the Department of Environmental Protection that handles the sewers, all of those agencies, not to mention runoff issues that we talk about at each one of these hearings where DEP doesn't get a chance to look at these applications at all, and all of those agencies get involved in city planning actions. They sit around a table, they have a system set up, and they review these applications in depth, and DOT then gets a map street where it requires that the street be developed according to its standards. It can enforce that, and DEP manages the utility system and can enforce and come in and repair. And when the homeowners association doesn't even, because we experienced this on applications that you know of, people don't even know they just bought a house that doesn't have any rights to basically anything, and that they have to pay for the improvement that's in front of their street, not to mention the entire water main that's traveling along whatever cupidity or something like that, which might be a very expensive water main to maintain.
Those individuals purchase property and don't have proper representation, then that's on those.
We're nowhere close to this at this point, because we still haven't passed the jurisdictional bar here. There is no hardship. So talking about whether or not the street's going to be wider is irrelevant. This case should not be before us. It's not meretricious of this waiver, of this very tailored exception by the case law.
Right.
It doesn't fit.
If I understand your position, though, it's not a jurisdictional issue because the board does have the ability to hear this. Your position, though, is that the finding is not met.
Correct.
So
it's not jurisdictional. It would be a decision that you're making saying that the unnecessary hardship has not been met.
Okay, so it's a finding.
I think that's an important.
Yes. Okay.
Okay, it's a fair distinction.
Well, it's also what is the finding hasn't been met, and what is this waiver intended for? Who was this intended to relieve? And it's my belief that this was never intended for a project like that. And if it has been applied by this agency in the past, that's a shame because it created difficulties, right? And as you know, over the last several years, the board has shifted away from allowing anything even close to that through GCL waivers.
And I would say that the board has recently granted other large projects, Taurus, the industrial loop as far as the length of the street. And what ends up
Don't count
happening here.
industrial loop, we just explained why that's not related.
And
all
we
right?
would disagree and say it's relevant because it's relevant with respect to the length of the street regardless of the buildings that are on it, because this is a map street law. The fact is that the board has granted these applications, and all of a sudden, this application is deemed to possibly not meet
That's
them.
not true.
And I would say that that's an arbitrary decision to say, where's the cutoff as far as the size? There's nothing in the general city law, there's nothing in the zoning resolution that speaks to the difference in the size of a lot with respect to the development and the review. So for the board to all of a sudden say that this particular set of applications, and I want to specify plural applications, that this set of applications is no longer within their purview, it's an arbitrary decision to decide this one is too much and this one is too little. And
To correct the record for the benefit of the court, it is not a shift of all of a sudden. The board for the last 4 or 5 years has been looking at the effect of large-scale GCL waivers, even not so large-scale GCL waivers, and has pulled back and has imposed more and more restrictions in the cases that it's approved to try to eliminate the misuse of this GCL waiver, and is actively pulling away from granting them on large projects.
That's fine.
This being the largest that we've seen in the 4 years.
we would
5
say
years.
it's fairly clear to be arbitrary on our side, and I understand the board's position.
Okay. All right.
As far as changing the size.
So I think
You know-
we're ready for public comments?
If I
right?
just, I
Yeah,
understand,
yeah.
we'll come back. I just want to say that, there were some very specific items that were raised, and I just want to clarify that in addition to the hardship items, that will provide a revised statement. We're going to provide the theoretical BPP typical of their sites. That will provide the restrictive declaration. I'm trying to remember some of the others, but we'll go through the list. We've done enough of these applications to know the typical materials, and we'll submit those copies to the record. And I realize that that's separate from the larger issue that's being discussed, but we will. put them
So
in the
like we
record.
do on variance applications, if you haven't made the A finding, not sure we really need the B through whatever, but your choice to submit them.
It's fine, we'd
Okay?
like to have it in the record because I think it's important.
Okay, thank you.
Fire department first?
Yes, please. No, they don't, doesn't need to. They submitted a letter this morning requesting, sorry? And I just want to add, because it was added to the record today and yesterday, that we have submission from Assemblymember Cusick and Councilmember Rose opposing the project.
So start with the members of the public?
Yeah.
Okay, one by one, you can come up, you have 3 minutes.
We don't have representatives of elected officials? Yes, we have.
I'm sorry, I
Okay.
apologize.
Yeah. First, please.
Elected officials first. Just please state your name for the record.
My name's Robert Morgan, and I'm just here to read Assemblywoman Nicole Malliotakis' testimony for the record on this project. Assemblywoman Malliotakis represents the communities that are impacted by this project. Nicole says, "I am testifying in unity with my fellow Staten Islanders and other elected officials and urging your board members to vote no in the Savo brothers' request for a waiver of the ULURP process regarding their application before you. ULURP stands for Uniform Land Use Review Procedure. The ULURP process is an important one as it reviews and weighs the concerns of the community and that of the developer. To consider instead a waiver of this process simply because the developers are claiming a quote hardship in complying with the process is a contravention of their own previous testimony on this issue. The Savo brothers propose you're granting a waiver to build units not fronting on a legally mapped street, contrary to General City Law 36 R3-2 zoning district. This quote hardship waiver undermines reviews in place through the ULURP. It also undermines their original testimony that environmental issues would be brought up at a later date. That, quote, later date is now, and meaning when their testimony said this was in previous litigation on this issue. The waiver would also allow the developers to build units not fronting on a legally mapped street. If allowed, this, quote, hardship would really be on the backs of residents of this proposed development who would be financially responsible for the costs of maintaining their streets as well as paving, snow and garbage removal, and sewer maintenance. In the brief by the Savos Brothers, Inc. and Mount Builders, LLC, Attorney Jeremy Panzella Esquire, in the Appellate Division Brief, case number 2014-01124, page 25, he states, and I quote, "In other words, until Mount Builders, LLC seeks permission from a state or city agency for required permission to do something with the property physically, the environmental effects of the requested change cannot be possibly studied." So here their attorney is saying that this very process, which they're seeking an exemption from, would be the opportunity for the type of review that's needed here. And now they're changing their position from the appellate court case. However, they are now abdicating their own position in hopes of eliminating all review and further development of this property. They were aware from the onset that a project of this magnitude would be scrutinized by the community and its elected officials. Shame on them for seeking this waiver and ignoring the devastating effects on the community and the neighboring properties, the impact on our schools and other vital services, without an iota of regard for the very process that would ensure a public review. I implore this board to rule against their waiver request and allow the necessary process of review to continue.
Thank you.
Thank you.
Just to clarify, because I do want to correct the record, this is not a waiver of ULURP. That's not what this is. This is a request to waive the requirement of General City Law, Section 36, that requires a building to front on a map street. The alternative in this case is to go to city planning, if they wanted to develop something like this, to go to city planning and either pursue what turns out to be an authorization or a special permit under the large-scale residential development rules, or a mapping action. And maybe you need to do both. I'm not sure exactly how that works. So, so just to clarify for the record. Thank you.
Anyone else from the elected? You are sitting from the elected? No. Okay, so we can go.
Okay, so members of the public, you can come up one by one. You'll be given 3 minutes to speak.
Okay. And authorization still goes to city council? I don't think so. No. So then I have to correct that.
Please state your name for the record.
Sorry. I also just want to add something. The comment made about how we would be forcing the applicant to go to a legislative process. An authorization is not a ULURP action. So a large-scale residential development, what?
So, may I?
Yeah, please.
So a large-scale residential development, there are two, there's the major and the minor, but in this case,
Probably major.
it probably will be major. If it's a major, then it's a special permit. A special permit will go through a full ULURP process, whereas if it were considered to be minor, it may not require a full ULURP. However, it would require a review at the City Planning Commission.
Yes, but then it's not a legislative act, as is being stated. It's simply an administrative body, the so-called executive act.
Whereas a
Sorry.
mapping is a full land use action, a full ULURP action.
Go ahead, sorry.
My name is Mary Bullock, and I'm a member of the Protestant Dutch Reformed Church on Staten Island, a congregation that dates from 1665 continuously. Staten Island has deep roots, and even though we're on the North Shore, we care about every inch of the island, and that's why I'm here to tell you that we support this group. Also, the St. George Civic Association, the Van Duzer Civic Association. We were at our location for 94 years before George Washington came through and recruited Joshua Merzero to be his first spy in the Revolutionary War. Every Staten Islander cares about every inch of our island. And I fail to understand why someone would want to make a few extra dollars by doing disrespectful development. We owe it to our posterity to pay attention to the laws that have been set in place for the common good. Thank you.
Thank you. Next speaker, please.
My name is Barbara Sanchez. I'm a member of the Committee to Save Mount Manresa. I'm also the president of Narrows Crossings Condo, which borders the Mount Manresa property on Narrows Road North. The Saville brothers have been horrible neighbors, and they haven't even started to build. Their first show of aggression was their destruction of the beautiful grounds of Mount Manresa. Can you imagine feeling your home shake as ancient trees crash to the ground? Hundreds of huge trees. Workers taunted us and made lewd gestures with their chainsaws while we watched in horror. This assault went on for days. The Saville brothers knew the trees were important to us. They left the carcasses strewn across the property. It looked like a war zone for a year. Then they poisoned us with deadly asbestos. Mount Manresa's historic buildings could have been incorporated into a beautiful community development, but the Savilles wanted the buildings gone quickly, so they couldn't be landmarked. They submitted falsified asbestos documents to expedite their permits, and they started demo. They knowingly exposed me and thousands of others in the community to deadly asbestos dust. The Saville brothers didn't care who they hurt, elderly in the neighborhood, kids at the bus stop, or people who walk past the property to go to work every day. That asbestos dust is still there on the grounds of Mount Manresa, waiting to be stirred up. Now we see the building plans from Mount Manresa and this hardship waiver request. You would think they were building an isolated town in the middle of nowhere, but they're not. This is Rosebank, an established, densely populated community. I'm personally concerned about what happens to my condo's retaining wall once they start taking down the glacial hillside. If they've taken this structure into account, I doubt it's to my condo's benefit. My second concern is for my future neighbors. How will they afford snow removal, sewer pipe, and street repair? What happens if the ambulance or fire truck can't get past the double parked cars on their private road? What about school seats? And the sewers? When we have a storm, will all the runoff go into the homes of the neighbors on Fingerboard Road? My third concern is the traffic. Fingerboard Road is a skinny two-way road that takes on traffic to and from the Verrazano Bridge. How will this large development impact Staten Island from its most vulnerable and critical location? There are too many questions on the impact of a development this size and in this location. There needs to go through a review process, which includes an environmental review. I urge you, deny this waiver and require that the Savilles go through city planning to move forward. Thank you.
Next speaker.
Thanks for the privilege of allowing me to speak, and I'm very impressed by what you were saying today. I'm a member of Mount Manresa Committee, actually the president, and I lived in
What's your name, sir?
Jack Bolenbeck.
Thank you.
Okay, and I lived in the community for a number of years, and I'm fully aware of the problems at Mount Manresa, and it was a beautiful site, a bucolic site. No one in Staten Island is in favor of seeing that place destroyed. Nobody. Elected officials are united in not seeing that place destroyed. And this project is a disaster waiting to happen. I want to show you some. These buildings and the buildings on the other side, Expressway, were built back 25, 30 years ago. Things have changed since then. The highways are much more crowded, traffic congestion, sewer systems, combined sewers in that area. We have emergency vehicles will have to get access into these places. If they have private roads, if they avoid the Europe process, if they are allowed to, circumvent the rules that do exist to protect homeowners and protect the community, we're going to have a disaster on our hands here. Mount Manresa had glacial hills, beautiful trees that dated back before the Revolutionary War. One tree was 400 years old. They destroyed everything, cut everything down. They could have kept some of it. And the big tragedy was asbestos. We knew, the community knew there was asbestos in those buildings. The Sauer brothers definitely knew it because their investigator was arrested. But we wrote a letter to the borough president, and that's why the borough president named these streets appropriately, because it's well known on Staten Island what the Sauer brothers have done. But getting back to the asbestos, they knew about it, we knew about it. I have a letter I'm going to submit to you that proves that we knew there was asbestos in the buildings, and they did. Yet they had the audacity to demolish those buildings, getting permits from the buildings department, exposing thousands of people to asbestos, kids. We know what happened to World Trade Center. We know, especially a lot of people I know, sick from the asbestos. 20, 30 years later, asbestos, when it's in your lungs, it becomes cancerous. It can be. These kids were exposed, as Barbara said, what kind of hardship are they talking about? Look what they did to the community. I mean, it was a disaster what they did. They're talking about a hardship. They only want to make more millions. That's what their hardship is. And it has nothing to do with the community. If this project goes through or anything close to it, you have a disaster on your hands. I'm speaking with emotion, and I'm angry because we had to live with this. We've been fighting this for 6.5 years. And every time they have power, they have money. And what do we have? We're just a bunch of volunteers. We formed our own non-for-profit organization to fight this. And this is our last chance. We like to see if whatever they're going to build, it should be map city streets. That's number one. They shouldn't have any kind of variances or waivers. After what they did, they shouldn't. It should be strictly abiding by the law, going through the Euro process, and not getting, because they're wealthy, getting all kinds of double justice, where we have to be under one set of rules and they have a separate set of rules. So the community has to be protected, and the elected officials, everyone from Malitakis, Savino, the borough president, city council member Rose, Congressman Rose, are against this project. And I could go on naming elected officials, and the people are against it. So I'm angry, and I'm telling you right now, this project should not go forward as it is. There should be map city streets, and if it was me, I would restrict them to as little amount of housing that possibly can be built, because they're going to just make more millions of dollars. They live in Jersey. They're going to walk away from this, and we're going to be left with a disaster. We're going to be left with emergency vehicles stuck trying to get to a fire. Like I said, combined sewers that the infrastructure is so old. We have to look at this, look back, evaluate this very carefully, and go through the whole process. They should not be given a free license
Time is up. You have to
to
wrap
do
up.
what they've done. So I'm angry, and I'm telling you, it's got to be done right.
Didn't know you can't think.
And I have some documents to present to you.
Please. Yeah. Next speaker?
This is a picture of the dust cloud and stuff, and this is the letter we sent to the borough president. Can I just say one quick thing?
Your time is really up. If you want to submit more in writing, really be our guest to submit.
They know where to send it.
That letter was sent prior to the demolition.
Okay.
So we knew there was asbestos.
Is this your original?
Yeah, you can have it.
Really?
But we knew there was asbestos in the building because we proved it in the letter we sent it to the borough president, and we CC'd the governor.
Okay,
Right now.
Thank you.
Hi, my name is Corinda Longera, and I live about 1.5 miles away from Mount Manresa. And I want to thank the members of the Board of Standard and Appeals for giving us the opportunity to express our concerns. I'm here today in opposition to the appeal for waivers that have been filed with the Board of Standard and Appeals and submitted by the attorneys for the Savo brothers, AKA Mount Builders. I respectfully request that the BSA reject all appeals for waivers that have been filed by the Savo brothers to build 163 housing units that are not fronting on legally mapped streets, which is contrary to the General City Law 36 R3-2 zoning. By granting any waivers to this very large and dense development, it would not be subject to the Eurolop strict reviews and guidelines. Also, an environmental impact study would not be requested by the DEC. It is critical that this development be reviewed by all agencies involved, as it is a disaster waiting to happen. The developer has designed a community of densely packed and attached barrack-type housing units that could easily become fire traps. The plans called for a total of 285 parking spaces assigned to the 163 units. The statement of facts and findings claims a total of 473 accessory parking spaces will be provided. Assuming that number includes the 285 assigned spaces, the question is, where will the additional 188 vehicles park? The drawings do not indicate any additional parking areas to be used, and most likely these vehicles will be parked on the streets. The submitted drawing number BSA-10 Site Circulation Plan indicates Forberry Lane, Avedita Place, and Cupidity Drive will all be 34 feet wide with two-way traffic lanes, basically that will narrow down each lane to 12 feet in each direction. Also take into consideration large delivery trucks, maintenance vehicles, school buses, and additional vehicles parking and traveling on these roads. This will cause these roads to become impossible to navigate in the event of emergencies, ambulances, and fire trucks. The following fire code was revised in 2014 by the New York Fire Department. Excerpt from code. Roadway accessibility. The remaining changes to the 2014 fire code relate to firefighter accessibility. Since every second counts when firefighters need to get close to fires, the fire code seeks to...
I'm sorry, 3 minutes are up. Please wrap up.
My 2 minutes are up?
Three.
Oh, I'm sorry.
Very short time.
You could submit, you
In
could submit, if
closing,
it's,
thank you very much, and please disregard their appeal.
My name is Gloria Vistica. I live in Hills North Condo. Our condo is part of North Drive. It is adjacent and nestled in the hill of Mount Manresa, and our condo was built in 1979.
Just 1 second, please, until we can turn off the phone. Otherwise, we can't hear you.
That's someone's phone?
What?
Yeah.
That's a phone?
Yeah, that's the alarm. Press the button on the side.
There you go.
Oh, what?
Okay, I'm sorry, please start again.
Hello, I am Gloria Vistica. I live in Hills North Condo, adjacent to Mount Manresa off of North Drive. We also front on Narrows Road North. There are 102 homes there, and I represent my condo board, as well as the Friends of Manresa. We were built in 1979. We have very beautiful shrubbery and a few trees in our lovely condo, which was chosen by the homeowners as a safe and beautiful place to live, to raise our children. And we purposely moved next to a woodland area so that we would have the benefits of the beautiful trees and the health effects and to know our neighbors. Now, a nightmare occurred in our lives when one day all of these trees were felled. And how did we explain to the children what was going on, that our community was being destroyed? A sanctuary for all species destroyed in a day by people called Savo. And we then had the terrible health effects of asbestos contamination for 4 days, which we all viewed from our yards, and it was airborne for 4 days in this community of thousands of people next to a major roadway. And we got that stopped, but we know that it takes many years for the asbestos contamination to be revealed in your lungs. And also, all of this contamination is now in this land of 15 bucolic, beautiful acres that had been destroyed. So we come to you with our fervent desire that the people who committed these terrible environmental crimes willfully not be rewarded by any kind of waivers, and that they not be able to put hundreds of homes in an area which has low-density housing, single-family, and some attached housing, but next to very busy and small roads. We are very concerned for our children and our elderly and everyone who lives there, who believes in quality of life, being a moral person, doing the right thing, having nature sanctuaries nearby, which everyone needs for their mental, physical, spiritual, aesthetic health. And I think the city knows this, and I don't think that the city will grant any kind of waivers to these bad actors and these bad players. And by the way, in conclusion, the names of these streets mean lust for greed way, and that type of thing, okay? That's what our borough president named it, because avarice was the name of the game with these developers who have no concern for their community. I also don't see any buffer zones or any trees on any of these attempted maps, which are non-maps, because they don't want to map, because they don't really want you to know what they will be doing. They cannot be trusted. They are not legitimate business players. They deserve no credibility. That is my final statement.
Thank you.
Thank you.
Are there any other speakers? Anyone else, please?
Good afternoon, everyone. My name is Gabriella Velarde Ward, and I'm a resident of Staten Island. I'm a member of Mount Manresa for a number of years, and I'm an architect. I've worked as an architectural designer, as a construction supervisor, and as a resident engineer. Let me say this. That's not a site plan. That's a rendering. An architectural illustration, that's not a site plan. Let me also emphasize the fact that Fingerboard Road...
You need to take the mic with ma'am.
Oh, sorry.
Yeah, just take it with you.
Okay.
You can take it with you if you want to point to the thing, yeah.
That Fingerboard Road, as was stated before, is a very narrow road. In fact, I've been down that road many times, and if there is a bus coming down towards the south on that road, the driver going north has to get up on the curb. That's how narrow it is. The two can't pass at the same time. There are many, many issues with this. I only had the opportunity to review the site plan. That's all I reviewed, the one with dimensions on it. Oh, the other thing I wanted to mention is there's no context here. You don't see the homes, how close they are. You don't see the expressway. You don't see anything here. And that's what architects usually do when they want to hide something. I know. I took a look at the site plan, and I am very, very concerned, just from the site plan. Without any oversight by appropriate agencies, both the future residents as well as the community surrounding this very dense housing development will be placed in danger in a number of ways. I'd like to talk about water, since I only have 3 minutes, I'd like to just talk about water. The housing units were designed so densely that a large majority of the ground is hard surface, not absorbing water. My question, were there calculations made to understand how many catch basins there should be there? The way the calculations are made generally is by the size of the roof, the square footage of the roof, and that's how you know how many catch basins. Who's going to review that? That has to be reviewed. In this age of climate change, with torrential rains, and this summer in Staten Island we have had at least one or two, let me take this out. We've had at least one or two torrential rains all summer. Each week we've had one or two torrential rains. Now when you have a torrential rain, the water moves really quickly. And sometimes it skips right over the catch basin. You know what that's going to mean? It's going to mean flooding in Fingerboard Road. A narrow road, and it's going to cause a lot of traffic damage. And it's going to be very dangerous. Okay, and so without this permeable earth surface, where will the water go? My time is up?
Yeah.
Is that it? That's 3? Okay. All right, and I urge, there are a lot of questions here, and absolutely has to be reviewed, and this does not deserve a hardship. Doesn't.
Thank you.
Thank you.
Any other speakers?
How many more are speaking?
2 or 3.
2 or 3. 2 or 3? Okay, thank you.
Hi. I want to thank the
State your name.
Board of my name is Phyllis Zito. I'm a native Staten Islander. By the way, we've been together for almost 7 years now, this group. I don't know how many grassroots groups come before you that have existed for that period of time. And the reason for that, because maybe you haven't pieced this together again, Manresa has been the crown jewel, not only of Staten Island, perhaps of all of New York. That's what we're fighting. And it's another unusual thing is for Staten Island to agree on any one issue. However, in this issue, they have agreed. All of Staten Island wanted to save Mount Manresa and wants to treat it with the utmost respect. In case you did not know this, I mean, to be presumptuous, but Joyce Kilmer, he was a convert to Catholicism. He's known as the Irish poet. Although he was born here, he wrote the poem Trees. And if you'll indulge me, I'd love to read it to you, if I may. Because I was present when the trees were taken down. Horrible. Okay. This is Trees Kiln is a poem titled Trees. I think that I shall never see a poem as lovely as a tree whose hungry mouth is pressed against the earth's sweet flowing breast, a tree that looks up at God all day and lifts her leaves and arms to pray, a tree that in summer wears a nest of robins in her hair, upon whose bosom snow has lain, who lives intimately with the rain. Poems are written by fools like me, but only God can make a tree.
Any other speakers? Anyone else?
Hello, my name is Rose Bartelli. I just have a few comments. I live on Fingerboard Road. I know what it's been like since they destroyed Mount Manresa. We talked about water. I get flooded in the front of my house now. I live right on the corner of Merle Place and Fingerboard Road. When we have torrential rains or heavy rains, I'm loaded. The front of my house is full of water. It's all flooded. We have to wait maybe a day or two before it subsides. The parking is disgusting now. I can't imagine what it would be like after they build an unbelievable number of homes in that small area. Excuse me. Fingerboard Road is not Industrial Loop. Industrial Loop is out in nowhere land. This is my neighborhood. It's disgraceful what they want to build in that area. It's a hardship for the neighborhood. I don't think there are seats for children in the school. The hospitals are overcrowded now. A friend of mine was in the emergency room the whole night without a room, without getting into an emergency room in the hallways. It's unbelievable. The wind that comes down from that hill right now is, I have to hold my storm door with my hands to try and lock my front door because it's so windy right now, ever since all the trees and everything are gone. It's just a hardship for the neighborhood. I can't even get out of my driveway. The traffic on Fingerboard Road is unbelievable. It's a narrow road, as you've heard. It's one lane in each direction. If the traffic is unbelievable. If the cars are not coming from the left, they're coming from the right. You can't get out of your driveway, and you can't park. I share the driveway with my neighbor, so I only have the driveway 1 week. The following week, I have to look for a spot either on the hill and my husband, he's got emphysema, so he can't even walk. I have to go park the car, and we're not teenagers, as you can see. It's just unbelievable. Please don't grant them anything. They don't deserve it. They're just greedy builders.
Thank you.
Thank you.
My name is Loretta Drogan, and I would like to thank the commissioners for this opportunity for us to speak today. As my colleagues have commented, we have been together for 7 years. We are not a ragtag group of individuals. We are citizens that represent an unbelievable spectrum of the community of Staten Island. We have professionals here dedicated to their professions that have given of their time, energy, and valuable resources, not to mention their monetary input, have taken from their family's larder of available funds, personal funds, to pay for a city expert to do what needed to be done. I look at these people, they are now my family. I am a veteran educator of the City of New York of 34 years. I traveled over the Verrazzano Bridge for 34 years. I had to sit at the corner of where we are discussing in bumper to bumper to bumper to bumper traffic to reach my children. It will be an impossibility. We speak from experience. My children went to school at the foot of the Verrazzano Bridge and in Manhattan, but their elementary school was St. John Viller Academy. I know this area so well because my immigrant family came from Italy and settled in the community of Rosebank. It is dense. It is populated. My major concern, one of my major, is the children and the trauma of this community that Gloria spoke of so eloquently. We were traumatized by the voracious veracity. We're not tree huggers. We're not this weeping group of people who have to drink juice boxes because we're traumatized. We're not traumatized by that. We're traumatized by their greed and their avariciousness. And that is why the borough president and Assemblyperson Malliotakis and Congressman Rose and every elected official on Staten Island is nauseated by them. We are sick of their greed and the absolute, if I told you about all the people that we spoke to and the city agencies who would put their arm around the back of their chair and said to me, I can't name them here, what are you making such a big deal about? You people are ridiculous. It's a bunch of trees. And I quote that. When the commissioner came to, when the mayor came to the city of New York, he knows us by name. I have a dossier. He has my picture. He knows me personally because he's sick of hearing us bang this drum. It's wrong. This is wrong for the city of New York. Am I done? Thank you. And there are no school seats anywhere. I was an administrator in the DOE. There's no place for the kids to go to school, and there's no toilets to be flushed. There's no water. And I'm angry too.
My name is Janet McKee. I'm with the Friends of Mount Marisa. As you can see, I want to thank you very much for letting us come here and get what's on our chest, off our chest. I don't know if there's a final name for this project, but I will give you one. Hit It and Quit It Estates.
Are there any other speakers on this?
I think I'm the oldest one in this group. And I can't walk out.
Oh, wait, hold on.
Okay, let's get you a mic. We'll get you a mic because you can't speak off the mic. Yes.
You could sit down.
Thank you. I'll tell you why I can't stand up and can't walk. Because 19 days ago, I had cancer removed from the asbestos that the several brothers, we have been out there 7 years. Every weekend we're out there, rain, sun, cold, snow coats, everything, out there collecting little bitty monies to come and fight these men. These men are not good builders. They have done a lot of corrupt things. I live on that island all my life, and I don't like what's going on because this was a beautiful place. Here's a picture of what it was. And if you saw it today, as she says, she lives there. None of us knew each other 7 years ago. We are so angry and so sad of the destruction that these Salvo brothers have done. They don't care what they do. The money is all about money and greed. We've been fighting 7 years. Can you imagine 7 years of fighting? Oh, where they live. We know where they lived. They live in Colton Neck, New Jersey, the hottest place to be. I don't live there. I live here on Staten Island. I'm born in Aracar. That's where this was. Yes, okay, so I'm born there, staying there, I got my plot already, and that's where I'm staying, okay? So 75 years I've been living on that island, watching destruction. This is the worst. When you talked about the cars in the driveway, we'll drive down where the train track used to be, and you'll see the Salvo brothers' houses, and you can't put your car in the driveway, because it's hanging out. It don't fit. Nothing fits. They do whatever they want. They own the bank. They own the borough president, Mr. Molinaro. I'm sorry, Mr. Molinari, I have to behave. Thank you so much. Previous, he's gone, but he's still around. And what about his girlfriend getting her house fixed by the Salvo brothers? I had to say that today. All right, thank you. Sorry. And they don't care anyway, because they don't live there.
You've already spoken, I think.
Thank you.
So are there any other people who have not yet spoken? Okay. We're all here. Okay.
Not my plot already, don't worry, Sal.
Okay, please stop, please stop. Okay.
Thank you.
All right. Okay, so what I do, all right, calm down, please. I would like to correct the record. While everyone was speaking, I had a chance to look more closely both at satellite imagery of the actual site as compared to that site and the one that's on the wall there and the one that I have in our record. We had a discussion about how GCL 36 paragraph 3 allows an existing, let's say, in the event that there's an existing house on an unmapped street, or it's actually a CCO street, so one that has a corporation council opinion, or one where the BSA has granted a waiver.
No, I'm saying the one at the end, I'm sorry.
Oh, okay. Or where the board has granted a waiver, it's possible for a new house on that block to qualify as of right without coming to us. To obtain a permit and a C of O through the Department of Buildings. So it was stated that this site could take advantage of the same thing because there are already houses facing on Narrows Road North that may or may not be an unmapped street, and on North Drive, which may or may not be an unmapped street. None of the site faces directly on either of those streets. There's an intervening plot, very long one, facing Narrows Road North, and only intervening lots facing onto North Drive. And the only place where this lot, this 15-acre site, has frontage directly on Narrows Road North, it's not a part of this proposed development. It's where that very large multifamily would be. So it isn't actually possible. No, these are the intervening lots.
And then there's the green space, there's one finger.
Yeah, well, but the green space isn't fronting on Narrows Road North, right?
It is.
So,
It is.
But that wouldn't be the frontage that counts of having a building fronting on Narrows Road North. So let's not play with that, okay?
No,
so the building wouldn't be fronting on Narrows Road North, therefore cannot take advantage of an existing frontage on what might arguably be an unmapped street. Whether it is or not is not clear. And so I just want to get that out of there. It's not true that they could be legalized one by one, because none of them have frontage shared with existing houses with frontage. You do need to look at the site plan in the larger context, because that's cutting out the larger context of drawing. It is.
Sure, I don't disagree with what you're saying, but that wasn't the point that was made earlier, so I'm a little confused.
So
But that's
what I'm
fine.
saying is, unless GCL 36 paragraph 3
Yes.
works where you've got an existing either CCO street.
Correct.
Where there's a house that has a C of O that benefited from the CCO street, or an existing house fronting an unmapped street that got a BSA waiver, and then you can take advantage of GCL 36-3. Right?
Agreed.
As of right.
Agreed.
None of the houses that are proposed here, other than fingerboards, could do that. So, but you had pointed, when you were showing us on the map, you had pointed to the houses that are sort of have their backs to Narrows Road North, as if that was fronting on Narrows Road North that already has houses on it, but it doesn't front on Narrows.
That's fine. If I was apologies for any confusion there. The only point that was made there was that paragraph 3, the exceptions allowed that if one of these homes were approved with the CO issued, fronting on a Mount Pep Street, other sites within the block then would not need to get the GCL waiver. They could go directly to the Department of Buildings process.
But
It doesn't, the
only-
condition doesn't exist now.
Right.
But it could exist.
And only if they only ask to the street on which they front.
Agreed.
It doesn't automatically kind of vest all the other projects in the development.
100% agreed.
Okay.
I'm just saying that you could go one by one.
I just have a question regarding that. So let's say you build one of the houses fronting on Fingerboard, you're saying the rest of the houses can follow because...
Well, fingerboard is legal because that's a mass street.
Right, so if you build one of those houses fronting on Fingerboard, you're saying the rest of the houses can be built
This is
as
the
a front?
scenario. This is the scenario. Fingerboard actually is a map street, even though it's sort of an unusual title situation with the city. Narrows Road West is a map street.
Right.
They don't enter into exception 3. Where exception 3 would come into place is if this home, just pick one, this one, let's say, okay, which fronts here on Forberry Lane. Actually, this Forberry would be better. So if this home were built and this street were developed, so let's say we just developed this little U-turn here and this one home built, all of the rest of these could be built as of right straight at the Department of Buildings,
Under GCL 30.
under GCL 36. So you get the approval for this one, lot 146, the rest of these could be as of right. If you got this approval for this one and this street were developed, all the rest of those would be as of right.
Provided that that's what the BSA actually did. But what the BSA typically does is it looks at an existing street, it doesn't create a new street, right? It looks at an existing street and says, what's the condition of the existing street? Can you add this house? It doesn't say, oh, look, build a new street and put this house on it, and then add and add and add and add.
Right, and I'm logically trying to say, even if you were to take one of those streets, we would only provide you direct access from Fingerport just to that building. We won't let you build an entire loop so that in future you can add one home at a time.
But actually-
So even if you were to lay out the plan in a way where it would extend, if we don't approve that private road, we only allow it to, let's say that right at the tip of Finger and, not Cupidity and the,
Direct my finger, I'll point it.
let me just look at the map.
In any event,
That's fine.
exploit,
I just, you know,
To clarify how that thing works.
yeah, I'm trying to,
that exploitation of that loophole would
so if
work for
you
you.
go from Fingerboard,
Good.
go in, yes, go in,
Yes,
and right at the corner, that first house.
right here. Lot-
No, go further.
This one
in.
here?
No, go further, that one.
There we go, okay.
If you were to.
Lot 105.
Let's say you came in just for that.
Okay.
One house. We would only give you one loop around that'll come out, right? We would not be giving you a full length of that entire road that
Right.
goes all the
But
way. So yes, that's a hypothetical situation, but the reality is you've seen us operate and
True, but also, as far as building this, if we went to Department of Buildings, I would need to confirm, but the Department of Buildings might let us build Forberry Lane as of right, just like this.
okay. So at
It's a
most you
private
could
road.
build
Law,
this.
the spirit of that law, it was made for a different purpose. It was made for the unfair effects it would have on a single homeowner at the
Yeah.
end of a long block.
Right.
It wasn't made, and if you're saying, well, I can exploit this loophole, that wasn't the intention of the law, and if that, so if you found a way to use it incorrectly, there's nothing I could say to that. But that certainly wasn't the intent of it.
And anyway, that's the Department of Buildings domain, not ours.
Right, there would be Department of Buildings to decide that.
And that is the exact argument I had made in supporting the Teresi project. Teresi is that if we were to have individual lots fronting on Richmond Road, you wouldn't have these long super blocks when every property will have a driveway and you can build 5-6 homes at a time. This is what would result, and I wouldn't be supportive of that. I mean, the reason I thought that plan was good, because you had reasonable number of access ways to this development that allowed for a safe access and entry points and emergency accessibilities without being a drain on the existing street network, and that was reviewed by the city planning.
It was reviewed.
Which is lacking here.
You're right, no, it's understandable, but it was reviewed for, like, topography and.
But as part of this review, they do look at good site planning and subdivision. The whole part of that review was subdivision, and how do you do appropriate subdivision that allows for proper means of egress and access without being an undue burden on the surrounding street network.
Understood. Yep.
And topography, and this site does have a topography which though did not qualify under hillside special district or natural area or anything, but it does have topography, and that needs to be factored in.
Listen, that's the clarification thing. One point that was discussed in review session, I just want to mention quickly here, but we can also include it in the record. I know there was some question about like the number of tax lots and the homes and everything like that. There's also comments about these others. But just to point out,
Zoning lots.
it is 169 tax lots, one zoning lot. There are tax lots, and we'll provide the RP 602, I'll show you in a second, but this site right now is not part of this application, and this one is not. The Department of Buildings has not issued any objection for this because it does front on a map street, right here, Fingerboard Road. There is discussion ongoing at the Department of Buildings about this site as to whether the frontage on the map street or not, because Narrows Road is a map street, and more than 8% of the frontage of the building is here. It's under debate. Just to be very clear for the board, if and when this is not approved by the Department of Buildings and relief is required, we're not trying to hide it. We would come to the board and file, actually, more likely an interpretive appeal application as to what frontage is versus a GCL application. But if an application is required for this one before the board, we would come there. So
I am actually surprised that DOB does not have an objection to that multiple dwelling building at the corner of Fingerboard, because so far, the rough drawing that you have submitted of the site plan, the parking curb cut is well within 50 feet of that intersection, and which is not permitted.
I'll bring that point up to them to ask, but it hasn't been raised as an issue so far. As far as this curb cut, I'm not sure what the distance is or something like that. The other question too is I'm not sure what the status is of Merle Place as far as the intersection, so whether it's a map
Again,
street
as
or
part of
not.
good site planning, if you're building interior roads, some of these parking access ways can be from that interior rather being on the Fingerboard, which is a narrow road.
Sure, I just wanted to, and actually I'll pass this up now, I'll submit this, but just to clarify, this is the RP 602, and the 6 lots that aren't part of this, the tax lots, are circled in red, just to provide some clarification. But we'll submit that to the record as well.
Okay, all right, so then, I think we've heard everything. And we can set a date for the hearing. Close it without further.
The one last thing I would say before setting the date is, I understand what the board said earlier and what the chair said, but with respect to the fire department and the Department of Transportation, who have issued letters, the fire department abruptly and the Department of Transportation, we would request that the board ask representatives from DOT and the FDNY who wrote the letter to be here to speak. It's been done before for prior cases. I know the board has exercised subpoena power before in certain cases, but we think that it would be fair to have them here for a few reasons. Number one, we would like the reasoning behind their decisions as to why they don't believe that these can't be unmapped and why they be mapped. Number two, we believe that it is appropriate to be able to ask them what the difference in their level of review would be before ULURP city mapping action and also this GCL action. And we do think that it's appropriate, so we make that request. You've heard the request.
It's not our standard to require that 8 other agencies come and justify their decisions. We often have DOT comments. In fact, it happens a lot with our schools. DOT often submits comments about schools, and we listen to the comments. We ask the applicant to comply with the comments. We don't ask DOT to justify their position. We rely on them as an expert agency to give us an opinion. Same with fire department. We don't ask fire department to justify its decision. Sometimes we ask them to help us understand, but we don't ask them to justify it. They're firefighters. They know why they need these things to be done this way. So I'm not offering to sort of expose other agencies to contest and so on. They have their expert opinion. They're entitled to it, and they issue it in the form of letters.
And just today, we approved an SOC project that went through a rigorous DOT review, even though it was not required, and DOT's review process has changed from the last time, and they had to abide by the new DOT review, and they did. So the fact that an agency changes its review process and requirements during the
Course of the application.
It is what it is.
Understood. We make the request. I would say this is not a standard application, and also that the explanations in both of those letters were very lacking. It was just, we'd like these streets to be mapped with no grounding or reasoning. So that's why we make the request.
This isn't a place to depose the city
And that
agencies.
request was made in 2017.
Which the letter from
DOT.
The letter from DOT is 2 years old, actually.
So maybe they want to update it. We're happy to get an update, because
I
I
think
think
the
actually
update
more
may not be
information
in
for
your
you
favor.
is just as helpful to us as the board deals with applications
If
this
you
time.
want to reach out to DOT, be my guest. But we're not about to ask them to
We've had
appear
great
here.
success, as evidenced by the South Avenue applications.
Right, so as you can see, what's this about? Oh, no, I don't know what this is.
So these are the ones that are clouded are the ones that are not.
That are not subject to this 163. 2 of them are the larger buildings. The other 4 remaining are just street bed tax lots that would not be
Is that
sought to be
Pascal
developed.
Court?
Yes. No, Pascal. Yeah, Pascal Court is one of, so I just wanted to,
This one?
there was questions regarding the statement saying there was 169 tax lots, but only 163 applications, and I just wanted to clarify.
How many total
what the
units
other
is
6
there?
were.
How many total units, including those lots?
There's,
Including the multiple dwelling.
I don't know off the top of my head what the units are in the multiple dwellings. I can find that out. I'll make
It's
it.
apparently 90 units in the big building.
Yeah,
I don't
90,
know,
10,
and
10,
10 in the smaller building.
as per the drawings.
Yeah, okay.
I'm sorry.
As per the drawings that you've submitted, it's 90 plus 10 and whatever is in
I
there.
can ask, but as I said, we believe that those are as of right, so that.
And I think we do need to know that the total amount of units that are being proposed on the entire zoning lot to ensure that the street network can
And I would
accommodate
disagree,
that.
and this is why.
We're done.
Because this site is not accessed by any of these map streets, and this site will not be accessed. So this interior streets right here, this is the entirety of the lots that are going to be affected by those streets.
Are you saying you're refusing to give that information?
I'm just saying that it's not pertinent to the particular
Are you
application.
going to provide that information?
We'll
to-
consider it.
Now you're sounding like DOT.
I'll applaud that.
So, no, but okay, so we'll have a continued hearing.
How much time?
Yes.
Madam
as
Chair?
far as the
Madam
submission-
Chair, can you pull the microphone towards you?
I'm sorry. Yes.
Now, just to understand, as far as our submission, we're going to supplement the standard materials, but we're also primarily going to submit information with respect to the threshold issue that was discussed as far as unique hardship. As far as
And
our
also,
purposes,
sorry, just to go back to the statute, whether the circumstances of the case require the buildings to be related to the map street. So that's the second part after.
Right.
It says where, practical difficulties, et cetera, and where, so address all of that.
Sure. Okay, yes. So we'll include all that information. As far as our purposes, trying to think timing-wise, the theoretical BPP may take a little bit longer. The restrictive declaration, I think, is done, statement. I mean, we can be flexible, and I don't know if the board wants more time, but I don't think it would take us terribly long to submit. I know that there's notice requirements for the next hearing. We could probably submit in 3 weeks, but we could push it back a little bit. My only request is that we don't do November 26th. I'm not going to be in here, so I prefer to be a little earlier if possible.
Earlier than November?
There's November 19th. Is there a hearing on the 19th? I just know the 26th. I think it's appropriate to be here.
Okay. So November 19th with an October 30th submission.
October 30th?
Yes.
Yeah, so for the understanding of the public, so we're going to have a continued hearing on November 19th. It'll be also in the morning session, but as you can see, sometimes we don't know exactly when that is, and morning isn't necessarily morning. And they will be submitting materials, if you wanted to check with the board office, or it should be, a copy of that should be submitted to your community board, and to the borough president's office.
And the council member.
And your council member, so either of, any of those offices should be able to be available to show you what the submission is, and we will continue the hearing. But I
just
do
wanna say-
want to underscore that, like on a variance application, first you have to meet the A finding, right, before there's relevance to the rest of the case, and you've heard the opinion of all the commissioners with respect to that finding, okay?
And I would advise, or counsel advise council to provide the information requested. Similarly, in Brock, where the denial of information requested was a reason in and of itself to deny an application. I know you said you're familiar with the case as your office handled it. The lack of forthcoming is about being forthcoming with information that's...
Speak up, sorry.
The lack of you being forthcoming with information that's available to you says a lot more than not giving it.
But there's nothing that's been requested we don't provide except for when we discuss this mural and this other building. I also don't know how far development plans have gone for those, so they may not be available because they are being treated as separate lots and separate things. So understood, acknowledged, but there may be limits to what we can provide for sites that aren't part of the applications.
But, so that's part of it, right? So one of the reasons that this should be a city planning action is where DEP carefully reviews impact on sewer and storm systems. And in this situation, where it's being broken up into different projects, DEP cannot be aware of the impact on storm and sewer and other utilities. So I left out Con Edison. Con Edison gets involved in city planning mapping actions, right? So what are they supplying? How many units do they have to be preparing for? Can their substation handle it? This is a lot of units, right?
I think
and
it's
so that's the whole point, that sometimes you have a project that's far too large to be considered piecemeal, first of all, or to be considered under an application like this.
And I would add to that, the street network also, how the leftover portion of the zoning lot will be well served by the lack of access that is going to be not provided, since we are going to review some of those other projects in isolation. Maybe a better access can be provided from the Narrows Road with combination of finger and not just relying all on fingerboard. Fingerboard, I'm sorry. I'm just...
To clarify my comment, the only thing is, since I don't have access to it, and our office had nothing to do with those applications, I don't know what information is currently available, but we'll research it.
But your client has access, because your client is a developer, and so your client needs to cooperate.
But if this was done in stages, it may not be done to the same level as the rest. That's all I'm going to say. I don't want to make a statement one way or another as to what can be provided, just, I don't know.
Okay. Your client has the option to do whatever it
That's fair.
chooses, and we interpret it accordingly,
You
right?
wouldn't make a statement about something you didn't know, so I don't know, so.
Right, okay. Okay, thank you very much. Thank you, everyone, for coming. We appreciate your comments.
Thank you for listening to us.
Okay, do you want to take a break?
Yeah, let's take a 10-minute break. What did you want to do? Just
Just
vote on
do
the
the decision.
reschool? Can we just vote on this reschool?
Just do
Vote
the
on this?
vote on the reschool.
Okay,
Yeah.
also the second poll wants to come back after the break?
Okay, yeah.
All right, let's get, ladies and gentlemen, the hearing is still continuing. Can I just go, okay, I'm sorry. Item number,
We're going to take a 10-minute break because that's all, but we sort of had a lunch break.
That's why.
item number 16, 2019-34 BZ 2527 East 24th Street.
Well, so let's go, if you need to get some more food. All right, what do you want? You want 20 minutes? That's fine.
I can eat it at the table, I'll just.
Okay. Okay. All right, I'm so sorry.
I am so thankful.
Please, sorry, we need to clear the room, please. Please, our hearing is continuing, so please exit quietly, okay? Okay, sorry, go ahead.
Jody Stein for the applicant with Herrick Feinstein, Land Use Council.
Okay, so we did close this, right? So we did get the submission from fire department and everything was revised, thank you very much. So I would like to make a motion to grant, and I don't think there were any conditions, right, Chase? No conditions, okay. Motion to grant, no conditions.
Chair Perlmutter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Shetta?
Aye.
Commissioner Shabeta?
Thank you.
Thank you.
Thanks for your patience, sorry.
Okay, we're gonna take a 10-minute break? I know. Okay, good, okay. 10-minute break.
We're gonna take a break. Yeah.
I'm just saying.
Is 10 enough to go get food?
Yeah, I'm just
Yeah?
gonna
Okay.
run down the street.
Okay,
We asked them.
Mike's on? Mike's on?
And
Okay,
the
ladies and
answer
gentlemen,
is?
back on the record, Board of Standards and Appeals public hearing for September 10th, the zoning calendar. Second call item, item number 11, 14014A, 1016 East 13th Street, Brooklyn.
Thank you. Come on. Names.
Elise Fullader again from Eric Polanic PC. Worked with,
Spiro Malkotsis, representing RBM.
and we tried to put in as best as possible what was originally proposed, what's the current permitted zoning, thank you, getting a little tired, so are you, I'm sure, and then the differences in what the loss would be, but ultimately, there would have been required 2 side yards with a minimum of 8 feet, and now we don't have any side yards, so the whole building is kind of a loss, but we tried to break it down through the different, these were all the, what's permitted and what's current, and we broke it, what would change, what would be the loss in each of those different scenarios.
And the loss is based on what? Income loss or construction cost?
The construction cost, based on $300 a square foot to build, what we've built already, and what we would be losing based on what we've built on the cost.
So what you built already at $300 a square foot, you have
Correct.
to lose, plus the demolition cost if it was
Which
even
would be
possible.
even more. I didn't calculate that in there. I didn't think it would be needed.
That's assuming you could actually demolish, because you're talking about shaving off the sides.
It would make the building useless. It would have to entirely come down because the way that building is set up, the stair and the elevator are in the center. So we would have no, area to occupy other than that.
And it's a 4,000 square foot lot, so it's like.
It's a 4,000 square foot lot.
It has a 40-foot frontage.
Correct.
I just have a quick question. You have 2 lines. What are the first 2 rows? The first one, you see 2.69 FAR total and then 2.15 FAR total. What is
So in the resolution, it broke it down by total FAR and then what's permitted in residential FAR. So 2.69 is total, and the 2.15 is what was permitted residential.
Oh, and the balance being commercial or something like that?
Yeah.
Or community facility?
Yeah. So I showed kind of both scenarios.
Does this building have a community facility component? It does. Oh, okay.
It's approximately 3,000 square feet of community facility on 2 levels.
Okay. Okay, so the building was 15 feet too high, covered too much of the lot. Yeah, okay. I think that's
Too
good,
much
no?
FAR.
I mean, yeah,
I mean,
it'll do.
It's like a demolition of a building that's up, that's 95% complete. I
Sorry,
mean-
we would have done something bigger if we had more time.
Yeah, okay.
It's
Well,
fine.
But in future, for your future applications, because you do a few of these,
Yes,
right?
we do.
There always needs to be a serious loss.
Okay.
Analyzed based on today's loss, not loss from whenever the last time you were here, right? Okay. Right, was this actually submitted?
Oh, I didn't set, if they're approximate numbers, should I submit it? It's like really approximate.
Why not submit?
Sending it to submit, right?
I can send it to submit.
You're sending it to submit.
Yes, I'm sending it to submit.
Sending it to
I can
submit.
walk off the stage and send it to submit.
Okay, so is everyone good with this? Is council good with us doing it like that? Okay, so it will be sent to submit, so I'd like to make a motion to close then.
Chair Perlmutter?
Aye.
Vice Chair Chanda? Aye. Commissioner Otley Brown?
Aye.
Commissioner Sheta? Aye. Commissioner Shabeta?
And a motion to grant.
Chair Perlmutter?
For 1 year. For 1 year.
Chair
Aye.
Perlmutter?
Aye.
Vice Chair Chanda? Aye. Commissioner Otley Brown?
Aye.
Commissioner Sheta? Aye. Commissioner Shabeta?
Thank you very much. Going to send it to submit.
Thank you.
Okay. Zoning continued hearings. Item number 17, 26814BZ, 2310610 Northern Boulevard, Queens. They're requesting an adjournment and they're asking for sometime in June?
What?
9 months.
What?
Well, that's the letter I received today.
So this is the third adjournment request in a row after 2 postponed hearings and last heard in November of last year.
Well, they're-
So we're going to be sending them a dismissal warning, and to next year in June doesn't make any sense. That sounds like they're another one of those applications where they
Well,
don't know
here's
what they're
they said.
doing.
We previously requested an adjournment of the September 10th continued hearing for the above referenced variance application. We are submitting this follow-up letter to request a continued hearing dated in approximately 9 months on June 2, 2020, or the next available hearing date. We understand that this is the final adjournment and want to ensure that the applicant and the project consultants have sufficient time to prepare a comprehensive revised application. This revised application requires the preparation of a new supporting materials, including economic analysis, subsurface containment reports, contamination reports, and an updated environmental assessment statement. Josh Reinsmith.
Need I add that the last time we heard this was in November of last year, so that's an adjournment of a year already. So that sounds to me like a basically dead case. And we should put it on for soon, like the end of November, which would make it happy anniversary, and then dismiss it for either on the merits or failure to prosecute, whichever one is right. Because we can't keep doing this where it's an indefinite application. Either you're serious about making an application or you're not.
Well, then the submission date, if you do it November 19th, and the submission date is October 30th.
Well, we could do November 26th.
26th.
Plenty of time to do whatever it is they think they're going to do, or just withdraw the application, which would be the best. That way, they could come when they're actually ready. Come back in June of 2021 with an application that's ready. Because I don't know what they were doing here. They postponed it twice and adjourned it twice and only heard it 2 times a very long time ago.
All right, so we're adjourning it to November 26th?
Yes.
Okay.
Yes, with a November 6th submission.
Thank you.
November 6th submission, last time with a letter to owner and representative.
I'm a
Doing
little
letter.
surprised by that lengthy timeframe because they have already done the traffic and parking demand analysis and DOT has reviewed it. So if that was going to be the long review period, I could have understood that, but that's done. So based on those assessments, they just have to revise the drawings. The environmental review, they had already done quite an extensive, so.
Yeah, that's what's in their letter.
What would be done would be some.
So
just
what's going on is
fill in the gaps.
sale of the property, reconsideration by the owner about how they want to proceed, and they're asking us to be patient while they figure out what they want to do.
Okay.
It's very obvious. So we can't do that. Okay.
Okay, so November 26th. Okey-doke.
And submission date?
Would be November 6th. Item number 1817-15BZ, 133 Beach Fifth Street, Queens. You don't have to be sworn in. You withdrawing the application?
Yes. Good afternoon, Lear Altman from the Office of Lear Altman. We request a withdrawal without prejudice.
All right, though, that's the right thing to have done. If they want to come back when they figure out what they want to do, then so be it. All right, so then I'd like to make a motion to withdraw.
Chair Perlmutter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Shetta?
Aye.
Commissioner Shabbat?
Thank you.
The application's been withdrawn. Where are we? Oh, sorry, backwards. Item number
19.
7715BZ, 24436 85th Avenue, Queens. There is a request to withdraw this application.
Jay Goldstein on behalf of Rothberg Inspector. Request to withdraw without prejudice.
Thanks. So motion to withdraw.
Chair Perlmutter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Shetta?
Aye.
Commissioner Shabeta?
Thank you.
Thank you.
So 456. Item number 20, 15715BZ, 3925 Bedford Avenue, Brooklyn.
He submitted, there was a submission.
You want to be sworn in? Yeah, that'd be good. Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond to board member questions? Of course. Thank you.
Hello again, still Lear Altman from the Office of Lear Altman. We had somebody attend your executive session yesterday, heard your comments. We made a submission based on those comments. Subsequently, it was brought to our attention that there was no revision date on those, and we had missed a signature and seal on one of the plan pages. I already have a revised set of existing plans and proposed plans with a revision date on every page, and I confirm that every single page is signed and sealed. I apologize for missing that on page P103.
So wait, so the revision date is?
I have it in my phone. I can hit send whenever your board is ready. It was brought to my attention during the hearing this morning that had happened. I'd already made the hard copy submit and everything.
That's not what was submitted
No.
earlier?
Last night, before 5 o'clock, as requested, I had made a submission. I brought the hard copy into your board this morning, prior to hearings. When I came to the hearings today, it was brought to my attention that this was not on there, and I immediately requested that it be taken care of. The one seal and signature that's missed and the revision date.
Sorry, we don't do that. Had too many bad experiences with what is technically a bait and switch.
Oh, no.
We don't do that.
That's fine. If we want to stick with the plans, I am fine with that. We submitted plans and we stand by those plans that we submitted. It's missing one seal and signature.
This one says the date on it is 1/4/15.
That's why it was brought to our attention
How are we supposed
by...
to know that that's the last set of drawings?
That's why it was brought to our attention. I gladly reached out to the architect and asked him to please send me the identical set with those two minor changes.
The only thing I can say is it's stamped 9/10/19.
Oh, Henry.
It is clocked in.
Henry emailed you?
No, actually, Assistant Counsel Devine was kind enough to inform me, and I gladly took care of it immediately. But it was stamped in this morning, hard copy to the board, dated today, for the record, dated 9/10/19.
Means we're reviewing it on the fly and we don't.
Well, the set that was submitted yesterday was hard copy stamped today, so if that's a concern, it was hard copy stamped with today's date, although the revision date's not on there from the architect.
Say again, what do you want to see the existing?
plan? I have a question on the revised existing plan. As I understand it, you were able to identify floor area in the attic that is not counted towards
The architect
flooring.
was, yes. May I show you
mean
where it
your
is?
team? Yes, and I had a question because it seems like it's the area that is crossed out. And what is there? Because I'm trying to understand it from the existing section as to what actually is the height.
Let me show you.
Here, that's it, that should be the existing.
Yeah, if you go to...
Height?
Yes. Go, it's this section that is excluded. So...
This area right here that's
yes,
under 5 feet,
and
and this area right here that's under 5 feet.
So is this also then under 5 feet and that?
That's a closed space that was not included before. This unaccessible space was never included in the floor area. This space was where there's an X.
So my question is the roof line here same as?
Let me just...
Because from the...
If you look, there's a dorm, it's somewhat of a dormer style right here.
Okay.
Right here is the ridge. It comes, let me see if I can hold it up so maybe you can see it further.
Because this is part of the same, it falls under the roof line.
This is where, I was trying to hold this so we can actually see through. If you see right here, this is where it's at its highest point, and then it slopes down as it goes this direction. I was just trying to show through the page. You can
So
see
according to that, on the far corners on the back also should be out.
Those are
And they-
inaccessible, and those were actually never included.
No,
So
I
then
mean,
Chair's
those
point is
also.
then what about those areas?
Those were never counted in the floor area. The areas, this was counted, and this was counted because it wasn't a closed-off space, but technically it actually doesn't get included under 1210,
Shouldn't this whole thing be?
which is why it was reduced.
Okay. That's the question I had.
Okay. So I just want to go through the comments and make sure that they were all responded to, and then we can talk about whether we can just accept it with a stamp, a receipt date. What you submitted, you didn't submit it yet.
It was submitted, hard copy this morning, electronic copy yesterday, which is what you have right now. I do have another
Just
set
doesn't have the revision date.
Or the architect's seal.
on one page,
Oh, it doesn't have the
P103.
seal. You have to have the seal.
On page P103, it is missing the seal, and I said, when he approached me, I said I'll be glad to get it, and I just received it today.
And what do we do about the fact that the approved plans from 92 show different side yards?
We
And the
haven't been able to
survey?
confirm anything. Unfortunately, that survey, as you stated yesterday, and you're correct, is very difficult to read. I asked the architect if he could please go back to the Department of Buildings, get me a better version. His statement to me was that's a blowback from the DOB system. He said there is no better version, he can't get one, it came right off of the microfilm. That's the best version he has and he could get for me. And I shared that email, of course, with Assistant Counsel Vine today as well.
Opinion about, well, we don't have signed drawings, so we can't use the not signed drawings. And I don't like the submission that we can't review. So I would have to say we have to,
We have one page that was missing, unfortunately, the seal. Every other page, of course, has it.
yeah. And so, one more week, we're putting on a lot of stuff for next week. I don't like that. But I'd ask Chase to compare the set that was submitted yesterday to the set that's submitted this morning. Make sure they look the same.
Yesterday and
Okay.
this morning are the same set. Do you mean the one that will be submitted either tonight or tomorrow morning? You want to compare?
I thought you said you submitted a signed and sealed set.
I submitted, no, the set that I submitted this morning is identical to the electronic copy that came in yesterday. Then after that, when I came over to the board, is when Mr. Vine informed me that he had seen this. I then reached out to the architect. I've now received in my email a set that has the revisions that have been requested, but they haven't come to your board yet. I'd be glad to hit.
But it's not
send-
just the revisions, signed and sealed.
On one page, yes, P103. Just so you know, all the other pages were signed and sealed. He didn't just skip it, he inadvertently missed one page.
Right, okay. So, again, please just check, because we've had a terrible experience where the plans didn't look like anything like the plans that were submitted, that were basically agreed upon by the board, so I don't want to...
That would be a problem, I
So
understand.
it's our new rule, we don't do any last-second submissions of drawings.
That
Okay.
makes absolute sense, and I'm happy to submit them subsequently if that's better for your board.
Yes, okay. So submit those immediately to give us time to review
I can have
them?
those to you either tonight or tomorrow morning, depending on what time
So
hearings
in
end.
future, you're the attorney, make sure all drawings are signed, sealed, dated, don't just take things from the architect, that should be a basic mantra of yours.
No, it is, unfortunately, yesterday, if you recall, that request was to have it in by 5 o'clock yesterday. I called the architect, I asked him, he was running new calculations on the building. By the time he got them, I flipped through, I
The
apologize, I missed
mantra
that.
applies no matter what time, when, you're the attorney, you're responsible. That
Understood.
The architect is not the one who appears before us.
Since we're not going to vote on it and there's little room for some fixing, for the sake of consistency and to make sure it's amply clear to everybody who's reviewing the plan and the property owner, we identify in the attic area the portion, both in the existing and the proposed, that is not counted towards floor area.
I'll be glad to have that done.
So, in other words, hatch it is not floor it.
Hatch it as a not floor area, both in the existing and the proposed.
Absolutely, I'll be happy to.
Yeah, well.
So is this on for next week or what?
Okay, no.
Okay, so submit immediately, which sounds like with those minor corrections could be by close of business tomorrow.
Yes. I don't see why not.
And so then it's on for a decision on September 17th?
Correct. So, and the cover letter should indicate that the floor area, the area in the attic not counted as floor area is hatched, that
Of
the revision dates have been added, and all drawings are signed and sealed. Actually, when you provide these cover letters, the cover letter that goes through the things that should have been included is your version of a checklist. Go
course.
look at the drawing. Are you stating what's true?
Yes.
Okay.
I do confirm that when I write my letters.
Okay.
Do you want to make a motion to close?
Yeah, sure, we can close this. Are there any speakers on this? So a motion to close?
Chair Perlmutter?
Aye.
Vice Chair Chanda? Aye. Commissioner Otley Brown? Aye. Commissioner Sheta? Aye. Commissioner Shabeta?
Thank you very much.
Thank you.
Item number 21, 26315BZ, 4547 Little Clove Road, Staten Island. There's a request to withdraw this application.
Jay Goldstein on behalf of Rutherford Inspector, respectfully request to withdraw without prejudice.
Right. So I'd like to make a motion to withdraw.
Chair Perlmutter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta? Aye. Commissioner Shabeta?
And a request, of course, that one of us, council, Tony, Carlos, somebody,
notifies community board and the borough president of the withdrawal.
Oh, cool, okay.
Thank you very much.
Item number 22, 2017-231BZ, 765 Pennsylvania Avenue, Brooklyn. Raise your right hand, please. Thank you. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to board member questions? Sign here.
Elise Volader from Eric Palatnik PC. On behalf of the applicant, I have here today with me a representative from BP, so we can all discuss the comments together. She can introduce herself.
Hello, my name is Karen Uchiyama. I work for BP. I'm the construction and maintenance coordinator for New York and New Jersey.
So we spoke, I spoke with Karen about the grass on the side and how it has to be large trees. Showed her samples from other submissions we've made on other gas stations, so I think we understand that. In terms of the HVAC, she let me know that in September 2018, they changed out the HVAC and there's a new HVAC system there, but we wanted to clarify what you would like shown on the roof plan.
So if the HVAC is on the roof, there should be sound attenuation enclosure, because new HVACs become old HVACs, and then they make noise, and this is backing up to residential.
Please speak into the mic, I can't hear you.
All right, so you're suggesting
Lift the mic up.
So what you're suggesting is to include an enclosure for the HVAC on the roof?
Yes, that's a sound attenuation enclosure.
Okay.
Yes, okay.
And we can, and we'll ask the architect to show that on the plan. We'll ask the architect to show that on the plans. We looked at the broken wall that you said alongside of the landscaping. She'll fix that. And then you have a picture of the trash enclosure, which was recently installed.
Right.
I think those were.
And I think the issue was sad grass surrounded by broken curbs.
Yes.
So let's look at all of the curbs. There's also wheel stops that are just kind of haphazardly floating. Each parking space that fronts a curb for planting should have a wheel stop. The whole idea being that the cars don't roll on top of the planting. Okay. And
Do you have concern about items on sale?
sorry, say it louder.
I'm forgetting, is this the project where you had concerns about the items on display?
No, this is a different
That was
one.
Francis Lewis more so.
Yeah, that was, and Henry Euler submitted on that one.
Okay.
Okay. No, I think that was it. The only thing that sort of for our record, I don't really understand why the drawings were done like that. The elevation drawings were basically taking old elevations, scanning them, and then drawing in CAD on top of them, which is a terrible method unless your scan is in another layer and you can drop it off, right? So if you could clear those drawings so the elevations are clean elevations instead of traces on top of bad backing drawings.
And I'll send this video to the architect, as she's obviously not in charge of that.
So, yeah, because it's a very peculiar, and we made a comment about that the last time and still have these drawings that really shouldn't be in our record.
Okay.
And we also asked the last time to show where the underground storage tanks are and to clarify the history of them. In other words, that they don't have leaks when they were installed, that they received approval, inspection. We didn't receive that.
The architect told me that they haven't been changed out since the last approval for this case.
But that doesn't mean you don't answer the question and show them.
I'm just
Okay, okay. I mean, you know, if they haven't been changed out, it means that DEC is inspecting them or should be, right? So.
Yeah, so we have a current permit for the tanks that were installed a few years ago, so we should show the details of the tanks on the drawing.
Yeah.
Okay.
and that the permit's up to date and the inspections are up to date, right?
So we'll attach a copy of the permit.
Yeah.
Just send me copies.
Okay, that's that, I think. Everything else is fine, right? Okay, any speakers on this? All right, then. So,
Wait, can I, one sec, I'm sorry, Madam Chair. Did you do a secret protocol affidavit or anything like that?
can you speak up?
Secret protocol affidavit or anything?
I think we do have one as part of this, but I don't remember off the top of my head, but I think as part of this application, we did an EAS.
You did submit it? All right.
But I'll
Okay.
check.
So if that protocol included status on the USTs, but that's my notes from before, so I'm not
Okay.
sure that that was
You
included.
can always add to the EAS.
Yeah.
Okay.
Okay.
That's just, it just was thinking that.
Okay, so the first thing is the landscaping should be installed, right? And it should be shown on, I believe it's shown on the drawings already, but it's, or maybe it's not, it's just shown as sad grass.
But it's closed.
No.
Just the grass, we'll put in landscape.
Okay, so we need drawings that show
Yep.
dense landscaping that functions as a dense buffer for adjacent properties. The minimum height planted new is 4 feet for each shrub, and to grow to 6 to 8 feet ultimately, right? So that's your direction for what kind of landscaping, and typically they're planted quite close together or staggered where there's room for staggering. I don't know if there's room for staggering. So you actually need to show that landscaping drawing before you install. So I'd like to see you back before the end of planting season, so it gets installed now.
Between hearing, but you don't have to show, you just need to show them the plans.
Okay.
Yeah, okay.
Okay, so you're going to make those changes to the drawings
Yeah.
and come back here in time for planting season, so ideally by the end of September, could we do that? Is that possible? Or end of, or beginning of October?
October is pretty,
It's just to show the.
oh, just to show.
What do we have?
So this is next week.
No, October is terrible. Okay. Next week looks better. All right, how about October 3rd? Come with the, and it means a submission by September 31, right?
October 3rd.
So that's just for.
October, yeah.
October 3rd is a submission on.
Well, yeah, all the drawings will be changed by.
Let's say, no,
Can't be now.
no.
No, but chief.
We can give
All right, how
them
about
more time.
next, yeah, how about next, you make a submission
Yeah.
by next week?
Wednesday?
Next Wednesday? Of
Until
the-
next Friday.
Okay, next Friday?
The 20th.
Yeah, so next Friday, the what?
September 20th.
September 20th?
For a continued hearing on October
3rd.
Okay.
Right?
Just
Okay.
the end of the week's always better.
Yes, and, all right, so it's basically, you're going to show all the changes that we talked about, most importantly, the landscaping drawing, and then you will install, so, within the, after we have that hearing and within the planting season that is now, okay? Okay, good.
And just as a reminder, that is a Thursday.
Yep. Other hearings?
Okay, thank you very much.
Thank you.
Item number 23, 2017-233BZ, 446, 448 Park Avenue, Brooklyn.
They request
Adjournment request on this?
Van Baton from Shell Nobel PC, they requested an adjournment for a submission date in December.
Oh, submission date in December, okay. We can oblige. So January hearing.
January 14th is the next hearing in January?
Right.
First hearing.
And the submission date for that is December 25th. Would you prefer to have it before or after?
They could submit it before that, like a
Okay.
day before.
The 24th?
Sure.
Or,
They just asked for December submission date, so.
okay. You can always submit early.
Early, exactly, that's what I meant. Okay.
So Can I have that
So
again?
is it
Kurt? I'm
December
sorry.
24th?
Okay, so December 24th submission for January 14th hearing.
Thank you, Kurt.
All right, thank you.
Item number 24, 2017-243BZ, 29-16 Francis Lewis Boulevard, Queens. Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth before the board and to respond on city board member questions? Go. This one, swearing sheet. Always a swearing sheet. This sheet is always for the neighbors.
Henry
He's on your letter. They have no issues with the Sunday.
Right? I don't remember asking.
Elise Fullader from Eric Palatnik PC on behalf of the applicant. Here again with the BP representative. I'm going to let her say her name because I don't like to bring up people's names.
I'm Karen Uchiyama for BP.
Okay. And just to let everyone know, but I don't know if I don't see him here today, Henry Euler from the Civic Association, Auburndale Civic, submitted a letter with a lot of comments and requesting some of the things that we mentioned yesterday be handled. I don't know if there were any other ones.
I guess you can email me a copy.
Yeah.
Well, again, we will revise the landscaping plan. We do have landscaping in that corner triangle, but we will make the landscaping plan match what is there.
But the landscaping that's in that corner is pretty weird looking. It's sort of, there's this root growing out of one spot. I don't consider a root landscaping. It's usually, I don't know what that is. And then there's kind of this lopsided nature of the planting. So it really needs to look like a managed planting bed. It doesn't look managed. That's the corner behind the building on
Oh, this
172nd,
corner.
not the front corner.
Okay,
That
we
is
were wondering about.
very decorative and nicely done. Okay.
Okay. So we'll have that up.
Already emailed it to you, Elise.
Thank you so much.
Mm-hmm.
And then we heard your comments about a miscellaneous pest control sign. We'll figure out whose that is and potentially have it removed if it's.
Well, I think it
might not be.
It's on your property, so
Yeah,
take it
so
off.
We'll figure that one out. And then wires and banners you said need to be removed. We will look through the site. And then a trash enclosure, a very nice one, was installed, and I got pictures at like 4 PM this afternoon. But I will submit that as part of my new submission because I didn't know that was happening until 4 PM this afternoon.
Okay, and the dumpsters have to go into the trash enclosure, right?
Yeah, they're currently inside the trash enclosure and it's nicely done, so you'll see on the photos.
Okay, and the tires likewise can't be stored outside. They have to be in an enclosure or inside the building, right? And also the things for sale can't be outside the building. It's supposed to be inside for the building. You know, if you want to display that you sell antifreeze or something, that's called a display window, right? So for the public, especially in a residential district, is not a place for displaying your wares, right?
Understood.
Okay. And I think that was it.
And we'll
So,
go
okay.
through Henry's comments.
Yeah, and so I think Henry's comments, or Mr. Euler's comments, were basically tracking what we talked about. They say, oh, there was trash. One neighbor who lives next to the rear of the business on 172nd Street reported that litter frequently accumulates by the rear. And he's spoken to the people that run the station, and the litter is removed, but then it comes back. So I'm not really sure how you deal with that, but you need to create what I call an architectural solution. It can't be just continuously complaining that it's a messy site. Instead, there needs to be maybe fencing or something that prevents it from getting all strewn with litter. That's one of the reasons that landscaping is such a good thing, because landscaping tends to prevent litter.
And you
So-
already asked us for landscaping, so maybe that'll.
Right, I just don't know exactly what the location is
I
of the litter
think-
strew.
I think it's, no, she only sent this. That's what I sent.
I don't know.
I mean, it sounded like it was probably that corner you just mentioned.
Yeah, it could be that corner, so maybe instead of just planting, maybe you put a little fence around it, so you're discouraging people from going in and tossing litter, I don't know.
Okay, so we'll see what the needs for the business is, and if it's for storage, then we'll put a fence, and if it's for only landscaping, we'll just specify it on the drawings.
Okay, good.
And just revise your statement, pages 1 and 2, you have 2 different expiration dates.
Yeah, you said that.
All right. All right. Are there any speakers on this? Okay. So let's give you some time and therefore not crowd up our, like, end of October, early November? What's that like?
Should we do something similar to what we just did?
October, we have 24 and 29.
October 29, yeah, October 29 is the best. We have really packed schedule. That other one was really important because the landscaping isn't installed, right? In this case, the landscaping can be completed according to the drawings, except you need to fix that landscaping plan on the triangular corner, right? So the triangular corner isn't exactly, it's not a dense landscaping, it's a decorative landscaping. So you already have good example of decorative on the other corner, on the intersection. Just use that as your model. So, yeah, so that, right, because right now it's, so use that as your model, modify the landscaping plan to show the same kind of thing as you have on that intersection. And that way you don't have to come here and show us, just install it, okay?
So October 29th, when is
October 9th submission for October 29th.
Thank you.
So you'll install and take photographs and show us that it's done, okay?
Item number 25, 2017-270BZ, 1434 Utica Avenue, Brooklyn. Please sign in, and I gotta, oh wait, wrong one.
Bless you.
Sorry, just sign this one. Must be a typo. You gotta raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before the board and respond honestly to board member questions? Okay.
My name is Edward Loria. I'm the applicant.
Okay, I know you requested an adjournment. Did you
Yes.
hear our comments yesterday?
Yes.
So you know that this special permit is only for uses that have existed and that are proposed to be enlarged, the same use. The use has existed for 5 years, not the ownership.
Yeah, well, I need the adjournment at any rate because I recently received a letter from the fire department asking for fire curtain to be installed. So that has to be done. But with regard to your comment, the present C of O is for use group 17B. The existing occupancy presently is a use group 17B, and the proposed occupancy is a use group 17B. Now, in use group 17B, we have a lot of different categories. We have a lot of different uses. So, but it's essentially the same use. What the question is sale of motor vehicle parts. So now we had motor vehicle repairs as the current C of O. Presently, we're selling motor vehicle parts, and the proposal is repairs and parts. So it's continuously use group 17 use, 17B use.
Wait a minute.
I'm sorry, Mr. Loria. The sale of automotive parts, isn't it a use group either 6 or 8?
Well, I find 17B includes automobiles, trucks, or trailers, including parts or rebuilding engines.
No, that's automobile repair.
That's automobile repairs.
Sales is like.
That's the machining of parts.
Sales is like 8, isn't it?
I just wanted just to be clear because it's a threshold issue. But I think, and, you know, you confirmed this, but I think the sale of just automobile parts is retail. It's either a 6 or an 8?
Well, this is wholesale parts. They don't sell retail.
Okay.
They don't sell retail.
So the fire department, so I don't want to go over what we already went over at our last hearing. We had an essential threshold question. And to say, I need to respond to the fire department doesn't answer the essential threshold question. Fire department inspected this site on December 27th of 2018 and stated, our inspection has found that these premises are used as auto parts retail store. The motor vehicle repair shop was discontinued in 2017. So that's not the operation of, if, let's just say for argument's sake, auto parts retail was a use group 17 use, which it probably isn't.
No, it isn't.
But if it were, then it's only been operating since about 2017. So we don't have 5 years of continuity of a use, and it sounds like we don't have 5 years of continuity of a use that is entitled to this special permit. So that was what we asked you to establish the last time you were here.
I thought we established that last time.
No, we didn't. That was the whole point. We asked you to go back and respond, because fire department's inspection was what drew into question whether or not you could qualify for this special permit, and we were awaiting revised drawings. We were asking for, I'm just looking at my notes from the last hearing are, I think I'm confused. The proposed use for the building is sale and storage of auto transmission parts. Is this properly use group 16D? And has the use been lawfully on the lot for 5 years or more? That's a finding for the special permit. Fire department indicated as retail sales. We asked the applicant to go through the findings of the special permit and received nothing. And then there were other comments about the floor area calculations and things like that. So you're asking for an adjournment, but we still didn't get an answer to the first set of questions that go to the threshold question. So I'm suggesting that you haven't met the threshold, and I don't think that you can apply for this special permit to enlarge a use.
Well, the problem is, it's not retail sales of car parts, it's wholesale. It's absolutely wholesale. It's only deal with dealers. They don't sell to the public.
But so this application is, let's see, this special permit is available to the use for being the building in which the use is located. The use is not listed in use group 18, and where's the uses that are required?
Use group 17B, you said this,
Yes.
the existing use, the proposed use, the past use has been 17B. The closest one I can see is automobiles, trucks, or trailers, including parts or rebuilding of engine.
Right.
That's what you're referring to.
Right.
But that's not what you're doing.
Sales.
That's not
Right.
sales. That's and above it, it says manufacturing establishment, use group 17B, and manufacturing therefore of automobile, trucks, or trailers, including their parts or rebuilding of engines.
Right, it's not sales.
It's not sales, right? In any form, wholesale or otherwise, right? And I don't see actually anything in use group 16. So you don't have a lot of choices, right? This is only available for 16D and 17B uses, isn't that right, for this special permit? 7353.
It refers you to,
Say what?
I think the section refers you to another section that identifies the actual uses.
Yeah, it does, so I need to get there, though.
1560.
1560? Okay.
Yeah, and use group 16 is a retail or service establishment, that is use group 16A. Retail or service establishment, under that is automobiles, motorcycle trailers, or boat sales, open or enclosed. So it's not even parts.
Yeah, but those sales of automotive deals includes the servicing of vehicles, which is what makes it the 16.
Right,
And there's
but-
the automotive service establishment,
just-
automobile
yeah.
trucks, motorcycle or trailer repair.
Yeah.
So how do we get to this? That's what I want to know.
So 1560 identifies the uses that are contemplated under the special permit.
Here we go. Right, so 1560, reference commercial and manufacturing uses. The following uses shall be applicable to section 7353, that's this application, right? 7B, exterminators, gun repair, sail making, taxidermists, trade embalmers, window cleaning contracts. Upholstery shops under 8B. 9A, blueprinting, medical or dental, musical instrument repair, plumbing, heating, or ventilating showrooms, printing establishment, art studios, typewriter repair, umbrella repair. 9B, hair products for headwear. 10A, depositories for storage of office records, photographic or motion picture studios. 10B, all uses. So you could look to see whether any of these things are in 10B. Use group 11A, all uses. 11B, all uses. 16A, blacksmith, carpentry, electrical, glazing, heating, household office equipment, machinery rental or sales. I don't know. Mirror silvering, poultry or rabbit killing, the famous poultry or rabbit killing, sign painting shops, silver plating shops, soldering or welding shops, tool dye or pattern making. 16D, carpet cleaning, dry cleaning, laundries, linen, moving, storage, packing, crating, warehouses, and so on. Okay, none of those sound like what this is, unless maybe you're in that machinery rental or sales establishments, but that doesn't sound like what this is. This is not machinery, this is automobile parts. And so...
Well, it's transmission, automobile
Automobile
transmissions.
parts, right?
Transmissions.
Not machinery.
Yeah, but transmission is not a machine.
No.
Transmission is a part of a car.
It's a part of a machine.
It's supposed to be tools.
Right? So the problem is, unless you can establish, A, that you're one of those things that's listed in section 1560, which you need to do, and that it's been in existence for 5 years, you need to withdraw this application, all right?
So I'll attempt to address that issue.
So we're not going to allow for a long adjournment because it's a simple, straightforward question. It's completely independent of what fire department asked you to do.
Okay.
Because the question here is, can I enlarge it?
Right.
Right? So the answer is not unless.
Unless you meet the findings.
Yes. So, and so I don't want this here long, so I'm only going to give you till our earliest, that works. Let me just see how many we have, 25, that's right.
Okay, so October 29th continued hearing with a submission date
Can I
of
just have-
October 9th.
Can I have a little further? I'll be out of the country until November.
You're out of the country from now until November?
No, from the month of October.
Okay, until November.
Okay, our calendar looks a little better on November 19th
Fine.
with a submission October 30th.
Okay, so that's the last hearing. You have to prove that you are qualified for this special permit or withdraw, okay?
Okay, thank you.
Thank you.
Is it still considered an adjournment, though, or no? Check
No.
this out.
No.
Yeah, I just, because I want to mark the record.
Yeah, not adjourned.
Okay.
Oh, should we put it on for decision?
Oh, no, we can't
No, we
close
can't
it,
close.
but we can say he needs to establish the
I
threshold.
put last hearing, a note, last hearing.
Well, let's put it this way. If he doesn't establish the threshold, then there's nothing else for us to do. If he does establish the threshold, then we have to continue, because so far we've never been able to find out whether we even have the authority to review this application.
Okay. Item number 26, 2017-272BZ, 1019 46th Road, Queens. There is a request for an adjournment.
And I'm here, and we're going to submit an authorization that we now represent this client.
What do you know?
Yeah.
Okay.
But we'll do that with our submission, whenever
Okay.
that is.
So...
2 months preferably, I was told.
So does that mean, sorry, go ahead.
No, so you'll be submitting the affidavit of ownership, a letter from the owner, just stating that they're no longer retained.
Yeah.
And update your application form accordingly?
Yes.
The applicant, Mr. Harry Kalin, who is the attorney representing, had notified me that Eric's office will be standing up for him.
Yeah.
Standing up or replacing?
Well, taking
I
over.
believe it's replacing. I was told
Did he say
replacing.
replacing?
Standing is different than taking over, right?
Whatever it is, you
Superseding.
can
Whatever
reach
it
out
is,
to
I will
me
give
and we
you the
will do it
perfect-
procedurally
yeah.
correct.
Right.
Whatever you need.
Yeah.
Yeah, so the whatever we need, though, is, as you might have heard in the review session, whether or not was actually your case, this is a CrossFit gym that's been operating for 7 years or something, I think, without a permit. What's that?
I hit a button on it.
CrossFit gym, no permit.
But it's operating for 7 years without a permit, so a request for adjournment is not appropriate, right? It's already was adjourned in June.
Okay.
We need this thing legalized, right? And so we need you back fast.
Okay.
Okay, they asked for an adjournment till like February and without explanation.
Okay. Well, this happened all in the past day, so I'm not going to speak on it, but.
I know that you don't know.
Yeah.
They know, whatever the reason is, but we don't accept their request for a long adjournment. So whenever we can put them on something.
November 19th?
Yeah.
Okay. So a submission date of October 30th with a continued hearing on November 19th.
November 9th. Okay, thank you.
Item number 27, 2018, 3BZ, 154-160 West 124th Street, Manhattan. There is a request for an adjournment.
Okay. Similar, so
adjournment?
we last heard this case a year ago, and we need to send a letter to the owner that it's the last adjournment, and really, it doesn't sound like this case is going anywhere, so my recommendation is that they withdraw.
So what date do you want to do?
Soon, soon. One of those late November ones, yeah.
Let's go with November 26th with a submission date of November 6th.
Okay, thank you. Item number 28, 2018, 53BZ, 104 DeGraw Street, Brooklyn. Sorry. Why does everything stick to you when you want them? Yeah, sign it and I'll swear you in. Yeah. That's okay, that's good. Okay, ready? Raise your right hand. So you affirm to tell the truth, the whole truth, and nothing but the truth before the board in your testimony before this board and to respond honestly to board member questions. Proceed.
I don't know whether to say good evening or good afternoon. It's 5:45.
Good evening.
So, good evening. I'm Stuart Beckerman from Slater and Beckerman for the applicant. So, we saw the video of yesterday's review session, and I'd like to address some of the concerns that was expressed by the board. And after I do my presentation, Marshall Sohn, who's the applicant, will speak to his experience in the neighborhood and his knowledge of the market, which was somewhat relevant to some of what was discussed yesterday. And then Barbara Cohen will address questions about her economic analysis. And then finally, Ben Stark will summarize how we've met the 5 findings with reference to certain key pieces of evidence. So, so before I address specific points, I just want to state that we've repeatedly shown that our site is unique and that therefore, if a variance is granted, it will not serve as an effective rezoning of the neighborhood. Our uniqueness study demonstrates, a uniqueness study that had been done last year demonstrates that there are no sites in the study area that are 35 by 100 or less, an interior lot, vacant and unapproved, and unimproved, and abutting residential on both sides. And if the board were to grant, there are no other sites that would meet all four criteria. We've shown that an as-of-right development is not economically viable.
But before that's the B
Sure.
finding. What's the hardship imposed by a 35-foot wide vacant site?
I'll get into that later.
Okay,
I'll
but
go
don't go
through-
to the B finding, that's part of
Sure.
the A finding.
Well, it goes to the hardship. And so I'll just state that we've shown that the unique conditions that distinguish us from other properties make this property uniquely unviable for conforming use. I understand what you're saying, that goes to the B finding.
Let's slow down a second, okay?
Sure.
Because I think we gave you a hint at the last couple of hearings.
Mm-hmm.
On the 25-foot wide sites, those are easy, right? You say, I can't have a functioning office building or a functioning, well, in the old days, hotel, because the size of the stair core, elevator core, and all that takes up everything. You end up with a little 12 by something here and a 12 by something there because the stair has to be in the center and it breaks up the core and so on. And it's not that people wouldn't rent this thing because it's too small, right?
Right.
Or other versions of that are, I need a service elevator, I can't have a service elevator because there's no room. What is imposed by the 35-foot width that is the actual hardship without going, or now we're talking about the formal hardship, not the economic hardship, right?
Well, there are two ways of approaching hardship in the A finding. One is that there are conditions on the property that affect the cost of construction, and therefore that affects I understand, it's hard to talk about A without talking about B, because B quantifies A.
No, but you can talk about A before you get to B.
Because if you talk about B and A together, then we're not sure if it's a market hardship and not a uniqueness finding hardship. And so I know the argument, and I understand the B argument about the viability of this type of office or industrial in this area. But that affects just about every office and industrial in this area, because manufacturing is dying, period, citywide, and anything that's less than an optimal, at least 100 by 100 square foot site, is going to suffer some kind of marketing difficulties. So that's why we need to divorce that conversation from your A, so that we could talk about what about this site is posing an actual hardship that has nothing to do with the marketing. And once you meet that threshold, then you can then rely on your B finding argument to support it.
Okay, so let's just parse the A finding. What does the A finding say? It says that there are unique physical conditions that give rise to a practical difficulty or unnecessary hardship in developing the property in strict compliance with the zoning.
What's the practical difficulty?
Well, it's practical difficulty or unnecessary hardship.
Right, so what is it? Because it's not really the financials behind it. It's, for instance, and I gave this guidance a few hearings ago, I said that when somebody has come to us and said, I have a narrow site, I can't put manufacturing in here, they've actually shown a skid is 9 feet by 9 feet, the average skid is loaded 16 feet high or whatever, and I need a forklift, and I can't fit it all in my 25 by 100 lot or 17 by 100 lot. I'll have virtually no place to maneuver if I put stock there. So the question is, what could you show us from a 35 by 100 foot lot that shows us that there is a hardship here that isn't financial in nature? And the reason why we are asking this is because, as I said yesterday, in seconding what the chair said, the issue here is the threshold of what is wide enough for conforming use. And while this one lot getting a variance may not destroy the character of this neighborhood, you have to understand that this will provide the precedent for everybody else citywide who will say, you said 35 feet wide was was too narrow in Columbia Heights. Why is it not too narrow here in, I don't know, East New York? People will use this case. And so we have to be mindful of opening that door of what is too narrow, and we don't want to open it too wide. So basically, everybody that's under 100 feet by 100 feet can come in for a variance. That's our concerns.
Can I think I'm in the minority here, so I'm going to just put a question there. Speak loud. I'm in the minority here, so I'm going to put a question there. So let's say this site was in some other area where the surrounding uses were not residential, but non-residential in nature. There, an argument for pushing a residential building on a 35 would be difficult, possibly because you're surrounded by manufacturing uses. Whereas here, if you're going to push for a manufacturing use where the uses on both sides are residential, a manufacturing use is not going to be willing to locate there, even if the price was right, because they don't want to take the risk of having to constantly deal with the residents saying, you're making too much noise, you're doing this, you're doing that. I think it's very reasonable where a manufacturing business will not want to willfully locate there even if the price was low.
So there's instinctual knowledge, and then there's the knowledge that's required to meet a finding, which is more formal. And that's what I'm trying to get them to articulate, is a formal set of reasons why there's a hardship here, so that this way we can close the door on everybody else who's going to come in here and say, we have a 35 by 100 foot lot. It's not going to work. So I don't know how you make the case. I'm not on that side of the desk.
Right.
But that's what needs to clearly be articulated. You need to help us to shut the door for everybody else, basically.
But I also just want to pick up on just this one comment. We always talk about this because they're M districts as if someone's actually doing manufacturing. But we know, as you said, most of this isn't manufacturing, though we do see in the Brooklyn Navy Yard, we do see actually in this area some light manufacturing type work done, cupcake factories and other things like that. But what we do see is legitimate use in the M districts is offices. And most of the time, it isn't a manufacturing building against the residential, it's an office building against the residential. And in this particular case, the proposal is an office building in addition to residential. So you can't argue in this case, we rarely see this situation, right? You can't argue in this case that this is not an appropriate use next to residential, because not only is there an office use in this proposal, but there's residential in the proposal as well. So it can't be that offices are a bad thing to have next to residential, or it wouldn't be this combined proposal. So that's, I think, from the beginning, that combination has weakened the argument, because on the one hand, the application says it's so bad to be next to residential that they're going to give the offices a hard time for being there, when in fact the proposal is offices. So it's talking out of two sides of the
I just want to say a couple
mouth.
of things to that, and maybe it's hard for me to concede this, but maybe we have a fundamental disagreement on the A finding and what it means and the way it historically has been interpreted by this board. I will refer the board to the fact that just over 5 years ago, this same board granted a variance 2 doors down on an identical set of facts. So,
Not on an identical set of facts. On a set of facts that were based on a neighborhood that was quite different than it is today. So,
well, I thought you're suggesting that it shouldn't matter what difference.
No, so one of these.
I'm a little confused about that.
So, okay, so, of course, I
How does
wasn't
that
there
affect the
during the argument made about a 35-foot wide building back then, 5 years ago. But if some of the argument were that B finding where nobody will rent it because it's too hard to get here and nobody will come and have offices, that's no longer the case now, because the neighborhood has changed significantly, right? And the nature of work has changed significantly. 5 years ago, we just started seeing these kind of WeWork type phenomena and so on, just started seeing actual applications in these M districts to enlarge these buildings
to allow more floor area for a manufacturing, or let's say a commercial use, right? And in all of these situations, I'm a little more sympathetic to an argument that it's not enough floor area for me to pursue my commercial use. But the idea of switching both the use and then therefore, by sort of definition, granting more floor area to because it's residential and you're using a residential district, it's almost like a sort of a double dip. You get more floor area and residential as opposed to just more floor area to continue working in a commercial district.
So can I say, I was there. I was here for that previous case. 5 years makes a large difference in the world of the manufacturing slash office use, because back 5 years ago, it was a simple manufacturing, one-story manufacturing isn't going to work on a 35-foot lot or two 17-foot wide lots, I believe it was. Whereas now, you do have office buildings. And wait, that is a possibility. And so the conversation changes. Neighborhoods morph. Unfortunately, sometimes the morphing goes against you. For instance, if you drove down Flatbush Avenue in Brooklyn 5 years ago, downtown Brooklyn, you'd be like, who the heck would ever want to live here? Now, 5 years later, who wouldn't want to live there? So things change in 5 years, so I wouldn't necessarily say you granted it then, you should grant it now. You have to go into that application, because you can get that application and look at how they made that uniqueness finding. And it goes back to what I said about showing that the industrial won't work. They sketched it out. They literally sketched it out, what would happen. So they took us by the hand. You, of course, then have another hurdle in that you also have to prove now that office is starting to move into this area. May not be an optimal place for office, but we all know that places that start out as not being optimal end up changing a neighborhood slowly by surely, and then it takes off.
There is no evidence in the record that new office construction is happening in this neighborhood. None. To address your point directly, there is no evidence. No one has presented any evidence that there is new, and certainly not on a site that's 35 by 100 on a side street. It's just not happening.
But
There's
then
no evidence.
that's a market
who testified.
situation,
I know,
right?
but it's the board that is suggesting that that's what's changed, the market.
No.
So you're putting me in a position of having...
No, I'm saying that the analysis is changing. In order to prove that same hardship, and that it is a hardship being 35 foot wide, you now have to take into account that other uses are taking hold in this
They're not,
area that
though.
are as of
But
right.
That's just not, I respectfully disagree. We had a broker who testified to that fact, that nobody is constructing new office buildings.
No, you're talking about constructing new offices
Right.
as opposed to people wanting to work in this area. People are coming to this area to work now.
But that is exactly what distinguishes the site, is that it's a vacant lot. When you're seeing new commercial uses move into the neighborhood, largely they're moving into existing buildings where the rents that are generated can be a lot less to offset the cost. Here, we have to justify new construction. So again, I respectfully disagree, and I believe we were involved in that case 5 years ago, so we know that case. That was our law firm.
That was your law firm?
Yes.
It's interesting. I didn't know that was you. I believe it was
Right. And we didn't look at offices then because it was not a reasonable use then, and it remains an unreasonable use. There is no new office construction occurring in this neighborhood. None. And so when, again, we listened very closely to what was said yesterday. I'm just going to try to sort of skim through what I was going to say, because it seems that a lot of what I want to say, you're telling me, is not really germane. But, like one thing that the board was talking about yesterday was, to illustrate the viability of M zones for far from subway access for certain commercial uses, including offices. We were directed to Red Hook and the Brooklyn Navy Yard. I mean, those neighborhoods, I believe that if we had the same lot with the same conditions in those neighborhoods, the hardship would be the same. And I don't think it's fair to compare what we're encountering with, for example, the Brooklyn Navy Yard, which is a city-owned site with multiple buildings on a large campus where they basically created a destination. And they've worked decades to generate support for commercial uses and industrial uses. And the Pioneer, what was the Pioneer Works in Red Hook, again, that's like a large building with, we could never do the kinds of uses and that's an existing building that has evolved over time. They basically make money from, renting it out as an event space. We certainly can't do that on this site.
No,
Even if
you
we had an existing building. It wouldn't even
You
make
misunderstood.
economic
My
sense.
reference to Pioneer Works is that the neighborhood, because of Pioneer Works, is changing dramatically related to Pioneer Works. It's a little bit like BAM locating in a part of Brooklyn where nobody was willing to go. And Pioneer Works is having the effect of more restaurants, more people wanting to work in that area, and so on. So,
But not in a way that affects the conditions on this site and the unique conditions that burden this particular piece of property. Nothing about what was discussed has any impact on your ability to use and develop this property. And again, the A funding is about development. It's not just about using, it's about the ability to develop for a conforming use.
Right.
So that is integral, and I think that the economic viability of it is integral to the aid. It illustrates the uniqueness. So I respectfully disagree with the way some of the commissioners are looking at this case.
Well, I think that it's a very fine line, and I think that you could prove your case, but you really have to focus more on the functional impossibility of it. When we had a case, and this is a case that your financial analyst worked on, which had to do with a WeWork situation. And it was on a lot that it might have been 40 feet or 35 feet, I'm not sure, by 100. And she actually made the case that this was not suitable for office because the layout was such that it wouldn't meet any of the minimum requirements of a co-working site.
Right.
So that's what I'm saying. It's like she didn't even have to get into the financials. She did it because we asked for more information about it. But that's what I mean by divorce yourself from the financials and talk about the functional non-viability of something. And so whereas for the other case on DeGraw, the functional non-viability was just showing us the floor plate, that you couldn't have these skids and a hand truck moving its way through, or one of those mechanical trucks moving its way through and getting anything done. You could do the same for office.
And I just want to add one thing, just going back to 96, 98 and what you're discussing. I believe that, that this neighborhood, the commercial use that makes the most sense remains a warehouse industrial use. I think that really is the use that you see new construction on, and that really does make the most sense. That's what people are doing. But as we've, I think amply demonstrated at this point, at least I think the uniqueness is satisfied, at least in regard to that type of a use. But now we're being asked to look at other uses of which there's no new construction. And so it seems unreasonable for us to even be looking at.
But you're going to have to focus on the functional non-viability of this. And it's not that we're trying to make your life difficult just for the sake of it, because we really want to see this case come back in another month, because trust me, believe me, we don't. Okay, we want to be done like you want to be done, but we also have to explore all the avenues. And for instance, there was a time when on industrial-sized lots, we were asking for hotels.
Right.
We stopped doing that. Part of the reason is it's no longer as of right, but we also started phasing that out on some of the more narrow lots because we realized the functional non-viability of having a hotel on a 25-foot by 100-foot lot, because it was explained to us over and over again, and it took hold because it made sense. So we're asking you to do this exercise, not in the hopes that you don't meet the A finding, but in the hopes that you could actually articulate this to us, help us to close the door on everybody else, and then we could move on.
I very much appreciate what you're saying, and I'm listening as closely as I can, and I'm trying to take it all in and figure out how we can return to you something that would help you make the finding A. So, just so I understand, what I'm hearing is that because we included an office within our development, that somehow that's being used against us in some way.
It's not being used against you. You're saying that the site is not viable for office use, and then you say it in your papers. The site is not viable for office use, and then the proposal is office use. This is extremely confusing. The proposal is office use. Either it's viable or it's not
I
viable.
appreciate, what we're saying is that it's the residential that makes the office use economically viable, and we offer the office really as a way to kind of, we just think that it makes the use more appropriate at this location, and it goes more to the E finding, and
Why does it make the use more appropriate?
because it's a manufacturing zoning district, and we just thought that this was a scheme that made sense for what we were trying to accomplish.
But again, it's not being used against you. You say yourself, it doesn't work, but we want to do it anyway. So,
To that
I'm sorry,
point,
state your name?
Ben Stark for Slater and Beckerman, to the applicant. We feel very strongly, and we feel that this is backed up by the testimony of Dan Marks, that the tenants who would be seeking to rent within the bottom floor of the mixed-use development scenario, the proposed scenario, it's a totally different tenant pool than the tenants who would be seeking to lease a ground-up, singular office development. They're two worlds. And we feel that the board had recognized this, that on one hand, it's the architecture firm with the principal living upstairs and a handful of employees downstairs. That's the mixed use. Whereas the as of right development proposal for the office is more of a larger tenant pool of a shared office.
I need to interrupt because, A, we've been through this before, and so this is very circular, and I just want to, as part of the circle, say, when we started off this case, I asked, is this a live-work proposal? And the answer was no. The answer was maybe, maybe not, maybe we'll rent out the top floor separately from the bottom floor, not necessarily traveling in tandem. Sorry, I have notes from when it wasn't I asked very specifically, if you were saying this is purpose-built and live-work, it would be a different analysis than if it's not purpose-built, if it's not live-work. And
I
so,
can respond to that. We wanted to get as much clarity as we could from the board. We've always been clear that the intent is to lease this to a single live-work tenant. When we asked what the implication would be of changing the financial analysis to be a single live-work tenant type of financial analysis, we were told that the applicant would be restricted in the off chance that they have to pivot and lease spaces separately, that there would be some sort of restriction against that. That's what we were told.
no, I'm sorry. Please don't introduce new things. We never said that. We wanted clarity on how the financials would be analyzed, and sorry, there's been lots and lots of flips here. So what makes this quite a difficult case to review is speaking from many different sides of the story inconsistently, right? And so
I'm sorry that has come across. We feel that we have been consistent in that the intention has always been to lease to a single live-work tenant.
It's not owner-occupied.
No.
But it's not owner-occupied. It is still speculative, a speculative development to find one tenant who would live in both units.
That's not what you said in the letter. You were like, maybe we'll find one tenent, maybe we'll find a tenant for this and a tenant for this.
I understand.
We don't want to limit it because we don't know what the market is like. That's why because we said, why don't you lay this out differently so you don't have all the circulation space.
We would love to lay it out such that the board recognizes that our intent is to lease it to a single live-work tenant. We had understood the board's follow-up in that regard to be that if we went that route from the construction of the financial analysis, in constructing the financial analysis in that way, that if 10 years after construction there was some sort of recession, that we would be somehow restricted in our ability to lease to separate tenants. Like basically that there would be some sort of representation on the certificate of occupancy that would restrict leasing the spaces out separately. That from a speculative development standpoint is something that we couldn't agree to. It's downright dangerous to go through with that. So we felt that we can make the findings as the units being separate, but that is, our intent is always one tenant, because that's the only thing that the market is going to bear from a commercial standpoint here. We know that we can't find separate tenants for the residents and the office. We know that the market is really for the live work. That's why we're building it. But I do want to.
I would recommend you listen to your own video and listen to what you actually said at these hearings. So please,
Well, to the extent that we have to correct the record and restate in verbal or writing that we intend to lease to a single live-work tenant, we will do that. The hearing is still open, and here we are. And I will say once again, unequivocally, that we intend to lease to a single live-work tenant. But I do want to get to the point of that Commissioner Brown brought up about what is the physical aspect of this proposal that presents a hardship. And I point to our submission from, I believe, prior to the June 25th hearing, noting that included illustrative floor plans for a couple different as-of-right proposals, the office development, like a hybrid retail producer use. And we noted in that submission that although the site is 3,500 square feet, you don't end up with 3,500 square feet. We are in a neighborhood that has poor subsurface conditions. We cannot build a cellar. Building mechanicals have to be provided at grade. 3,500 and a 1 FAR building becomes 2,700, 2,650 or something like that.
well, mechanicals aren't floor area, so, right? Right?
We can't put any storage in the cellar. Yes, we have to have mechanicals at that level. I mean, if we're talking about adding a second floor in order then to take whatever space on a first floor would be occupied by mechanicals, now we're making the project even more unviable in adding a second floor from a financial perspective. But yes, we're not talking about the financials. In regards to the hybrid retail producer space, same sort of dynamic. In this neighborhood, you can't have a cellar. We are then limited in the functionality of a 3,500 square foot space because of the need to provide storage and mechanicals on that grade level. But looping back to what Stuart had said a little while ago, where hardship, not just practical difficulty, but hardship from a marketability standpoint comes in, is that, like Dan Marks had said in the previous hearing, we still have to compete in this market for prospective tenants. As Dan Marks had said, getting a tenant to have the vision of what we would try to build here and stick around for 3 years while we build this out is an extremely tough sell when you have a neighborhood full of lots of similar size that are already developed and can be offered at lower price points. That's where the hardship comes in, because
But now you're back to market. Please stay with the.
it's not market, it's about us and other properties. It is about us and what we look like and what we offer in relation to other properties. And if you go down the list of as-of-right uses and you go and you look at what we can offer, 35 by, from a physical standpoint, 35 by 100, 3,500 square feet of floor area, no cellar, new construction. What we can offer there, it cannot compete for an as-of-right tenant in relation to the other similarly situated properties in the neighborhood. It is about competition. And from a competitive standpoint, we are fantastically unique. We can never offer something that the existing buildings can offer from a price point.
Right, but it's not just about competition, because everybody faces that kind of competition, no matter where you are. It's like, where do I fall in the neighborhood of homes in a residential neighborhood? Some are more competitive properties than others. It has to do with functional standards. So you gave us, I'm looking at the illustrative plans of the office, the simple office scenario. You have 20 workstations for employees. You have 2 private offices that are about 15 by 10 feet, and you have a conference room. You have some storage, very little bit of storage. You have a little pantry, you have 2 bathrooms, and a reception area. So what I'm looking for is why this isn't meeting an office standard. Why isn't this? Why? Look, I walk down Chambers Street and I see the architectural office is on a similar size lot. Why isn't this meeting an office standard? You got to answer that. Otherwise, I'm going to have somebody coming in an M zone, in a nicer M zone, with a 35 by 100 foot lot that says, I want to put an apartment building here.
I just want to say,
Because I can't put office.
And I
Let
just
me
want
ask you,
to...
when the zoning was, when the 7221 was first written, what was anticipated was that this would apply to sort of a vacant piece of property with specific physical constraints that are topographic or whatever. But, I worked at the Board of Standards and Appeals in the 80s, and I was mentored by Bill Valletta. And, I just remember, I took over a class that he was teaching, and I remember talking about the evolution of unique physical conditions, and the evolution reflected the realities of development in the city of New York, and that the BSA, that the board was constantly adapting to changes in the way we looked at uniqueness. I mean, the first time the board found uniqueness in a building, it was revolutionary. The fact that you can look at an existing building and saying that in and of itself constitutes a unique physical condition. Nobody anticipated that in 1961. And what I'm saying here is that in this neighborhood, a vacant lot of this size is a unique physical condition that gives rise to an unnecessary hardship in relation to similarly situated properties. That is just fundamental to my understanding of the way the Board of Standards and Appeals has historically interpreted 7221, and you're being asked...
But that's what we're doing right now. We're asking you, it gives rise to something unique. It gives rise to a practical difficulty or a hardship. What is the practical difficulty, such as too big of an elevator core? We get this on the 25 by 100 lots. People do it for breakfast, right?
Doesn't 7221 say practical difficulty or unnecessary hardship? Do you have to find both?
Yes. You have to find the practical difficulty or unnecessary hardship.
Unnecessary hardship.
What's the unnecessary hardship? The unnecessary hardship is not that I can't get the highest and best use. The unnecessary hardship is that, for instance, I need 2 stair cores and 2 elevators, and it leaves nothing left. That's the unnecessary hardship. That the corner lot, for example, has some sort of condition, or it's a weird, my favorite ones are, it's shaped like Italy, and there's no way to fit it. But I want to just read something, because I'm trying to understand where all of this argument about market comes from, and I just happened to stumble on an article, April 15, 2019, in the Brooklyner, which says, which talks about a real Property Shark release of statistics, and it says, Brooklyn's priciest neighborhoods, Columbia Street, Waterfront, Dumbo, and Carroll Gardens. The map that it shows is including this particular site, and it says, as usual, Tribeca came in the #1 spot with a median home sale price of $4.2 million, and Brooklyn's top entry at #8 is the Columbia Street Waterfront with a $1.5 million median home sale price, just edging out #9 on the list, Dumbo. So what I want to say about that is, if this is such an undiscovered, inconvenient neighborhood, then where people are willing to spend more than anywhere else in Brooklyn to live here, then why wouldn't they want to have an office just down the street from themselves, where they can have an architecture office, for example, or some other kind of little law firm or something like that. That's the part that and I'm not saying it's the highest and best use. I'm not saying that this that the floor area allowed in this zoning district, which is what I think this is really about. I think the real issue here is that this is an M11 district, and you only get one FAR. And I'm sympathetic with that as a problem throughout all the M11s. I think there's too little FAR. It's hard to make a viable anything, but that's not a reason for a use change to residential. That's a reason for more floor area in your office building or your manufacturing building where you have an adequate floor plate. If your floor plate were only 25 feet wide, then we have the same problem. So it doesn't really matter how many floors of an office you have on a 25-foot wide lot. It's not going to be a great office building, but on a 35-foot wide lot, if you had 3 floors of office, for example, because that's what you're trying to do here, get 3, however many floors, I've lost track already, 4 stories of residential and office. What if this were 4 stories of office? You could definitely make an office work if it was the same amount of floor area in office. Right?
I understand
Because
your
what you're
position
doing is
there,
highest
but you're not, that actually doesn't line up with fact, because just on our block alone, between DeGraw Street, Sackett, Columbia, and Van Brunt, there are overbuilt buildings with larger floor plates than us. There's a couple, 2 FAR industrial buildings, that if there was a viable market for office in this neighborhood, those would potentially be converted to the quote, higher, better use of converting to office, but they haven't. And the reason that they haven't is partially, as our broker had presented on the previous hearing, that there are things about this neighborhood that are different than Red Hook. There are things about this neighborhood that are different from Gowanus or the Brooklyn Navy Yard. There, as Stuart said before, we can hope and we can imagine this world where these neighborhoods are on some sort of continued evolution, but we have filed the 7221 variance right now for the zoning that exists right now. And there are in the context right now of this neighborhood is there are not only not any office conversions going on, there's definitely not any ground up new development of offices going on, and especially not on a 3,500 square foot lot.
I just want to add, I'm going through my notes, and at the last review session on June 24th, I think amongst our discussions, I think what I gathered, there was an understanding from some of the commissioners was that while the office layout that you had proposed can work, but the office market in the Brooklyn was mostly in the downtown Brooklyn area, and there were more such uses that were coming online there, and that's too much of a competition compared to what this site would offer, and therefore even a 2 or a 3-story commercial office space will not work. And I think we had recognized at that point, at least some of us had, that the A and the B, in this case, the findings are interlinked, and it is hard to find such similar lot on this in this area. And that's what I have in my notes. So I took away from that hearing that, and that's why I'm convinced it meets the A. So you don't have to sell it to me, you just have to convince the others. But I just want to read it out for others so we can remember what we had stated before. And I therefore, I find it hard for us to want to push you to get to that exercise to show an office layout of a 2-story, 3-story, and use.
They already did.
No. This is a 1-story, and if the argument is that if they were going to come for a FAR variance to allow for 2-3 office spaces, then that is more reasonable than a use variance. And the argument that last time we had heard, and we were okay with it, was that there was too much more competition in other areas, that this space of, even if you were to provide 3 floors of commercial, would not result in a viable use on this site, even if the floor area was granted. And that seemed like a argument we were all kind of accepting. So I think we're kind of stepping away from that, and that's what I'm confused.
Well, no, actually, you're partially right about that, because I really think that some of us were convinced by the B argument. I'll admit, I was convinced by the B argument. However, I still think that A has to stand without a market analysis. And I'm pushing back on this, I'm being very strong, because I know this can be made. It has been made before.
I just want to,
So you give us illustrative plans, but there was nothing there to narrate them.
I
Was
just want
there?
to piggyback on something you just said. You said we made the B finding, but you can't make the B finding, and the B finding specifically says because of the unique physical condition. So if we've made the B finding, I believe we've made the A finding. No. And again, I just want.
Because anybody could make a B finding. By saying the B finding, I'm talking about the financials are working to illustrate it or not. It doesn't mean you made the A finding. Anybody can make a B finding, and I believe in all your years of doing this, you know that, probably better than anyone else. Anybody can make a B finding when there's an A, or even when there isn't an A, because the market is a whole different story. So instead of giving all this pushback, when I hear this kind of pushback, I kind of wonder why. Why don't you just complete the exercise?
Okay.
Which is, give me those documents for the WeWork and show that this structurally is not functional for a WeWork situation, which is what we're looking at now.
Or not WeWork, because they're
Or
big
like,
scale,
you know,
but...
small kind of co-working office situations. It's so easy for you to do. You have it. I can't spell it out any clearer than this. You have it. Give it to me.
Yeah.
We
Just
work.
state your name.
I'm sorry. Barbara Cohen, Real Estate and Planning Consultant. The whole WeWork scenario and the structure of it and the tenant requirements and how the operations of WeWorks, we worked that to death, not only in prior, but we've discussed it at length here and why that doesn't fit. The other issue is, yes, it's 3,500 square feet, and that once you build out that space and you end up with usable space of the 2,700 square feet, and that influences the prospective tenant pool, so that it may be an architect's office, may say that's great, but there aren't a lot of other prospective tenant types that would consider that layout, that size, for their requirements.
All the creatives, don't just say architects, all
Therefore,
creatives.
the tenant pool becomes much smaller, therefore, the vacancy rate will be higher, the lease-up time will be longer, and it all, again, leads back to why? Because the site is too small, and the product it produces, and the fact that it doesn't have the storage, and you lay out what anyone looking at this 3,500 square feet and laying out how it has to be used for their purposes is where the tenant pool gets chopped, and that's ends up in
You actually did a great analysis on this for a case in, I think it was Williamsburg, which
Well, I did it for 96. We did that was where we did the whole forklift issue and the size and so on.
No, but you did one for the
Yes, I did.
co-working space, and what
I
did you
did. That's
give?
what I'm
Don't
saying.
interrupt each other,
Wait,
please.
You
One at a
gave me
time.
Yes.
a
Yes, I
set of
did.
pages, right, documents,
You betcha.
that showed me what the standards were.
Yes.
And you set that against the plans.
Yes.
And you said, this
good.
fails. Why does it fail? Because co-working needs space large enough for people to get together and learn from each other and work with each other and share ideas. You cannot put that here. You need a place where people can actually eat.
Right,
and
the
do
rock this, wall,
and
the
this.
whole bit, right.
And the specs for this kind of an office are for a much larger space. And then what did you do? You gave me comps with photos showing the much larger spaces of co-working office so that I can look at it and say, wow, you made your point. It's really clear. This does not at all look like this. This is functionally not viable. Then you could go put your B finding together based on that.
Well, I certainly thought in my last submission, maybe it needed to be spelled out even further.
Well,
Where
remember-
I talk about the reduction of the space with the build-out of all that's required in that space. Now, yes, I can, if you wanted me to continue on, and look, that was all supplemented in the broker, echoing all of that as well. And I think even in my report too, it talked about really at 5,000 square feet, now you got something. Anything less than that, you ain't got much. So I can, revisit it, I can try to enhance it like the WeWork scenario and the backup, that, we can do. I have no problem with that. If that's what we're trying to link, because it is about size. It's all about size, it's all about what's produced, and it's all about a prospective tenant and their requirements and how it fits. We walked it through with the suggested bakery, we went back and looked at that, and we talked about operational requirements, tenant requirements, and linked it to the space and said, no good.
That's what I need.
Okay.
I need
Okay.
to
For
have
this
that door
particular-
firmly shut on everybody else.
Okay.
That's what I need.
Okay.
Right. But I just want to kind of add a little layer of this, because you obviously are taking it from the financial perspective. I'm taking it from the architectural, practical perspective. So it's not necessarily your job, and I don't really understand why we've been asking for this from the very beginning.
I do
And we haven't gotten it. The practical, show me why the layout doesn't work.
She did that with that other case.
With the other case?
And it wasn't
Okay.
from a financial, it was literally was
Was
showing
physical.
us, it was a series of articles that you gave me.
That's fine. I mean, we can do that. We can do that. Because it really is about size. Should I jump to the couple of comments from yesterday since I'm here?
I don't know if we're
About
ready yet.
the costs?
Yeah.
It was a very simple, you're right, that the calculated section of the Marshall and Swift numbers does include architectural fees. However, it is for average and typical sites, of which this one has the subsurface conditions that will require additional work by the architect. So I don't think it gets wiped out of the soft cost, but can certainly get teased out and probably reduced a little bit. Nonetheless, truthfully, the as-of-right scenarios, if you make that adjustment, still will nowhere near gain any viability whatsoever.
Okay, but it just wasn't architect's fees. I don't want you to limit it to that. As I said yesterday, there were architect's engineering fees, plans, plan check, building permit fees, surveys, some construction loan interest for the duration of the project, materials and labor, and contractor's fees. And I have two links which I gave to the project manager so you could see what I was talking about. Because it just seemed like double dipping, because you've got a full array of soft costs that cover all of those things and a couple of more.
Right, but it's not totally, it's not, what I'm going to say is that, like I just said, is that I think that a lot of that can be teased out to see where there's a level of duplication, but those Marshall and Swift numbers are for typical and average sites, of which this has additional issues.
I think the only addition is the piles versus
I believe this is a very,
standard
very
But nonetheless,
construction,
I
right?
think even
This
if
is a
it's
very
in-
typical site when it comes to engineering. What is the difference between
No, I
this
think the
site?
subsurface issues
There
does
is, there
make
is
it
no,
to-
there is no issue with there is no significant issue with the subsurface. What is the difference between this site and a very,
No, well, but the average, if Marshall Swift assumes an average typical site, meaning that doesn't have water issues, it's a.
But you're not building a cellar.
you're not going to the water issues because you're not building a cellar, right?
But the reason why is partly because of the quality of the soil conditions.
You're not
I'm just saying
dealing with
that's
that.
different than what is assumed and represented by Marshall and Swift, which represents an average typical site, which it does not assume subsurface soil issues or any other things that make the site different.
I repeat it
That's
for
all.
the third time,
Okay.
because you're not building a cellar, you're not dealing with the subsurface. Period.
But you still have to deal with the issue in terms of
What
permits,
issue?
inspections, and drawings and so on.
It's the same.
Okay, I'm just saying that I don't see taking all those things and making zero out of it.
In your financials, in your latest financials, you have two items that need to be eliminated. The soft cost and the environmental, which was not explained.
No,
before,
certain
and we
line
asked for
items, no.
explanation.
Certain line items in the soft cost can get reduced, but it's not
No,
zero on the whole, so that's
No,
not how
I'm not
soft costs
saying
are.
zero on the soft cost,
No,
but you
well,
have
that's
to,
what,
your soft costs on the
that's what's
proposed are
being
637, and when you add it to your hard costs, you
Mhm.
get a price per square foot that's a lot higher than Marshall and Swift. A lot higher, and I don't think that there is that much additional price to your architectural and engineering fees. Maybe there's more hard costs because you're putting in piles, but I think you're counted for that already. So I agree with Commissioner Shetta. In
It's not
fact,
gonna go to zero. I will look, line item by line item, I will look at it, and we can determine what is duplicate and what is there due to the conditions on this.
I would
And
assure
I
you
will,
that-
I will spell out what exactly I'm doing and for what reason.
I would assure you that when it comes to the soft cost, the engineering for the helical piles, the kind of piles you're using, it's much cheaper to construct using helical piles from the soft cost perspective than when you construct on subgrading. So actually, your soft cost, you shouldn't see any difference in the soft
Well,
cost.
look, the scenarios that here, we provided an approach with the plans and number of piles and so on.
I'm not talking about the number of piles.
No, I know that, but we addressed that in the last submission. And I'm just saying that I know you want to be able to suggest a different design and so on. I would like to be able to stay with what we have, review the soft cost line by line, and adjust accordingly based on the calculated cost in the warrant.
I'm not buying that. I'm sorry, I'm not
Okay.
convinced by that,
I would
because
say
I
I will, allow me to take a closer look, and I may come to your decision, but allow me the opportunity to take a closer look and
In addition to
determine
the
what.
environmental cost. Yes.
So I just would like to point out, I'm trying to do research while we talk, right? 160 Van Brunt Street, which is it's an office building that either is very new construction or very expensive renovation, which is in fact built or renovated as offices in Red Hook. It's very close to this site. And so we can, let me just finish my sentence. So if we use that as an example, because the statement that there's no new office spaces for sale, for rent or sale or being developed in this area is not correct. So, but it's an opportunity to compare. We're asking for, what is it about a 35 by 100 lot where you can build what you can build on it? What is it about it that makes it viable or not viable as office space? And, and I do have to say, you kind of undone a lot of that argument for me by having office space in this building. But at the same time, I'm looking at new office space that's for rent right now, and where they obviously spent a lot of money on this. And so what's different between this kind of development and the type of development that you're proposing that would make yours not viable from a practical perspective, not a financial perspective, okay? And there are examples, I just happen to find that one.
Yeah. My name's Marshall Sohn, I'm the applicant, and I just want to bring a little reality to this hearing. First of all, with respect to 160 Van Brunt, that was the old Golden Marine building where they reworked the camshafts for these huge cruise ships, which was later leased to a company called Tesla, which put their retail and put the space in there, and the building was redeveloped, okay?
Right.
And Tesla is the main tenant, is there, it's a corner piece by the water, and, it's a great building, but it was an existing building. When my council referred to ground-up construction, that was not ground-up construction.
This costs a lot of money to gut
Oh,
renovate.
I'm not saying it.
Right, so let's just talk about.
It costs a lot more than
yes.
Swift and Marshall. I guarantee you
Right,
that. And I guarantee you, Tesla's also a tenant of ours in 104, 106, and they're parking cars there. I know how they operate. With respect to why this building was set as a residential with office space, there was a specific reason for that. I had to go in front of Community Board 6, and they knew I was also the applicant on 9698, which we applied for with Slater and Beckerman, which we applied before this board for a variance for residential, which was granted by this board, which they made the A findings and they made the B findings, and that was approximately 5 years ago. When I approached the board to discuss, plans for 104, 106, they were concerned, because they were concerned that they wanted to keep some commercial aspect with respect to the property. As I said before, I didn't think that retail was that great of an idea, and they certainly didn't want anything that was that would involve music, club, restaurant, because they felt concerned for the surrounding residential non-conforming buildings.
You don't need a waiver for a restaurant or a club, right?
I don't know. I would assume I could put some type of retail in there, but I also know that is not a great area for retail because it doesn't have the foot traffic. I've worked a lot in that neighborhood as well as other neighborhoods. So when we approached the board, we came up with this solution that I thought might work. Office with residential and maybe a live-work situation where we could actually justify, the cost of new construction. You've heard Dan Marks, who's an expert, an honest guy, graduate of University of Colorado, broker, vice president of Terra. He told you there is no new ground-up construction of office space going on in that neighborhood. We still have vacant lots in that neighborhood. I own vacant lots in that neighborhood, larger lots, which work for certain industrial uses or parking where you have larger vehicles, like a bus that might be 65 feet long and fairly wide. You couldn't really put that on a 35-foot lot. There's very limited, when you come up with the concept of office space, yes, there has been some talk about office space by Thor Equities that they were going to try to do on a 10-acre site in Red Hook. And I spoke to Morris Bealey of Thor about it. I thought it was a great idea. The problem was he couldn't get a tenant. And if you don't have a tenant, no one's going to lend you money to build something like that. Right now, things have changed in Red Hook. Things have changed somewhat in the Columbia Waterfront District. But the real change is not that article from the Brooklyn Note, which will give you a shot of Cobble Hill and some of the expensive condominiums, which are in the Columbia Waterfront District and are in Cobble Hill, and the brownstones in Cobble Hill. It's the real value that has been created by the demand for e-commerce and these large sites. So now the Thor site is probably going to be a depot for FedEx. You saw by the Valentino Pier, that's being wiped out. It was sold by Estate 4, which had all these talks about doing some office space. Well, they're not. It was sold to Cytex, which flipped it over to UPS for over $300 million, and they're doing these robotic warehouses on the waterfront. And you got others that are going there because for the last mile, this is a great neighborhood. This is a great neighborhood. Doesn't matter that there's not real great transportation there. Doesn't matter that there's not that many people there. They're going to have trucks coming in and out, and they're going to be able to deliver, within a day, some of the products that their algorithms say people in these neighborhoods will want. They can hit downtown Brooklyn and they can hit Manhattan. I think that the reality of doing a WeWork space, and I've seen WeWork in the Navy Yard. It's absolutely beautiful. But that's the Navy Yard, okay? And they've done an amazing job. Would I invest a dime in that company? No way. I mean, I don't think that's I don't think what they have is a viable game plan. And I think, I was just reading articles today where...
You don't think WeWork is a viable game plan?
No, not a viable. They can't.
Public?
Their last round of financing went at $47 billion with SoftBank.
Well, let's just say they made a lot of money and then maybe it's losing its whatever, right, its shine, okay?
The difference, they lost billions of dollars in the last year. And I have to say, the owners, and I know one of them, they've made a lot of money because they sold their stock ahead of the IPO.
Right, but let's not use WeWork, which is this huge international thing. What we're talking about is co-working, incubator space. I'm looking also right now at another little site, which is right near this site, which granted is not ground-up construction. It's 138 Union Street between Columbia and Hicks. So
138.
138 Union, it's 2 blocks away
Yeah,
from the
it's
site.
empty. It's
So
empty.
it's not ground-up
It's empty.
construction, but it is a shared co-working
Yeah,
space. And so to say that there, and to say that, never mind about ground-up construction, we're talking about whether these are viable uses in the area, and then I'm seeing these
You know,
uses in the area.
I'm no expert on this, Commissioner, on the A and the B, and what's viable and what's not viable. But I know that space is not new construction, it was an existing building.
Right, it
It was
shows-
used for a while, and it's vacant as now, because it's right near Nancy Hare's cut is up the block. And it makes a big difference between new construction and an existing building, because the whole financial issue is what you can do with this property. It has to justify the cost of building a new building in order to get to that use. If not, you have a hardship issue. If you had an existing building, you have a totally different situation. You have something that, yeah, it might be obsolete, whatever. I can put a few desks in there. I can rent it for less. It might have a lower, tax base, whatever, lower tax class.
So I want to bring this up one more time.
Okay.
In this little building, which has very small floor plates, this is 1250 square foot on each floor, because it's only a 25-foot wide frontage.
Right.
Right? They show a layout here, so I can understand exactly how many desks there are available and which are the private offices and so on. This is a little either shared or co-working or however it's working, because it doesn't necessarily have to be a co-working space. If you can only build one FAR on your current M11, but we know that on these little sites, you can get a viable co-working or a viable, let's say, creatives type space. Let me just finish my sentence. A viable creatives type offices, but it's because you don't have enough floor area. Because what I need to bring up again, and I need to direct it at your council, is that what the main complaint is here really is that this is a 1 FAR zone. And the ask here is to be allowed to have 4 FAR in a 1 FAR zone, and a major change in the use, i.e. residential, where we just saw from that article that says it's the highest sales area in Brooklyn at $1.4 million, the average unit. It just says that in the article here. And so that's a highest and best use. That's not what a variance is for. A variance is to relieve the claimed hardship. So I would say, personally, the claimed hardship is that you don't have enough floor area to justify an allowable use. And if you needed 2 times the floor area or 3 times the floor area for an allowable conforming use, I would be more sympathetic, because I do think that the site doesn't have enough floor area to justify the conforming use.
With all due respect, I believe you're incorrect, okay? I owned 131 Union Street, which was the Citibank building on that block. We tried it as a shared office space. That had even a bigger floor print. We couldn't do it. We couldn't make the numbers work, even on an existing building. They have an existing building. The fact that they rented it out at some time as a shared space and use it as a shared space, to you is complete evidence that it works. Well, it's vacant now. To me, it doesn't work, okay? Unless you see the financials, you're making an assumption that I think is incorrect, and with the amount of rigor you demand from everybody else, I think that rigor should go both ways. I think if you really believe that and you really think that's accurate, then that information should be presented. We should get a subpoena, bring the owner of that building here, and find out if that's the case, because I'm telling you it's vacant. I mean, take a look at it. I pass it all the time. They're trying to figure that out.
Yeah, this is no longer a productive conversation.
Right. No,
You know what you have to do, and I would suggest you just do it and do it fairly quickly.
Actually, I was, before this debate, I was under the impression that the job of the applicant is to convince the board. But I see that the discussion is heading different way now. The board is trying to convince the applicant, which is not healthy for us. I don't think we should be wasting more time than that.
I don't think you should, frankly. I know you may want to, but I think you should hold your tongue. Because, you know, the longer, unfortunately, the way these cases go, the longer you're here, the more doubts are brought to bear. And so you could stay and you can talk to me as much as you want, but you're probably going to dig a very large hole for yourself. So if I were you, I would just, you know what your directions are. If you do want this variance, then you need to follow your directions and not suggest directions for us, number one, and not talk anymore. Because we're trying to divorce the market argument out of this uniqueness finding. We have a threshold issue here. We don't want to open this up for the 50 millionth time so everybody can come in and say, my lot is less than 100 by 100, I can't do anything conforming. We don't want that. And so you understand, convince us.
I understand your position.
Thank you. Thank you very much. And someday, if you meet me in a bar, we could have that market conversation.
Right. Okay, yeah. Are there any speakers on this?
Any speakers on DeGraw Street?
Okay, good.
Are they going to need a while to respond?
They're going to need a while, but really, this is the last, I mean, the last one was the last time. Maybe, I don't know whether we should just close this and reopen it if if there's more.
But are they going to convince us that the one-story office building that they are currently proposing is not going to work? Or would we open the venue for them to propose some more floor area to add to that proposal and look into probably larger floor plane and see if it's going to work? Honestly, I'm looking at the financials, and I don't want to talk about this because I got divorced from the financials since the last hearing. But looking at the financials, if you unplug the soft cost out of the equation, that proposal, the office building, seems to be on the verge of being feasible. So I believe if we just jack up the floor plate a little bit, it
With
might
a
be
minimum
even
variance.
Yes, it might be even financially.
See what happens when you keep talking?
Right,
And
right.
things get longer and longer?
Yes.
People start to think about other things. Let's just cut this.
No, we don't want you to talk anymore.
No more
Sit.
talking.
No, right. But I think one of the points that Commissioner Otley Brown had made yesterday was, we still don't know what the minimum variance is, so there's an assumption here that even if we could find the A finding, that you're able to establish a clean A finding, that the requested 4 FAR is the right amount of floor area. I'm not persuaded, the numbers don't persuade.
1.91.
Oh, sorry, it's 1.91, okay, sorry. I'm not persuaded that that's the right amount to ask, and now as we come up with more things, right? I'm not persuaded that residential use is the necessary waiver. So you have a lot of work to do to persuade all of those things, and if only you'd answered the question that we presented at the very first hearing, which was give us the proof, physical proof that the allowable use isn't viable, we wouldn't be here today bringing up all of these other things that came up since. Okay, so yes, need time.
Okay.
Um,
So
year?
December or next year?
December.
Okay. So how about December 17th with the submission on November 27th?
Okay. Please listen to us.
Okay.
Okay.
Item number 29, 2018, 116 BZ, 1982 Utica Avenue, Brooklyn. May I remind the board, we only have this room until 9 o'clock.
We're almost done.
Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, and to respond honestly to board member questions? Somebody left that pen. I think that's it. That's Lori's pen.
Elise Fullader from Eric Palatnik's PC. Good evening, everyone. We heard your comment about the vacuum cleaner, and it was removed, and it was removed from the plans, and there was a photograph of it taken removed, and I submitted it last night, and I'm hoping you got it.
And showing landscaping in that back area on the drawings?
Well, there was, the whole strip was planted along the rear, that was submitted
That has
before.
been submitted, yes.
No, not that strip, but the area where the vacuum was.
Oh, I didn't, that
That's
wasn't
right
on
next to
the
the
original plans.
Yeah, that's right by the side of the building.
Yeah.
So she
Yeah.
couldn't landscape that.
Right. I think we had asked them to extend the landscaping along the
Yeah, that was-
residential
yeah,
lot
So I
lines
guess
all
I have
the
to
way.
look at the submission, I don't know.
All of this was landscaped with
Right.
large trees. I did like $40,000 of planning, plus spray
Yeah.
planting.
Okay,
And then there was a vacuum cleaner they put right along the building. and they took
right.
that off.
Oh, I thought we said we would landscape, oh, maybe that was the trade-off. I thought we said we would landscape the area where the vacuum cleaner was.
It was back here.
Oh, it was back there.
And they took
Okay.
that all away and they.
You had two, you asked
So
them to
there
do
were
one.
two.
And you
Can
took out one.
Please? So there was one that
There,
was
yeah.
located, and that we had asked, the
Take that
trade
out.
was, put that there, vacuum and the wash, car
Yes.
wash, located here, and extend the
Planting all the way.
planting there. This one, we had not.
We said take it out.
We had asked
Oh.
that to be removed, but no replacement of any plants of any sort,
Okay.
because it was right next to the building.
Okay.
Oh, that's right, it was next to the dealer, and you put parking, right?
And, right,
Yeah,
and it's a
yeah.
All
handicap.
of those
Yeah.
blocks were taken out. all the
Yeah, the
landscaping
blocks were removed.
So that was submitted yesterday. When was this submitted?
Well, these plans were submitted a while ago, but what they did was they put a vacuum on the side of the building.
Right, right.
We saw that in there, and then we submitted yesterday evening
Okay.
a plan that shows no vacuum there and a photograph of it removed alongside that.
Yeah, okay, very good. Love it when you're like so responsive. It's like a model citizen.
Thank
Okay.
you. That's the best compliment I could have. Wow, I'm going to tell everybody in town.
Right?
Thank
They
you.
can watch
You
the
can-
video.
You can clip that part.
Oh, okay,
and
thank
Carry it
you.
around on your
Wow.
phone. Okay. All right, then. Are there any speakers on this? No. So I'd like to make a motion to close.
Chair Promoter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Shetta? Aye. Commissioner Shabeta?
And I'd like to make a motion to grant on condition. The first condition that we talked about, that the car wash operation has to cease at midnight. We talked about that a long time ago. And then there was also a note on the drawings that I'd like in our conditions that said the site grades, that's about the car wash, shall be configured in such a way to ensure no water outflow from the site to any of the adjacent properties with respect to the car wash, and that all water from storm and car wash within the site is directed to the 4 drain inlets shown on sheet Z001. And these drain inlets should be maintained operational, if that's a sentence. And then the other parts are the standard, that landscaping, fencing, asphalt or whatever the paving material is shall be properly maintained, lighting directed off adjacent sites, and graffiti and debris removed immediately. And I don't know if I left anything out. Anything else that I might have? Okay. So based on that, conditional grant.
Motion to close?
Yeah.
Chair Promoter?
Yeah. No, I
Thought
closed
we closed
already.
it. We closed it. No.
I'm sorry, sorry.
This is the grant, conditional
Motion to
grant.
grant, sorry. Chair Promoter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Shetta? Aye. Commissioner Shabeta?
Thank you. Have a great night.
New cases, item number 1, 2018-177BZ, 2061 Ocean Parkway, Brooklyn. Yeah. Raise your right hand. Do you affirm to tell the truth, the whole truth, and none but the truth in your testimony before this board, and to respond honestly to board member questions? Okay, thank you.
Good evening, Lyra Altman from the Law of Lyra Altman. We did have somebody attend your executive session yesterday.
Speak up into the mic.
Sorry, here we go. We did have somebody attend your executive session yesterday and heard your comments. To begin, you'd like a Sanborn map, we'll be glad to provide that for you. With
I
respect...
just want to point out, that was in the notice of comments. Should have been supplied.
I apologize, I will make sure to get that to you. With respect to a survey, there was a request for the survey, well, I should say, a survey that shows the heights of the adjacent buildings behind it, to the right and to the left. I will show you that we do have our survey, and our survey does show the house to the left.
Now, when you say your survey, done by a
The survey-
licensed surveyor?
Of course.
Oh, so, but it's, what? Is that included in the submission?
It is not, I've now obtained this.
Oh,
I'm going to hand
okay.
this up to Steve to see it. What you see is the home to the left is built 3 stories according to that survey. In addition, we've already submitted to your board a rear yard study that shows the home to the left as having a 20-foot rear yard. That's also confirmed if you look at the rear yard photos that we've submitted to your board. It is photo 10 that would show you exactly what I'm referencing, and I will hold it up for you as well.
This one? Yeah, those are always so hard to tell what's going on. Okay. And then the building to the right, which is the south, is a 2-story brick, right?
That is correct. You'll see that in image 5 of the rear yard photos. And I can hold that up as well. That's right here.
Okay.
These have already been submitted. I should point out that that was a BSA approval, that adjacent building under 2057 Ocean Parkway is the address. With respect to the floor area, we also looked at what was going on in the neighborhood, and we submitted a floor area study to your board. In the floor area, the 400-foot radius in just the R5 district, because we do clip a little bit of an R6A district, we didn't look at that, of course. What you will see is that there are 14 homes with FARs that range from 1.2 to 1.58. Interestingly, the one just to the north, the one I was just showing you the image of it that's on the survey, has an FAR of 1.22, but as your board often looks at the floor area as well, I will point out that that 1.22 translates to a floor area of 6,083 square feet, whereas our proposed 1.27 translates to an FAR of a floor area of 3,977 square feet,
But, so
quite a
the-
bit smaller.
But the question is, if 1.25 is allowed as of right, the request is for 1.27, and the architect included the shed.
Right,
Why?
if you look in zoning resolution section 1210, what you'll see is accessory buildings are required to be included. I think it's 1210H under the floor area definition. The exception is when they are for parking of a car. I can show you that.
We never see sheds included in floor area.
I can show you that right here.
Can we say BOB too? Like greenhouses? Do you?
Floor area includes H, floor space in accessory buildings, except floor space used for accessory off-street parking.
Does it have a foundation?
Just printed last night.
It doesn't say shed, it doesn't say
But that's
foundation.
printed
No,
right
I
off
know,
last
okay.
night, off of the enhanced version.
But we
of the-
No,
never
but does
see.
the shed have a foundation?
I don't know if it has a foundation. I
Well,
will
they
tell
said
you
it's
that
a
it has.
masonry
It has been included in floor area in many applications. Anytime we have a shed, we do include it, as we have to.
1210.
We don't ever include, of course, a garage because it's not included under H.
Okay, keep going, we're doing our thing over here.
Absolutely. See what other comments we had here. I'll get you the Sanborn.
I have a question. So
Yes.
this building is not, this accessory building is not used for off-street parking?
No, it is not. It's a shed. It is too small to be used for parking of
How
vehicles.
small is it?
10 by 12.
I was going to say, I'd have to look at the dimension. But a proper parking space is 8 by 18, which it certainly is not.
So, hold on a second. Oh, that's an accessory use.
Yeah, you're correct. It is 10 by 12. Thank you, Commissioner Sheta. And I believe the only other comment yesterday was regarding the demo plans. We do have somewhat of a demo plan at the rear of the proposed plans, if you were to look at page.
But we have this standard requirement for demo plans. I don't think there is a demo plan.
If you look at pages P16, which shows the existing linear feet, and P17, which shows what's being maintained. Very back of the piece set. If you'd like it amended, we'll be glad to amend it in any way you would like.
Oh, wait a second. Okay, so total existing linear feet versus, oh yeah, that is a sort of a demo plan.
Yep, and you can see it's
Yeah,
done by
it's a
floor
demo
and by
plan.
total.
This wasn't submitted as a separate set, P17?
Right, it's often attached with this architect, he often attaches it to the back of the proposed set.
Well, we're rapidly producing a standard, so there won't be any more,
When we have
hopefully,
something in...
confusion.
Oh, that'd be wonderful, we look forward to seeing that.
Okay. Okay. That's so weird. We often see storage sheds not counted, or they call them
I
garages,
think they
maybe.
call it garage, and oftentimes they get the, that bonus.
Yes, the 300 square foot.
300
But that's only for new
square foot.
buildings, the 300 square
So I think
foot.
we need to make sure in the plan, we indicate that this is an accessory use and not an off-street parking, and note be added to the plan.
We're
And
okay
not-
with saying...
And when you hatch it out indicating areas that are not counted in floor area, hatch that also.
No, this is
This
counted
run-
as floor
Oh, no,
area.
this is counted
I was
in
gonna say,
floor
I'm not
area.
sure.
Sorry,
Yeah,
I meant the other way around.
No, so-
Mixing it with
Mixing things up,
3925
mixing things up.
Bedford, I understand.
Right, right.
So,
Mixing
so.
things up.
Been a long day.
It's labeled as proposed masonry shed, so in order to do masonry, you must have a foundation. So,
If it's a permanent structure by the building code, it should have foundation.
right, but so a lot of the times they talk about them as temporary sheds and things like that, which we know there's no such thing as a
Yeah,
temporary
no, this is
shed,
not
but they
temporary.
they just order something from Home Depot and they erect it on
No,
nothing.
that's certainly not what they're looking for here.
Yeah, okay.
Well, the floor area definition under subdivision H states, and this I think is what you were getting to with the off-street parking, is that floor area includes floor space used in accessory buildings, except for floor space used for accessory off-street parking.
Correct.
Yes, that's what she's referring to. But I thought we had like accessory. Yeah, okay. All right, so then I don't think there's any other issues, right? We're okay with the 1.27 FAR, everybody? Because this is an R5, right?
It is,
Yeah,
yes.
R5. Okay. All right, are there any speakers on this? Then I'm okay with this, so a motion to close?
Chair Promoter?
Aye.
Commissioner Chanda?
Aye.
Commissioner Brown?
Aye.
Commissioner Shetta?
Aye.
Commissioner Schubert?
Okay, oh, and the survey should be submitted,
And the second one.
and the Sanborn.
Survey and Sanborn, will be happy to submit both.
So then we closed it. I don't necessarily know whether we can vote. Can we vote?
We can leave the record open.
But that means we don't vote, and we leave the record.
Oh, I'm sorry. Never mind.
However you
Do you
want.
have the Sanborn?
Can you submit the Sanborn and and do it on it's kind of late for a second call, but,
I can't get you, we obtained the 1929 Belcher Hyde after your executive session yesterday, and unfortunately, the lot was not two separate lots at the time, it was merged with some adjacent lots. So I'm going to have to get you a more recent Sanborn from 1929. But I will get you something pre-61 showing this lot existing as is, because the building was
so
the
we
same.
need that, it's basically. So
My
we-
pleasure to do that.
We can close it just to make it clear to us that don't have anything else to look at except, but we need the survey and.
The survey, meaning the one that I just handed you
Yeah,
approving. I'll be glad to
survey.
provide that to you.
And Sanborn.
How much time would you need?
I can have it by the end of this week. The survey I already have, as you know, the Sanborn, usually their turnaround time is 24 to 48 hours from EDR.
So what does that mean? You can have it?
If I order it tomorrow morning, because obviously it's a little late tonight, I should have it by Friday morning at the latest, 48 hours. That's typically their turnaround.
I don't want to get it on Monday. and then we don't
Yeah.
have it. Let's do it for October.
Okay. Okay, so,
I mean, I can request a rush if that would help, and...
But then if it doesn't come, then.
No,
we just
understood, I'm
schedule
fine with
it.
that.
Okay. All right, put it
So
on for
going-
one of the not too. We just,
we need to do math.
If I may, I'm just going to grab my phone for a calendar.
Okay, so a submission by October 1st for a continued, or decision on October 22nd.
We can't do October 22nd, I apologize. That's Simchat Torah, which is a no-work day for my clients. They wouldn't want me to be standing up here for that on October 22nd. Yeah, but I could submit early, that's not a problem. The hearing date is when it is. 10/22, we can't make work, I apologize.
What's after?
October 29th,
How many on that one?
25.
We can make that work.
So October 9th submission for an October 29th hearing.
We'll make that happen.
Decision.
Thank you very much.
Item number 2, 2019-29A, 30 Clinton Avenue, Brooklyn.
Yeah, you were. Good thing I wasn't paying attention to you.
What happened? I gotta see everybody.
I was thinking 8, so I think I'm...
Do you affirm to tell the truth, the whole truth,
thinking
and nothing but the
5,
truth in your
so-
testimony before this board and respond to board member questions? Okay, sorry. Sorry,
Richard Lobel of Sheldon Lobel, PC, for the applicant. Good evening. Chair, Commissioners, we are before you today on a special permit pursuant to 7319 of the zoning resolution. As the applicant team signs in and posts various plans, I will just briefly retell the salient facts, and then we can go into a substantive discussion, focusing on the board's comments from the executive session. The applicant is proposing building a school within an M12 zoning district. The building would be located at 50 Clinton Avenue between Park and Flushing Avenues in Brooklyn Community Board 2. The building would be on a lot which is 143 by 100, a 14,300 square foot lot. The lot is able to house a building of roughly 50,050 square feet on 5 stories. The building would be populated by the International Charter School of New York. This is a school which is an existing applicant. The school has been in operation since receiving its charter in 2014 and has had students since August of 2015, and so currently has an operating history which includes 2 locations numbering over 450 students. The school is quite excited by the prospect of uniting these grades within one student school population in one building, and to be able to have all their operations on this one site. Of course, the applicant has attended the executive session, and so we can address the board's comments really briefly. Of course, these comments are in the context of 7319 and the special permit findings. Briefly, the A finding, which requires that the applicant have undergone a search for a site where the school can be located as of right. And there was some question at the board's executive session with regards to the A finding, specifically the applicant's purchase of this specific site. To correct the record, the applicant would be leasing the site. So 30 Clinton LLC, which is the owner of the site and operator of the site, would be the developer of the site, and has representatives here today, is the owner of the ground lease on the site, whereas the International Charter School would be the lessee. So the considerations that they put into finding a site were in finding similar rental properties. As per the letter submitted by the applicant in December 2018, the applicant ran through roughly 11 sites within the affected school community district, and basically differentiated this site based on several factors, including the fact that there would be new construction here, the fact that this was located in close proximity to its existing school population. So there were really many positives which weighed in on the applicant's choice of this site.
So just to clarify, 30 Clinton LLC is an arm's length relationship to the school?
That's correct.
No relationship, no board members sit on it and sit on
That's correct.
oaths and all of that
And
stuff?
I can confirm that through testimony, but there is no, it is an arm's length relationship.
Okay, and so that property owner
will develop and pay for this site and then lease it to the school? Is that how it's working?
Yes, that's correct. And to the extent that the chair requires testimony on that, we can provide that, but that is the nature of the relationship. Okay.
So then in terms of the search?
Sure.
Search needs to be clarified that they also looked for those kinds of things where a developer was interested in building. We've seen a number of these kinds of schools recently where developers building a commercial building, initially maybe even wants to put offices in the building, and then eventually a school comes and maybe the offices go, or that's shared with offices, that kind of thing. So it's not unusual, but we need to clarify that the search included those kinds of possibilities.
We're happy to do so, either through the testimony of the executive director, who's here today, or additionally through supplemental testimony, but we're confident that the A finding here is met.
So is it a ground lease or is it a building lease?
The school is in a lease for the building.
Okay, so it would be,
Okay.
and the school is the building tenant.
That's correct. So then we move on to the B finding, and of course, the property is located within, as the board noted in the executive session, 130 feet of an R8 district immediately to the west. We'd also note that just as a matter of local character, the building backs up onto no fewer than 13 three-story multifamily buildings. So despite the M12 designation of the block, there is a very strong residential presence immediately adjacent to this property.
Immediate behind.
Correct.
If only it were adjacent or
We know.
across the street. Because behind is
Right.
actually not affecting
We're getting to
the
that.
main issue, right?
Sure, correct. The C finding with regards to sufficient noise attenuation and other environmental measures to mitigate impacts that will be discussed in detail by the environmental consultants who are here today. And of course, we go to the D finding, which is the finding regarding school safety and the fact that children and students may be delivered to and from the school in a safe manner. We think that as a matter of record, the applicant has had now 2 meetings with DOT, school safety, and so I think that the materials and the discussion has advanced beyond what the board maybe has seen and focused on with regards to DOT letters. So since the last letter from DOT in May, there's been subsequent discussion and submission of a school safety plan, student safety plan, and so because this is in the vital interest, both under the 7319 special permit text, as well as of the school and the applicant team to make sure students are delivered safely to the school, we have the opportunity of not only having Equity Environmental, which is the chair and the board knows is an experienced environmental consultant on the applicant team, but have also hired Sam Schwartz Engineering, widely recognized as one of the premier traffic and parking experts in the city of New York. And so representatives will be discussing this in detail, in part based upon plans which we'll demonstrate to the board. So the issues with regards to the executive session that were raised, of course, those are basically tracking some of the issues in the special permit generally. I would break those down into the kind of legal application issues, design and architectural issues, and then environmental issues inclusive of parking, and more specifically, traffic and school safety. We already discussed the fact that we can respond with more specificity regarding the applicant's search for a school of sufficient criteria. The statement of facts, I know that there was a discrepancy between the projected growth numbers between the EAS and the statement of facts. We'll correct that. We did check that, and the commissioners were correct that needs to be changed in the statement of facts. I think at this point, at the discretion of the board, I would introduce the project architect, who can discuss both the fenced area in the front of the school, as well as there's an elevation reference point which needs to be changed, and in addition, the response to the FDNY letter.
The updated?
FDNY letter, there's a response that the architect has submitted.
To download.
Hi, Commissioners. My name is Joe Sultana from JLS Designs. So I can speak to you quickly about the setback in the front. We're using an alternate front setback for this project. So the front facade would be perfectly straight for 5 stories. That 10-foot setback would give us a sort of public-private zone. We're proposing a fence there, so have some privacy from the school and the street.
So it's only a 10-foot, not a 15, it's a 10-foot setback?
It's a 10-foot setback, and then it'll go up 60 feet.
Right.
As far as FDNY, we
Well, before you do that, so there's this fenced-in area. How does that work? I understand the idea, I mean, I think it's a good idea to have used this, I didn't realize it was for alternate setback, but it's a good idea to have pulled the building back because it gives you a wider sidewalk, which will potentially can address some of the scary issues that DOT is concerned about, but I don't understand the purpose of that fence.
Well, we're proposing it in some areas, it's a low fence, it's not a very, very high fence.
No, but what's it for?
It's just a privacy zone.
But then it's obstructing the sidewalk, how?
No, it's
does
not
it-
obstructing the sidewalk, it's along our property line.
No, so if the concern of DOT, and I don't know if you've been hearing about, or maybe you've been participating in these concerns, DOT is panicking because the children are on the sidewalk and there's, you know, the forklifts and the skids and all of that sort of stuff. And the issue is that the children en masse are going to be coming out of the building or going into the building from drop-offs and buses and so on. And so what we've seen sometimes in really good situations is there's a great place to put the kids so that they can stand safely. And what you're doing by having what I can't really understand, this enclosure, is you're obstructing your own potential of gathering the kids, unless the idea is to put them behind the fence,
Chair.
in which case the fence would be bigger.
In recognition of the comments we've received, there's already been some internal discussion regarding using that space as a staging area for kids coming into and out of the school. So I think, quite frankly, that the applicant would be happy to incorporate that into our school safety plan and to do that going forward.
Oh, in other words, the fence either gets bigger or goes according to whichever way it is. Okay.
Based upon the expertise of traffic safety consultants, we'll basically figure out what the optimal use of that space is and incorporate that into our plan.
You know, we actually have I'm not sure how they handled it, but we actually had a school before us,
That was part
of a mosque, right? No.
Oh, are you talking about?
That had a whole fenced-in area. Some of it was illegal, and they needed to get a revocable consent. But I'm even curious about that. Like, would this be safer if this was more like a stoop on city property? I don't know. I'm just throwing this out. So if you had, in addition to your 10-foot setback, you had whatever's an allowable stoop depth, and that kids who get out of the bus immediately go through a fence, and all the kids are hanging out behind this fence, would that be better? Would it be worse? I don't actually know the difference, but at least it's kind of like they're caged. They can't get hit by a truck.
Yeah. No, we've again, Chair, we actually have discussed that as one of the options that we
Okay.
discussed with specificity. We're happy to come back to the board with that.
Okay.
Do the students stand outside? It was my understanding from reading that the, I guess, assistant principal, dean of students is standing at the entrance, like going, come in, come in, come in.
Right, and the cafeteria is kind of like the holding.
That's
area.
correct.
Yeah.
I think maybe just we would let the architect finish his discussion and then launch into that.
Okay, so next up, FDNY. So we received a letter from John Daly, and we're responding to it. The roof has two different levels.
Speak up into the mic.
The roof has two different levels. There's one at the fifth floor, and then top of the gym would be at another level. So the two roof levels actually connect together with an exterior staircase that goes from roof to roof.
Right.
We have a fence at the lower level, which is the recreation space for the children. We had it designed where the fence was on top of the parapet wall to create a 10-foot barrier. And reading the letter from FDNY and responding back to them, we're going to take that fence, we're going to move it back 6 feet from the parapet wall in order to give FDNY a landing zone at the fifth floor. And the upper roof at the fifth floor is very easily reached by fire apparatus. Parapet there is only 3.5 feet.
Okay. I know we had a daycare center actually that did exactly the same thing as you're proposing, and fire department had a lot of trouble with the access to that upper roof. So eventually they figured out how to deal with it, so we're aware of this kind of problem where you're sort of doing this split level roof idea. Yeah.
Are you proposing to use both the roof levels? No, only the lower roof.
It's just that
roof
because they have a staircase that goes up to the upper roof, and the fire department needs access to both roof levels. You see, there's this bridge that goes across, and that's a roof there. Fire department also needs access to that. And so, however
Is
you
that the
work
one
it
with
out.
the catwalk on the roof?
Yeah.
That might have been 673 Driggs with the, yeah.
Right.
Your project.
Yeah. And then, is this the staring?
Or Franklin, right? Also known as Franklin?
Yes.
Yeah.
That's the staring
That's the one,
pusher,
yeah,
and
I
they
was
ended up taking it out.
They had to take it out because it
But
was
there is
illegal.
a
Right.
fenced
Yes.
portion.
Right, and there are a lot of schools, I think often old parochial schools, that have these fenced areas for the kids. I don't know if it's a good solution, it's just maybe something that responds to DOT. Anyway, okay.
And the last issue is the elevation on our drawing is based on an NAVD of 88. All the surveys that we received after Sandy have that elevation.
Okay.
That's what we're using. Thank you.
As the student drop-off was raised by the board, I think perhaps it'd be best to have the environmental and traffic consultants discuss the school safety issues.
Good evening, Amber Cartalian, Equity Environmental. So, you guys had questions about the loading and unloading, so I just want to start by discussing...
You need to speak up.
Sorry.
Yeah.
I just want to start by discussing the arrival and dismissal protocol, just so we could be more clear on that. And so, the property frontage is approximately 140 feet, all of which would be designated as a no standing school days zone for drop-offs and pickups. Students would be held in the cafeteria, and there would be stewards along the street frontage that would escort children out as caregivers arrive, or as school buses arrive, students would be escorted in the groups and directly into the buses.
So how does that actually work? So caregiver arrives, what happens?
There would be stewards, and they would, have a pass or say, I'm here to pick up Johnny, and they would then call him and usher him out of the building.
So where does the caregiver go? So caregivers, let's just say, let's leave out cars for a minute. Caregiver arrives on foot. What does caregiver do?
I believe I'm going to confirm with Matthew.
You really need to hold the...
Sure, I'm just going to confirm, because I know for private car pickups and for school buses that they're ushered out, but Matthew can speak to whether or not.
Hi, come to the mic and state your name.
Commissioners, Matthew Levy, I'm the Executive Director of the school. As Mr. LaBelle indicated in the introduction, we've been operating the school for, we're in our 5th year now, 460 children in 2 buildings, and so we have a range of different ways in which children arrive at the school, and obviously it changes in response to the building we're in, but there's a mixture of parents arriving on foot who line up outside the building in advance of the dismissal time, and the plan that Amber's describing here, the parents arriving on foot to collect the children would be sequenced into the cafeteria. The children are staged by their grades or classes. The parents come in, speak to the teacher, pick up the child, and come back out in some sort of in-out flow. So that's on foot.
So the parents,
Parents.
the caregivers,
Right,
the ones arriving on foot,
right.
stand outside of the building.
Stand outside of the building, yes.
Cluster in some way that needs to be really organized because you have a very nervous Department of Transportation.
Right, but they're currently doing that. I'm
Yeah,
sorry.
but are you in a manufacturing district?
No, we're on Willoughby Street where it's incredibly crowded and we
No,
compete for
crowded.
sidewalk
Is it a
space.
manufacturing district? No. So let's just get to the real point here because we have DOT extremely nervous, right? So, this is a manufacturing district
Right, so
where
parents are standing
trucks
outside.
and skids and all that stuff, and arguably, it's not as much of an issue in the evening, or let's say afternoon, because it seems like most of these businesses are winding down by union schedule, sort of. But in the morning, it may be a big issue. But let's just keep the thought going. So parents waiting to pick up their kids, cluster on the sidewalk, that needs to be organized in a way
Correct.
that we can understand.
Correct.
Okay? That needs to be explained very clearly. That's what your lawyer will do after talking to you in detail and writing it down and doing diagrams with whoever does the diagram.
But it's typically a single file line.
There is room inside the cafeteria as well.
The children are staged inside the building, the parents are staged outside the building in a single file line. They come in and come out. The process currently takes between 7 and 10 minutes.
But, so right now you have 200 kids. This is going to be 700.
We have 460 kids present.
460. You're going to have 700 and something kids. So it's twice the number of guardians, right?
Not necessarily, because the middle school children are allowed to be self-dismissed. A lot of schools
Well,
allow that.
that's a whole other subject.
But,
Okay.
but to answer the question about how many guardians and parents would be outside, a number of the children might be
Right.
self-dismissed.
So when we're talking about where they stand, we need to understand from whoever's doing drawings,
Understood.
where do the parents stand? How many parents? How's that going to be regulated in a way that doesn't create sort of chaos for the businesses and danger? And because we're in a manufacturing district, that's the whole point. We're
Correct.
not in a place where this is allowed as of right, okay? All right, so now the parents waiting online, one at a time they go in, is that how it works?
Groups of 5, 7, depends on the size of the entrance and the flow-through, monitored by the staff.
So they go inside to the cafeteria, and then what happens?
They pick up the children and come back out.
So that means a teacher is saying, show me your, how do they know who gets what? How do they know?
Typically, at a certain point in the year, the teacher is familiar with the individuals who pick up the children, but at the beginning of the year, it's quite common that as parents are getting to know the teachers, they present ID and they sign out sheets, correct?
So then that parent who's walking the kid out, arguably to public transit or down the street, takes the kid by the hand and they go, right?
Correct.
Okay. So let's do the version of a parent arriving by car. Then what happens?
The
pickup.
The parents arriving by car are expected to park the car at a safe distance and, comply with the laws. And,
But they don't, right? That's not true, right?
It's not.
They triple park. and so
Heretofore,
on.
it has not formed a significant portion of our population. We've had no interactions with FDNY, and Amber, you want to cut me off?
No, so that's the reason why, we've requested the 140 some odd foot school no standing school days zone, is so that we basically, one, create a buffer in front of the school and an area where students can be directly escorted out of the building and into their respective vehicles.
So let's walk that through, because the drawing that was submitted to us shows 3 cars and 2 buses. So parents are coming, your data shows a lot of parents coming by car, way more than 3 cars. So how does that work?
So I just want to state that because the existing school location does not reflect the grade composition at full enrollment at this proposed location, and because also they do not currently have yellow school buses, we did use just some standard factors that are more reflective and a little bit more conservative in terms of vehicular trips and school buses. That said, in the analysis and in response to DOT school safety, we did take a look at the accumulation of how yellow school buses and private cars would be accumulating in that school no standing zone, and how things would move in the arrival window of the school opens at 7:30, I believe, for breakfast, and then class starts at 8 o'clock a.m. So it's a pretty large window when students would be arriving, and we feel that it would definitely sufficiently accommodate even a more conservative estimate of school buses and
So
cars.
I'm trying to understand that. So you're talking about drop-off, we started off with pickup.
Right.
So let's just go to the pickup time. How many according to the data that you provided to us, there's a lot of pickups in the evening, right? Or in the 4 o'clock time, because there are a lot of little kids who will get
Right.
picked up, right? Plus, there's the school bus pickup, right? So there's only enough room for 2 buses, and granted, it just doesn't take them that long, but nonetheless, there's a point at which you've got the 2 buses and the 3 cars and lots of other parents arriving with cars to pick up.
Right.
What happens?
So I do want to add, because there is an after-school program, pickup is a little bit easier in that the amount of students that are dismissed during that time period are slightly less.
The after-school, your statement states that you anticipate 30% of the students will be in
About, yes.
That's still advocating.
Speak up
for-
much
I'm sorry,
louder,
you still have,
70%.
70% to be concerned with. And I understand, it seems like it states, it doesn't specifically state that you're staggering the dismissal by grade level.
It would,
It would be?
Yes, it is stated.
415 and 445?
correct. Yeah, and it would be different grades. I have it somewhere.
Yeah.
It's like
Right,
kindergarten
dismissal.
first, and then first grade, second grade.
It's like 5 minutes apiece in between each.
Right, but so how does it actually work, though? So kids, parents are coming, or the bus, let's just do the bus. The bus arrives to pick up what? Like, in what intervals, how many kids, is it by grades? Like, how often do they come back?
The buses are, sorry, the busing is figured out by the Office of Pupil Transportation based on the distance that the family lives from the home and optimized by some sort of linear programming that minimizes the amount of bus time. So the children are staged at the school based on their bus routes, not
Okay.
based on their grades.
Okay,
That's an
so-
internal function that most schools manage with administrative staff.
Before 4:15?
I'm sorry?
Are the students on the bus before 4:15?
I think this is going to be a subject of negotiations with the Office of Pupil Transportation as we get closer to the date. It's hard to say today what OPT will do in 3 years for us, right?
Right,
It's just hard.
but the question is,
Please.
for us, is you have more than 2 buses, and so what we want to know is, do the buses wait to get filled up as each grade is dismissed, or is it that everybody going to Red Hook, you get on bus A, whether you're 5 years old or 11 years old?
Correct. The buses are determined, Commissioner, based on the destination that children are going to, not their age. And that's something that the Office of Pupil Transportation does for all schools, charter, parochial, private,
Right.
district.
So the buses won't have to sit and wait to
Correct.
get filled up?
Correct. Correct.
And then held.
Correct. And typically what the school will do is organize the children internally based on their bus groups and escort them directly to their buses.
Yeah, and if I may, I think what the concern being raised, if I'm correct, it's where's the staging occurring? So
Right, so the cafeteria is providing the primary staging area, and as it stands right now, we stage children in the classroom, depending on, again, grade and stairwell configuration, and how we can move families in and out.
And then the queuing of the buses is?
Going to be organized, I mean, we're going to staff that, right, and work with the buses. Typically, again, that's an administrative function within the school.
Right.
However, contrary to that, walkers, young people who are getting picked up, are dismissed by grade. So there's a difference there. So if your parent is coming to pick you up, or if
Correct.
you're self-dismissed,
Correct.
you will go at the appointed time that your grade is called.
Correct.
That's the difference.
Correct.
Right.
Okay.
So I'm trying to understand this in a really tangible way, like almost with diagrams. Like, the cafeteria has a maximum occupancy load of, it says, I don't know, if it's 327 occupants, I don't know if you're really putting 327 people in, no, 192 occupants. So that's by no means the entire school.
Correct, because they're
right?
going to have to come in stages, Commissioner, Chair, I'm sorry. They're going to have to come in stages over the half-hour period. We're not going to have all the children down there at one time. So kindergarten and first grade typically would go, and then perhaps second and third.
Okay, so if kindergarten and first go first to the cafeteria, some of them are being met by their parents, some of them are getting on a bus, some of them are
The
going to...
I'm sorry.
Some of them are going to Red
Correct.
Hook, some of them are going to Brooklyn Heights, I don't know, whatever it is, I don't really know. So how does that work? Because the bus that's going to the other part of Brooklyn, Sunnyside, isn't there yet. It's only the Red Hook bus that's there. So only the kindergarten and first graders
are down in this cafeteria to be escorted to that bus?
It's subject to the negotiations that we're going to have with the Office of People Transportation about how many children are going to qualify for busing, which is very difficult. As Amber's explained, we're using typical load factors right now, but until we're in the building with the children and negotiating that with the Office of People Transportation, we're going to have to be responsive to those needs and structured accordingly. So I think I understand you are concerned that you don't write a blank check for a plan that feels less than concrete, and I just think that it's inappropriate for us to make you a promise. We've just given our statement.
It's not about a promise, it's about an organizational
Right,
principle.
right.
Right now, I'm hearing, we don't know how we're going to organize this. We need better. So I don't care whether, the first graders and the third graders get merged together between the hours of this and that and this. I don't care at all, but the issue is we're going to merge a certain number of kids in a certain number of ways, and then there's going to be an adult who escorts them to a spot, and then there won't be 4 buses all waiting to be loaded up, parked in that 143-foot zone with no place for the cars.
Chair, as the one who's going to have to reduce this in writing and provide
Yes.
it to the board, I think that we understand the challenges as well as the board's requirements for detail. And I think we're just going to circle back as an applicant team and come up with an orderly way to present this.
Yes.
I will tell you that we have all confidence. This school has been in operation for 4 years. They have a large student population, so they are well-versed in these issues of student pickup and drop-off. But having said that, we get it. There's different by grades, there's different by area. We'll figure this out.
And in addition to which, we have this problem where there's a lot of kids that are going to be picked up by some version of a car, right? And whether it's it's a taxi or whether it's the SUV from, whatever, they're going to have to pull up somewhere. They are not going to be parking legally. That's just not done, right? Because you want to pick up your kids. So then the next part we need to know is how will that guardian get their kid?
In practice, and obviously we can't predict the future completely, but in practice, parents have created alliances so that if the Otley Brown child is in second grade with the Perlmutter child, that somebody goes in and gets the kids and brings them out while somebody else waits with the car. Parents have shown infinite creativity in both complying with the law and getting the kids in and out of the building, and we support that. To the extent possible. Obviously, new location, different set of requirements, we need to be thoughtful about it, but I just go back to the fact that we've dealt with a mixture of cars and buses and pedestrians. We know it's not a manufacturing zone.
Yes, so we're not good on the open to creativity because DOT is freaking out about this site and the conflict between the manufacturing uses and the kids, right?
Correct.
And so we need you to be creative in advance and say, based on our experience, this is how things have been handled, and this is what we propose to do.
Correct.
Now, if parents in the future want to come up with a whole new thing where everyone has a walkie-talkie or they're all on some sort of, WhatsApp site, and everyone says, hey, come pick up kid A, that's a whole other thing in the future,
Correct.
yay. But right now, you need to come up with a concrete plan based on your experience that will lessen the fears of that agency that is concerned about children getting hit by cars and trucks and forklifts.
And I hear completely what you're saying, and I hope that part of perhaps the concern that you're expressing right now is just that the response that we made to the February concerns that DOT raised, and subsequent to the meeting that we had more recently, that when the staff absorbs that, you'll see that we've started to move in that direction, and it just may be that the commission hasn't had a chance to.
Well, we haven't gotten a sign-off from DOT. Instead,
No, I
what
understand
we've
you haven't had
gotten
a sign-off,
is...
but we're in dialogue with them.
Okay.
We've heard them, and we've made specific proposals to them in response to those. So we're not being indifferent to it. We're not suggesting that DOT's concerns are
I don't think that
without
we're
basis.
suggesting that you're being indifferent.
Great,
but
great,
Yeah,
I'm sorry.
we're just taking what you've given us and taking it like one step further. Like,
Great.
for instance, you show us like 3 cars in the first part of the site, but what about the other 20 cars? Are they held at a certain point until those 3 cars vacate? Or are people just coming down the street and I'm double parking and blocking this person in because I'm getting my kid, which happens in the public school across the street from me? Or is it more orderly when my kids went to Catholic school? somebody was out there in the road and held up cars, and only the buses came, and everybody was escorted, then the buses left, then cars came through. So we want to know every step of the way, because it is the D finding. So you do have
Correct.
to make the finding. So,
Correct.
yeah. I
Correct.
mean, we do understand that perhaps you'll start doing something on day one that clearly is not working, and you're going to have to make some adjustments, but we just want to know that you all thought it through to the very next step to the end to provide for that safety.
Right, right. And so we could do the same questioning about drop-offs, which I'm much more concerned about because, and this is where I made the comment that I'm not only concerned about the safety of the students, I'm concerned about the viability of the businesses. So this idea of, closing the road or having buses in the place where all the forklifts used to go or where all the trucks used to go, I think coordinating with those businesses, the school, working with the businesses to work something out in advance is the right way to go here, so that we're not concerned that we frankly have visited sites where kids are running between forklifts and running between all kind of skids, and they run out and there's a bus right there, or we're in the car and we luckily don't drive that fast and didn't hit that kid that runs between traffic, right? So how is that going to be regulated? And we've seen sites where they put a lot of crossing guards in a lot of places on the block, like intense amount of crossing guards, sorry?
Even blocks away.
Yeah, blocks away, where there's the really bad intersections. Other ones where there are escorts, there are like all sorts of solutions. But you really do need to work that out in detail as opposed to just promising us that it'll be fine, right? Okay.
So Jeff Smithline went out and he did a more detailed school safety analysis. I just wanted to quickly, he's gonna speak to the proposed mitigation, but in response to Commissioner Shanda, I just wanted to point out that based, the majority of our
Take the
assignment-
mic.
Amber,
Yeah, Amber,
take the
take the microphone.
So our travel assumptions in terms of pedestrian trips were, based on both the transit and the residential density. So the majority of trips are going to occur coming from the south. We went above and beyond seeker here. So at a larger neighborhood scale, you can see this is very residential in neighborhood. And we looked at 30 different intersections because I didn't want to make any assumptions about which ways or which potential ways the children could walk, because the density is relatively similar with some higher density nodes. I looked at 30 intersections. Of those 30, I want to say about 2 of them were stop controlled. The remainder were fully signalized intersections, high visibility crosswalks, no high crash locations, a very safe walk for students. And Jeff Smithline will speak to more of what he's done. And
Thank you. Safe walk for students while you're in the residential neighborhood until you hit the trucks with the forklifts and the skids and the trucks on the sidewalk and the cars on the sidewalk and nowhere to actually walk on the sidewalk. So that was what DOT, as you probably know, sent us all the photographs of that, right? And the times when that occurs it's the same time as when the kids are arriving in school. Not the times when the kids leave, but when they arrive. So that's the problem. And that just makes sense. Commercial businesses like this, all the workers arrive at 7 or even earlier, right? So that's just how like these are kind of like manufacturing businesses, right? Go ahead.
So that's a good segue. My name is Jeff Smithline with Sam Schwartz Engineering. I was out there doing a day of observations during the school time periods. We actually had other staff from my office as well, just because there were a lot of curb cuts and a lot of areas to cover. Our focus was to respond to the DOT comment letters. So there were 2 comment letters on March 27th and May 30th of this year. We got engaged after that, and we did our site visits since those letters. We have met with DOT with our proposed plan. They have not responded, I think, on the record to that, but what I'm going to do is walk you through what we did. We were out there from 7 to 8:30 a.m. on a Wednesday, observing. We did counts of curb cuts So we counted all of the curb cuts on the block. Our focus was the block because it was our understanding that DOT was really focused about the activity on this block. So 7 to 8:30 covers that, that breakfast period and the arrival times of all the students. The students actually stop arriving at around 8:10. And then we also were out there from 3:45 to 5:15, which covers the 4:15 to 4:45 drop-off with a half hour on either side. We want to make sure we didn't miss something that happened maybe a minute before dismissal one day, but that would happen a minute after dismissal the next day. So,
You missed the beginning, the children start getting into school at 7.
yeah, so we did.
Sorry.
And the children start coming to school at 7, and you said you start at 7:30?
No, we did 7 to 8:30 a.m.
7 to 8:30.
And we do have a report that was submitted. It's dated August 14th, so you should have this with you. But I'm going to walk through the details of it.
Oh, I'm just saying it's in the school safety folder.
Okay. So I'm going to use the maps behind me. Figure 1 here, which is figure 1 in the report, just shows the curb cuts. North is to the right. This is Clinton Avenue. This is the block. Flushing Avenue is to the right. This is the entrance to the Brooklyn Navy Yard, or one of the entrances. The south side is Park Avenue. So again, we're looking so that north is to the right. There are 13 curb cuts that we counted. So we counted the volumes that occurred during the hour and a half in the morning that we studied and the hour and a half in the afternoon. We have a table of those results in the report. I can give you some highlights of that. So the morning peak hour, well, actually during both peak hours, the most active driveway was driveway number 7, which is a gas station, which makes sense. It's actually, surprisingly, there's a bunch more exits than entrances, and I think that's because there's a curb cut on Flushing Avenue too, so I think vehicles are coming in off of Flushing and then using, the edge of Clinton Ave as an exit to get to the light to get back out. So the highest volume that we recorded during the entire hour and a half period for either was during the PM peak at curb cut 7, which was 23 movements. That includes in plus out, which is, which over an hour and a half is about one vehicle every 4 minutes. In the morning, it was less active. There were 12 over the hour and a half, which is about one vehicle every 7.5 minutes. Again, that's the other side of the street. On the same side of the street as the school, the curb cuts are not very active. The most active was number 4, which is the Bangkok Market, right in the middle of the page. The highest number were 7 movements during the morning peak hour, which is 1 every 13 minutes or so. The other ones had 2, 3, 4 movements for the curb cuts, but there's more activity than that, and I will get into that. So we also observed the sidewalks. So there are cars that are parking on the sidewalks. There's forklift activity, which has already been referenced. That's associated with the Bangkok Market, which is again curb cut 4. So the forklifts are moving around this sidewalk in the area shown on figure 2. This is figure 2 from the report. What we wanted to do was highlight what we saw as the real safety hotspots here that are the areas of concern, and of course, we tailored our school safety plan to address these issues. So the east side of the street is definitely more active on the sidewalk. There are more cars parked on the sidewalk. There is a food cart or street vendor supply store here. It's called the Brooklyn Navy Yard Commissary, I believe. So it has 2 curb cuts, 9 and 10. There are cars that come in and they're towing like a street vendor truck, and they're coming in, they're getting supplies. They're carts, not trucks. But so there is a lot of activity here. There's on the east side of the block. Towards the south, curb cut 11 is has distribution. It's also next to an auto body shop. So there's some activity there. As is typical with auto body shops, they do park vehicles on the sidewalk. For the most part, these vehicles are stationary, but they are obstacles. So of course, they narrow the width of the sidewalk. When we met with DOT, we presented the same graphic. we aren't concerned about the east side of the block because of the way that the students are approaching. Most are coming either from the bus stops, if they're taking the bus, they'll be coming from the north along Flushing Avenue. But the ones that walk, as Amber said earlier, most are coming from the south and from the west. So we expect them to arrive at the southwest corner of the block. And so they'll already be on the west side of the street. Also, as part of the school safety plan, we have some measures that I will show you that will help enforce the students being on the west side of the block. On the west side of the block, though, we still do have issues. We have the forklift activity in the area of the Bangkok Market. They're moving pallets, skids, I think I heard the term earlier, mostly filled with rice bags. It's a food supply business. And so the forklifts are picking up the pallets and they're loading them onto trucks. And then to the north, we saw some vehicles on the sidewalk here. There's an auto body shop as well on the west side. And so sometimes vehicles were staged. Sometimes a vehicle waiting to be loaded from the Bangkok Market was being staged on the sidewalk. It's not a lot of activity because there's not a lot of vehicles. We counted the vehicles. But there's a lot of presence of vehicles at various times. So, a lot of the time they're stationary, but obviously they have to move on and off the sidewalk. So I'm going to move to the next sheet here, which...
Sorry, could you remind, what is number 1, 2, and 3 in gray?
Oh, I'm sorry, yeah, I could speak to those. 1 and 2 is a New York State inspection site. Oh, they do some auto body work there, and actually okay, yeah.
Are there spray booths in these locations? No? If you speak, you have to come to the mic.
I'll speak to the air quality and noise.
Okay.
So Kirkwood's 1 and 2 are both associated with the New York State inspection site. The hours are actually, this business opens at 8 a.m., and on the day I was out there, a car pulled up and they unlocked the gate. It's actually gated before then, and it opened at 8:02 that day. So they were spot on with the opening time, or maybe 2 minutes late, I guess. So actually during the bulk of the school arrival period, this is actually not active, but it would be active for the last 10 minutes from 8 a.m. to 8:10, which is the end of the school arrival period. Curb cut 3 is a warehouse, an existing warehouse that a floor is being added to, so it's under construction. The curb cut is not active right now. There is a fence, and we saw no activity that day. There was no construction going on that day. So that's the south side. These were curb cuts that had very little activity, 1 or 2 vehicles during the hour and a half. 3 had none, but the New York State Inspection Station, as you can see in the table in the report, it had very low activity. Curb cut 6 is under construction too. It's a future retail site, and this curb cut will not be utilized in the future. There's no loading dock or anything on that frontage. It'll be store frontage, from what I understand.
You said this survey was done on a Wednesday. Which
Yes.
part of the year?
We did it in July. We got engaged after the last DOT memo, which was in May. And we did our site visit in July. Now, July is not normally when you'd evaluate a school, but there's no school there today. And these businesses were all open and active.
Was it close to July 4th?
No, it was not a holiday week. It was July 17th was the Wednesday we did.
Okay, continue.
So what you see here in figure 3, which is figure 3 from the plan, and what we spoke to DOT about when we met with them about a week after we submitted the memo. This is our school safety plan, so let me explain what you're looking at. I'll start with the crossing guards. So at the north intersection, which is signalized, already has high visibility crosswalks. Same thing on the south side. We are recommending the school request school crossing guards at these 2 locations. You do that with the local NYPD precinct. There's no guarantee of receiving it, but these are the 2 logical locations where you would request that. I think that's pretty straightforward. What the S's are, this is essentially school staff and school greeters, so we're showing 4 at the site frontage, which is to accept the students in the morning and to release them in the evening. But we are adding one in the morning at the northeast northeast corner of the block, basically so that if any students come from the east, which should be a very low amount of students, but if they get to this corner, the staff person would force them to cross the street so that they end up walking south on the west side of the block. We don't want any students on the east side of the block, not just because of the issues we saw on the east side of the block, but it forces them to make a mid-block crossing at some point, so there's no reason. I don't think a student would naturally want to do that, but we're still engaging a staff person at this location in order to sort of channel them to the west side of the street. So then I'm going to get to what these circled Fs are. So this is additional staff people that are employed by the school. The F means they will have flagger training. So there's the, I'm going to get the acronym wrong, it's called ATSA, but it's the American...
Traffic Safety.
Yes.
Something Association.
But I will get it right. It's the American Traffic Safety Services Association, and that's an industry group that provides training for flaggers, and it's specifically for work zone training. So it's the same training that a flagger would go through for a work zone. We think it's important here because there are some aspects. It's not sort of typical curb cut activity with trucks backing in and out, where you may just want someone to make sure the curb cut's clear. There's activity happening on the sidewalks. There's forklifts, which are a little different. You know, they sort of, they maneuver a little differently than vehicles. And so we're recommending two, not necessarily these exact locations, but two staffed on the north side of the street or north side of the site where we see that activity happening. The idea here is that they can work together. So if you think about students arriving in the morning, they would be heading southbound on the block. You know, one flagger can be there to either hold up a vehicle or hold up the students, depending on what's happening and what movement happened first. The other flagger can be there to either help with that activity or actually escort the students through the area. So sometimes there may just be a stationary vehicle on the sidewalk where the flagger doesn't really need to do anything to stop a vehicle, but it'll be a restricted sidewalk width, so they would walk with the students past that obstacle. And of course, they would be stationed on the south side in the afternoon when students are leaving to provide that same service for students heading north off the site. And we are recommending the same thing on the south side, even though we didn't see a lot of activity here. Something I should mention with the forklift activity, the day we were out there, as you know, we were out there from 7 to 8:30 in the morning. The activity didn't start until 8:20, and from what we understand, that's pretty typical. The business doesn't seem to get started until around 8 a.m. And so they start to move pallets onto the sidewalk or stage them on the site, but they're not loading trucks until after around 8:20. This is what we saw that day, which is after the school arrival period. But we still want to make sure that that's covered in the morning in case it's different on different days of the week. And in the afternoon, there is some activity. It's not as heavy, but we think it's important to have them during both peaks. And then the trained flagger on the south position here is just meant to control the two curb cuts, and when the warehouse opens, there'd be a third. It's a small warehouse, it won't be very active. Again, this business opens at 8, so really there's no reason for the flagger to be out there any earlier than 8. School dismissal time ends at 8:10, so we said 8 to 8:15 would be appropriate for the morning, and then for the full afternoon dismissal period. So that sort of covers all the staffing positions we're showing here, and this is what we showed to DOT.
So I have a question. I can't find right now the photos that they sent for the morning, but but anyway, I found the photos from the afternoon, and I see on the west side of the street, which is the side that you think of as the safer side, right? A truck parked right on the sidewalk, so where there's not a lot of room to go, right? So morning ones, okay, so thank you. Yeah, so these are DOT site inspections. This one is from September 4th, and there was a site inspection on August 19th. The one I was looking at was 3 PM on the west side sidewalk, showing a truck parked on the sidewalk. So, and granted, and so that's right at the time when kids would be leaving, right? So.
Yeah, so
No, the children are dismissed between, and I don't mean to be contrary, but the children are dismissed between 3:45 and 4 o'clock.
Okay, so I don't know that their afternoon visit, so their afternoon visit at 4 continues to show the truck on the sidewalk, right, on the west side of the sidewalk.
Yeah, and
So, and then I'm just gonna, for the whole observation, so they have the west side of the sidewalk at 7:59 shows a curb being used, shows some cars parked on the street that arguably are not reducing the full size of the side of the street. But I think, your observations need to be coordinated with DOT's observations because they sent out their own inspector.
I didn't send this to them. I apologize for that,
Okay.
but we got it on Friday, and I'll make sure that you have it, but it's
Right.
just photos from their site visit.
Right, and so they continue to make these observational visits and then sending us, this is why we're concerned, because there was a representation earlier that it's not so bad during school arrival and departure times, but here's a photograph, Monday at 3 where there's everything on the sidewalk, right? So that's on the west side. But, the part of the problem I always have with these environmental observations is they're a snapshot. And it tends to be like one day, and then all the studies are based on that one day when you happen to be there and stuff was pretty good, right? Well, what about the days when it's a different day, when it's not pretty good? So I just want to make sure that you're dealing with a heavily obstructed sidewalk, and how are we going to deal with the kids getting around, fitting between the truck and the curb?
Yeah, so we did see that activity, and while the volumes themselves aren't that high, photos are stationary, so they are exactly that, snapshots in time. So, a lot of what we saw is, a vehicle, not a high volume, but a vehicle parked on the sidewalk, and it's there for 15 minutes, 30 minutes.
Well, this was an hour at least,
Sure.
based on their photographs,
But-
right? So,
But I guess my point is, it's not an incessant turnover of vehicles. It's a low volume, but they're there for a long time. And that's exactly why we didn't go with, hey, just put some school people out there and have them help out. We want trained people. This is more aggressive than we've ever proposed for any school safety plan, to have flagger trained people out there. And there's a reason for that. We did observe activity. Even though there wasn't much activity on the south side of the site, we are still recommending a trained flagger there. We set this school safety plan up specifically in response to the comments that DOT gave and what we observed ourselves, which is very similar. We can never say there was no activity, and even if something happened at 3 o'clock one day before dismissal period, there's we can't say that it won't happen at 3:30 the next day. So we have to be very conscious that if something, that was why we did an hour and a half of observations and didn't just focus on the half-hour period where school dismissal time or school arrival time is. We wanted to make sure that we got like a factor of safety on either side, so we could really observe things that could happen outside of the peak one day, but, there's no reason not to believe it wouldn't happen during the peak the other day. The exception to that would be the opening times of a business.
so how does the trained flagger system work? It's a teacher who has to take one of these classes?
It can be, so anyone can take the class.
Right.
It doesn't have to be a teacher. I do believe the school plans on employing these people.
Yeah, if I could. The bulk of the school workforce are obviously teachers. Those are most of whom you hire, but our teachers are not under a contract. They can be assigned duties, consistent with the needs of the school. So we tend to cross-train staff, but we also have administrative staff, aides, and other administrative personnel who can also be trained in that area and asked to participate, to just share the load and make sure that if somebody's on vacation, we don't lose our 3 trained staffers, right? So we anticipate that, we would have more people trained than we would use on any particular day, in part to share the workload and, cover the natural turnover that happens in staff.
So I guess the reason I'm asking this question is, will you then set up some kind of a protocol for the school where a minimum of, I don't know what, 5 or however many, 6 members of the staff, whatever they are, it doesn't matter whether they're teachers or administrators, go through regular flag training, whatever it is, every year they re-up their training program.
Correct, consistent with what the requirements are, right.
Or something like that. So I think in terms of what Richard will put together, there needs to be some kind of operational plan that's set up that you're going to have, that reflects what you're talking about here.
Correct.
Assuming that DOT is approving this structure, that commits to this protocol of training, of locating those people on the sidewalks in those approximate locations, and what it is they're actually doing, so that it's something that you're really committed to, and school administration knows that this is the deal going forward until this all turns into a residential district.
And but you're mentioning a point, Chair Muller, that this is a 30-year agreement with a 10-year extension on it, and none of us can, with great specificity, expect what's going to happen beyond the next period of time, myself included, and certainly your comment about residential being the future of everything does in some senses. And we heard the comments from the community board about the loss of manufacturing. We're certainly aware of the broader economic conditions, but it is what it is. We're playing the hand we've been dealt. And I just go back to the first point that Richard made about the basis for the finding. We began looking for a location for this school in 2014 before we knew that we even had the approval from New York State for the school. It has been a constant activity of mine personally. We've engaged outside resources, brokers, lawyers, you name it. And so I just can't emphasize more, if there were a better solution than this, none of us want to be consuming your time at 8 o'clock on a Tuesday night.
I actually do have a solution for you. Keep that site, but go buy or persuade the property owner to buy a residential building on the other side and have that be your access to your school.
So buy out the Bangkok market, I'm sorry?
No, not the Bangkok market. You see one of those little houses.
Oh, just go straight through the back.
Go through a house. Everybody's on a residential street, yay, kids
You'll
walk
co-sign
down
the
a
loan with me,
lovely
right?
residential street. What'd you say?
I said you'll co-sign the loan with me?
Can't approve on your own property.
No, but wait a minute, you're not doing it. Isn't there a developer involved in this?
Right,
He's
so
a
you can
property
go see-
owner.
okay.
So he's the one who needs the loan co-signed. Just go ask one of those people in the back.
I
They'll
understand real
sell.
estate's very easy in New York,
It would
so
be
thank you.
amazing.
Thank you for the
Because then you would have a
suggestion.
really safe access.
Now I'm going to ask you, since I've been asking the same question.
Say your name, please.
Scott Barone, owner, developer. Just out of curiosity, would we then have the front of the building facing the rear yard?
That doesn't matter. You're getting in, you're
You're
entering the build, do you know the City and Country School on West 11th Street? It's exactly that. There are it's a pile of residential buildings, all connected to each other, and in the center, there's a farm. They have not cows, they have pigs and chickens. So you enter through.
Maybe the chickens. I can't say I won't ask.
Would make life a lot easier on you, I'm telling you.
It's probably only, $6 or $7 million.
So if I could just add one thing, I know at the executive review session
Going great. No.
that the Avenue School came up as a potential precedent or comparable location. It does have some similarities. 25th Street, adjacent to the school, has an auto body shop across the street. It does have loading docks where trucks back in and they can't pull in all the way, so they block the sidewalk. There's a construction site there now. I don't know if it was there when the school was approved. But what that school does, I have a copy of the resolution, that school has 2 greeters at the door from what I'm reading in the resolution, And there's another provision in here that if students are going to the STEAM building, which I guess is outside the property, that they have to call ahead to a guard at the other property, and they come and they actually escort the students across any parked trucks on the sidewalk. So it's, so there are some similar situations that exist at schools, and what we're proposing here for a school that I think is a third the size of that school is a more robust plan. We have 4 greeters, we have 3 trained flaggers, and we have staff even pulled further away from the school. I mean, we don't have a situation like we have there on 10th Avenue, which is 6 lanes wide. And I know there are crossing guards at that 10th Avenue crossing, but we are proposing not just the same, but much more for a smaller school. And again, it's tailored to the conditions here, which is the best we can do, is, you go out, you observe what's happening, and you tailor a school safety plan that hits the spots and then some.
Okay, thank you. Other things that you wanted to add? You know what the crux of our problem is, so, right? So, other than air quality, you're right, you wanted to talk, I just wanted to make sure the automotive repair doesn't have any spray booths.
Right, so I know you guys also had comments during the executive review about air quality and then about noise. I just wanted to point out that we did do air quality modeling to address both any potential industrial facilities with DEP processing permits, and also consideration of those potentially that do not have processing permits. A full model was done and submitted to DEP. DEP did not have any additional comments on that analysis, and also what's called an atypical roadway analysis was conducted for the elevated BQE. Once again, it did not show any potential impact, and receptors were plotted all along the building, including any potential outdoor areas. DEP did also receive that, reviewed it, and did not have any additional comments.
So in terms of those outdoor play areas that are near the BQE, the EAS covered the noise and air quality factors for playing on the rooftops?
Correct, but I just want to point out, we considered the rooftop play area as a playground for the purposes of being more conservative. The actual intended use of the rooftop area would be more so for, let's say, like a garden space. The school would have plants up there. The science teacher would utilize that to stage plants. It's not so much that there's like play equipment or students up there running around and screaming, but regardless, we considered it, and DEP did not have any additional comments.
That's about you being a source of noise for area receptors, right? I'm
Correct.
talking about the reverse.
Yeah, so our infield noise measurements were very low, so lower than anything that would require otherwise any attenuation. So we considered...
Oh, I thought you have a 28 to 31 attenuation.
The reason for that being, so actually the highest recorded noise level was a 67, and that was on the street frontage. We also did readings in the rear yard, and those were even lower. The attenuation requirement, the 31, is actually a consideration of students playing outside and its own building facades requirement, so that there's not noisy conditions in the interior of the building. And then the 28 was because DEP had asked us to consider any additional noise that could be generated by the elevated BQE, and I had indicated the noise levels are so low, can we commit to just a 28 dB? That facade that faces the BQE as well would not have, correct me if I'm wrong, it does not have any windows.
But the setback play area that's on the... No, I don't mean the play area, on the roof, on the side, right? It's facing, isn't that on the BQE side? Yes.
It is, even if you consider the elevation and you add conservatively 5 dBA, let's say, which generally wouldn't happen, and a lot of times when you have elevated noise and buildings, sometimes what you see is that even at a lower level, the noise is very, very similar. So even if you added 5 dBA to that conservatively, and we will respond to this because DEP did ask us to consider it a little bit further than just saying 28, I don't see a situation where you would have any substantial noise levels above, let's say, 70 dBA that would result in
Okay,
any.
so you
The
did-
kids screaming themselves are going to be.
No, I know
louder
they're
than-
screaming themselves, but we also don't want them to go
No,
deaf because they're
understood.
screaming over the sound of the BQE
Right.
because the roof is much higher than the adjoining buildings, so you've got a clear line of sight to the BQE, right? Or something, I don't know how high
It's-
that is.
We will take that into consideration and demonstrate that the noise levels related to the elevated BQE. would not be
Okay, great, thank you. All right, are there any speakers on this? No speakers? Any other questions, comments from the board? Okay, so we need to give you time to do a lot of work. Hope one day you will hand us this really nice letter from DOT that says we love this project. So that would actually be the easiest for us.
Correct.
Right? So, keep
One
up
day,
the good
Chair.
work. So we want to give you enough time to actually get that letter.
Okay.
And of course, respond to our other comments, I mean, about, the fence and all these other things.
And just, specifically, just in discussion with regards to DOT, we're very happy with the fact that we were able to proactively come forward with a school safety plan to see that Thanks, Kurt. But yeah, no, we intend to obviously fully incorporate the board's comments, and from a professional standpoint, to be able to deliver the board a safety plan, which we know to 100% certainty satisfies the board as well as the requirements of 7319.
Right.
I also just did want to thank, on the record, Jella and Tony for spending time with us and DOT to work out some of this issue. I know they took time to attend these meetings, and I wanted to thank them.
And I think that in terms of the operational plan, because ultimately there will be an operational plan, it should be in the form of a restrictive declaration as opposed to just a condition on our approval.
Understood.
So that it all meld together with DOT's requirements and fire department and all of that. We'll have an operational plan that's recorded, so everyone in the board administration, and I'm assuming there's like a board of trustees or something like that, they're on notice that you have an obligation relative to this kind of safety issue.
Understood, Chair.
Okay, great. All right then, so,
Is this a next year?
Well, we actually had a pretty thorough conversation prior to the hearing and determined that to the extent that the board had availability in early December, that would give us, a nice hearty amount of time to respond to some of these issues.
Do you have a preference between the 10th and 17th?
The preference would be the 10th.
So that is December 10th with the submission on November 20th.
Thank you.
is that okay?
Chair, Commissioners, thanks for your time on this.
Thank you. Thank you very much for coming. Jay, you still awake?
Jay, we're going to take a half-hour break.
No.
I can't feel my legs.
My wife's already mad at me, my kids are asleep, let's do it.
Item number 3, 2019-86 BZ 2702 Avenue N, Brooklyn. Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, and to respond honestly to board member questions?
Yeah. Yeah, because it's backing up to all those nice townhouses. They didn't mention
Evening,
it.
Jay Goldstein for the applicant. We listened to yesterday's review session. We corrected the error in the statement of facts. I apologize for that. We submitted it to the board via submit and through hard copies. Additionally, the plans were amended because the proposed condition plans were amended to add the note regarding wall and joist retention. So that's why you're getting a copy of the amended proposed condition plans.
Were these submitted?
These were submitted. Everything was hard copy and e-submit. With regard to the question of the CO from 2013 and the
Sorry,
existing,
so what did you change on these?
we added the note regarding wall retention and joist retention.
Oh.
It wasn't there, and I didn't want to have to get
Thank you.
a second hearing based on that.
Yes.
The final question, I believe, was with regard to the C of O from 2013 and the existing conditions. I handed up to the board 2 BIS printouts. One is from 1993, which shows the conversion from a 2-family home to a 1-family home. So this was historically a 2-family home. That explains the size of the house. It was converted in 1993 with the C of O issued in 95 to a single-family home. In 1998, there was another Alt 1 filed That alt 1 was for minor partitions in the roof, in the attic space. That's handed up as well. That's what led to the CO in 2013. I don't have an explanation for the time gap between the initial application being filed and the CFO being issued.
It said they added 759 square feet.
So when discussing with the architect, with Mr. Garfinkel, he said that historically, they could have had an attic up there that was used for storage. It had 8-foot ceilings, but that they altered the configuration, and therefore they counted it as square footage now, and it wouldn't have been under the prior CFOs. But when looking at the Sanborn maps, which was, I believe this is the crux of the question, when looking at the Sanborn maps, we see the outline of the building. That outline of the building hasn't changed. So the existing condition plans, which show the 4 walls of the existing house and the retention, that's the way it's been since 1930, according to the Sanborns. So that has not changed, and that enlargement or the retention of the walls hasn't changed either.
But so, I'm a little confused.
We try...
What's super confusing is, unless it's true that whatever you fill in these things can be not the reality, when you fill out an application, it's kind of whatever. Right. But the application or the materials from that approval say total construction floor area, which may not be the floor area, but nonetheless, says 3,969 square feet in a district that only allows 3,800 square feet, and you're only proposing 3,600 square feet. So I'm so confused.
These records are not always 100% accurate. The DOB BIS printouts are not always. We did try and find the application files when we give you the record request. The application file was not found, so unfortunately I can't produce the actual records.
So you can't produce the drawings, is what you're saying?
Right, but we gave you the record request where DOB said that that's not found. However, again, we did produce the Sanborn maps, which show that there has not been a change to the exterior walls. So,
so it's playing around with the interiors.
Right. It's the 1998 application was strictly limited to the attic. So it's playing around with the partitions within the attic. I believe the question, or the crux of the question, if I'm not mistaken, is what are the existing walls and what is being retained? Those existing walls of the first and second floor have maintained static throughout the history of the building, as evidenced by the Sanborn maps.
Okay. Are we okay with this? I'm glancing at council. Are we okay with this?
This is requesting a waiver for open space ratio, and we haven't gotten an open space ratio study, just a lot coverage study.
Is this the one that's open?
No, this,
No,
the
no,
open
the other
space, the lot coverage open space was the next case.
That's where it was discussed, but this is seeking an open
This
space
is also
ratio.
seeking, this is seeking FAR and OSR.
Right.
No, but open space is, wait a minute, it says the existing is 1 and the allowable is 1.5 and the that's the minimum required, right? It's a
Right.
reduction in open space.
Yeah.
We are requesting an open space. We did provide other evidence through the BSA resolutions, which backed up our open space. I guess I was going to discuss it in the next case, but as to the discussion of the lot coverage study, the reason we use the lot coverage study, and I understand the board's now moving towards requesting an open space ratio study. The reason we requested the lot coverage is not to prove that our open space is there. The lot coverage is just to prove that the size of the house or the footprint of the house is within the neighborhood character. So I'm not using that as this is what my open space can be because that's what lot coverage is, because that's not apples to apples. However, we use the BSA resolutions, which we do submit a copy of the resolutions for the surrounding area to show that those homes have similar open space. I believe the open space ratio that we're requesting is similar to many of the other houses that the board sees throughout.
So I do want to say that it's true that the board has only been getting lot coverage studies, right? And we're in the process of creating, as I mentioned, a guideline, at which point we will be requiring that the study provided is related directly to the requested waiver.
but I don't want to sort of throw that into the mix now.
Right, no, we're
because
starting
we
to see it in
have
our notice of comments, and I'm happy to provide it. It, again, wasn't used as a mechanism of proving open space. It was used just to prove character of the neighborhood.
Right. But the problem is, when you tell us that the open space ratio is 150%, for example, but that then there's a lot coverage study, so we don't know if this fits within it or doesn't fit within it, right?
Right,
They're
so
not
generally what
saying-
I do in my cases is give you the proposed lot coverage, even though it's not a required item. Even though lot coverage is not governed in an R2, it's an open space calculation, not a lot coverage. I generally, in my statements, will give you what the proposed lot coverage is, and I'll analyze it based on that. So I don't mix the two, but that's how I've been using lot coverage, but I understand the board's request going forward.
No, but so what I'm trying to understand is you're asking for, it's really percentage of open space of
Right.
71%. It's not an open space ratio, but a percentage of open space.
73% is the open space.
73%. So when you look at the lot coverage, which is the inverse, right? We're in the sort of, are we in the 60% and 70% range,
Yeah.
right? And when we look at this. So that tells me that, and the existing site is actually a lot coverage of 33 and an open space of 67%, right? So therefore, is this right? So you're asking, I don't know, that's my question is, I'm actually not really sure what you're asking for. So your chart shows there's an open space ratio of 150%, right?
That's the requirement.
That's the requirement. And the existing is, what is the existing? 100%.
100%.
Which
So again,
confusing.
open space is.
So what is it that you're required versus asking? I don't know because you
We're
can't
asking
convert
for.
it.
Yeah.
I think the way I have been reading these maps all along is most of these lower densities have a very high open space ratio. So like in this case, it's 150%. So, but most of these are built to less than what the requirement is.
Yes.
And that's what the surrounding context is showing. And what you're basically showing is that it's already over, none of these spaces are meeting the open space requirement anyway, and they are providing only 60% of the open space requirement, and we are proposing 75.
Right, but what I can't tell
how
is.
I always
Yes, essentially.
Right,
read these
this is how
things.
I've been reading them too, but that's the problem is, if in this chart that you provided, it says open space proposed at .73, is that 73%?
Yeah, so that's pulled right
But-
off of the
right.
zoning analysis, the BSA zoning.
Okay, but so that's the thing is it calculated as the open space ratio? Or is it saying that you're asking for 73% open space because right now you have less? Right now your site has 67% open space.
So
So
we're-
how'd you get to have
It's
more
a
open space?
.74 open space ratio. 2,672.3 square feet of open space.
Right. Again, it's pulled straight, it's pulled from the BSA zoning form. So we filled it in based on the guidelines of that form.
Yeah, I understand,
It's-
but.
it's a
And it's not clear what
calculated-
you're asking for, you understand?
We're asking for the .73 open space as opposed to 1.50.
Okay. So you're asking for a .73%, no, 73%.
No, 73% versus 150%. 150% is
And the
required.
chart, and the existing condition, though, we don't know what the existing condition is because
They
it says
claim it as
33.
100%.
Yeah.
No, 33% is the lot coverage.
It's divided by floor area.
Right.
Correct. Open space ratio is not exactly always the inverse of lot coverage
I
because
know.
sometimes you can have.
That's the reason that we're talking about this, that you gave us something that says the existing condition is 33% lot coverage, which is 67% open space, which is a completely different number open space ratio. Right?
Right.
So what you should have done in this chart is at the very least said lot coverage X, open space Y, open space ratio Z, then we could look at it and say, okay, all those things mixed together, and at least when we're looking, we see that everything in the neighborhood is more or less that same thing.
Understand.
Right?
Going forward, it will tailor the charts.
We can
Okay.
use the resolutions for this.
Okay, okay. All right then. So there's no one to speak on it. So then I'd like to make, are we good? Motion to close?
Chair Promoter.
Aye.
Vice Chair Chanda.
Aye.
Commissioner Otley Brown.
Aye.
Commissioner Sheta.
Aye.
Commissioner Shabeta.
And a motion to grant.
Chair Promoter.
What's the condition?
Usual condition.
Oh, usual condition that no more than the amount of existing walls shown on the drawing shall be removed, or the special permit is void. The reason it's less critical in this case is because this is really just a simple addition at the rear of the building, so. Okay.
Chair Promoter.
Aye.
Vice Chair Chanda.
Aye.
Commissioner Otley Brown.
Aye.
Commissioner Sheta.
Aye.
Commissioner Shabeta.
Thank you very much.
No, stay there. Oh, you have to submit something? Oh, you don't have to sign. Just swear you in. Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond to board-member questions?
I do. Good evening again, Jay Goldstein for the applicant. We've handed up amended proposed condition plans. We
Not
amended.
signed and sealed. Oh, yes,
Yes, they are.
sorry.
I hope they're. Made that mistake once. I think you only make it once. They're
Yeah,
signed and
you're-
sealed, dated today. We amended the plans at sheets A7 through A11 and A15 and A16 to show, or to note that the incursion into the sky exposure plane is the dormers, and that it satisfies, and that it meets the requirements for dormers under the zoning resolution. And I guess the lot coverage discussion we had from before pertains to this case as well. Going forward, we'll make the proper adjustments.
And the zoning chart on the, or that's on.
That was the other case.
No. It's the
That was the
zoning
lot
chart
coverage
on the statement of facts, right? Where your front yard will increase it from 1 foot to 5 feet. Just a note to council that the zoning chart, I guess
Right,
it's in
the
the
zoning
statement of
chart
facts.
shows
Or the
it as-
BSA zoning chart.
Right, the BSA zoning chart shows that both the front yards are going to be 15 feet. Actually, one of them is going to increase.
Right, it's 15 feet at the new portion of the building. We're actually reducing along East 27th Street, we're actually reducing or increasing the front yard. It has like a 1'3" front yard.
Oh, yeah, it
We're
has
getting
this
a-
little extension in
We're
front.
demolishing that and keeping a,
It's actually going from to 5
to
foot
5
to
feet
10.
10,
Yeah, okay.
Yeah, right,
So we're-
5 foot 10, okay.
creating a better condition, I think.
All right, so same story, right? So then I'd like to make a motion to close.
Chair Promoter. Vice Chair Chanda.
Aye.
Commissioner Otley Brown.
Aye.
Commissioner Sheta.
Aye.
Commissioner Shabeta.
And I note that there is a note on the drawings, as there was on the prior, that says floor joists and exterior walls to remain as shown on the or the special permit is void, which is an abbreviation of our usual note. It's a little longer than that, but anyway. More than 50% of the floor joists and 50% of the exterior walls must remain, or the special permit's void. Okay. So on that, a motion to grant.
Chair Promoter.
Aye.
Vice Chair Chanda.
Aye.
Commissioner Otley Brown.
Aye.
Commissioner Sheta.
Aye.
Commissioner Shabeta.
And I
Thank you
just
very
want to
much.
say that I very much appreciate so much that you make complete submissions like this and leave very little for guesswork or argument. It's a pleasure.
I appreciate it. Thank you very much.
Thank
This
you.
concludes the public review public hearing for September 10th, 2019.